Good morning, and thank you for joining us for this special breaking coverage of the Jennifer Crumbley trial. I'm Terrence Friday.
And I'm Meredith Bruckner. Day one was a mixed bag of emotions and outbursts throughout the courtroom. Now, today marks day two of the trial for Jennifer Crumbley, who is the mother of the Oxford school shooter who was sentenced to life for killing 4 students.
Today, testimony is expected to continue in the trial, and the juror expert Richard Gabriel that we spoke with says that the focus will be on impacting the jurors. As we wait for court to begin today, we do want to get you caught up on the trial so far.
And here to give expert legal analysis are Terry Johnson and Richard Convertino. Welcome so much for being here. Richard, you were with us yesterday. So Terry, I'll turn to you first this morning. What was your take on day one of the trial?
Strange, very strange. I saw some things that really give me pause, for lack of a better word. It seems as though there was no theme on the defense side. It's like, where are you going? What are you trying to do? You know, when you walk out of there, you know, again, the defense attorney has 3 times to speak to the jury, okay? The first time is during opening arguments. The first time is during jury selection, the second time is opening arguments, and then closing arguments. You've got to put something in their head to focus on, and I don't know that that was necessarily done yesterday. So it's a little concerning from that standpoint.
Yeah, it seems like a lot of people are focusing on the wrong things, one of those being a lot of those outbursts that we were hearing.
Yeah. Recap what we saw yesterday that you felt was a little unconventional, unusual for a case this big.
Well, I think that the thing I took away yesterday was that the prosecution is well prepared. They've had years to prepare, and they put together a case in a formulaic manner that's clear and concise. They stated in opening statements what their theory of the case was and what they're going to prove, and so far they've done it. I think the defense is, to be euphemistic, struggling. There's no theme that's coming out. There's no pattern. Her cross-examination, the defense attorney's cross-examination, I think is feckless and wholly ineffective. And I think all that she has been able to accomplish yesterday, especially in her cross-examination of the special agent, which was the first witness she cross-examined, was to reinforce the prosecution's case, which is which was a disaster for the defense.
Yeah, and I agree with you on that. I know it's not little backgrounds. You know, I'm a firearms trainer, you know, CPL instructor, firearms attorney, the whole 9 yards. And some of the chosen words used by the defense attorney yesterday shocked me. I mean, you hear the word weapon, that's an offensive term, it gives negative connotations. You know, as a defense attorney, you should use firearm or gun or something like that. And the other part that truly threw me was she made a statement in there to the special agent, which was, well, you have to explain this to me, I really don't know the difference. You are supposed to carry that expert and make that expert your expert. And as Rick mentioned, it just didn't happen yet.
A lot of discussion in the jury selection process about parental responsibility here. And it has to do with what are the rules that you think. And I think that's where each side is going to be looking to a certain type of juror, a certain personality. There are some parents who are like, no, I make the rules in this case in my house, and I make sure that my kids follow them, and I'm tracking my son. Another issue has to do with what was her knowledge of her son's mental state, and whether there was foreseeability in terms of his ability to actually do this kind of act. So the parental responsibility is how well does a juror know their own kids? How well do they apply rules to their kids? And how much in control of their child's behavior, and how well do they monitor their child's behavior? So a lot of that is going to be the personal application of these jurors themselves.
That was juror expert Richard Gabriel talking about the juror impact as we continue with day 2 now of this testimony. You were just talking about the defense and their approach. Something else that stuck out was her talking about them only having a sliver of evidence, even though we know that they have 400 exhibits at least that will be going forth. As we continue, what do you think it would take for her to try to salvage any of this approach?
Well, I think the missed opportunity here should have been in the opening, and it should have been framed as this is not about the killing, this is not about the gun. This is about, did my client have knowledge of what was going on? And if she doesn't show that Jennifer Crumbley didn't have knowledge, and at every turn I would say, do you know that Ms. Crumbley knew this? Was this foreseeable? And that needs to be the theme, not how many pieces of evidence. You can have 1,000,000 pieces of evidence, but if I don't know what's going on, you can't connect me on the charge of involuntary manslaughter.
And from the get-go, the opening statements of the prosecution, this was the purpose, is to show this digital footprint, to show that the parents knew.
Right. A focus is to build a bridge between the day of the incident at Oxford High School and build the bridge of knowledge and responsibility to both of the parents, and in particular, in this case, Jennifer Crumbley. And that's what the prosecution has been doing. You notice there is a very important part of the questioning that's called redirect. It goes direct examination by the prosecution because they have the burden of proof, cross-examination, then the prosecution has the ability to go back on what's called redirect examination to kind of clean up or get clarity in some of the questions and answers.
And we'll have to cut you there. We
Okay.
are going on a quick break, but when we return, we're here live coverage inside the courtroom. Stay tuned.
Good morning, and thank you for joining us for this special breaking coverage of the Jennifer Crumbley trial. I'm Terrence Friday.
And I'm Meredith Bruckner. Day one was a mixed bag of emotions and outbursts throughout the courtroom. Now, today marks day two of the trial for Jennifer Crumbley, who is the mother of the Oxford school shooter, who was sentenced to life for killing 4 students.
Today, testimony is expected to continue in the trial, and we want to take you inside the courtroom where day two of the Crumbley trial will be happening. Recapping everything that happened yesterday, though, we are expecting quite a bit of activity again.
Yes, and with us are Richard Convertino and Terry Johnson. Thank you so much for being here this morning. So what can we expect today, Terry?
Well, I think you're going to see more of the same at this point. The prosecution is going to put forth their witnesses, and they're going to start to establish a pattern that Ms. Crumbley knew what was going on. And you're going to see the defense attorney hopefully step up and show that she had no knowledge. There was no pattern. So that's what we're going to see.
Well, we understand things are certainly becoming more active in the courtroom. Let's have a live look.
Color. What question could you ask him that would not implicate his Fifth Amendment rights?
Okay, I'm sorry. This has to be a clear record.
It's not going to be a clear record now because the jury is sitting there.
I asked to have the shooter brought in after the issue of privilege was brought up by the shooter's attorneys and by the attorneys for the doctors. I was not planning to call the shooter until this privilege issue came up this week.
No, the privilege issue came up in November.
On the actual records,
yes.
Not on the testimony. The testimony is all impeachment.
What testimony?
The testimony that I anticipate these doctors will give is straight impeachment of things the shooter said.
I need to correct the record. It is not. And Dr. Anneker informed me that she had a conversation with defense counsel last week when counsel tried to subpoena her, and Dr. Anneker explained that to counsel that it is not inconsistent. She actually said that to counsel.
I don't know if it's
true.
inconsistent or not. I have not read the records. I have not read these records. But the privilege was asserted at a minimum last November by the shooter's lawyer, and try as I might, I cannot find an exception to that privilege. That privilege is absolute except in limited purposes. The privilege belongs to the shooter, and it's been asserted several times. I have personally, and my staff attorney, been looking for something that would support your position. The closest I've gotten is Stanaway, and that is a victim witness, and there was a threshold offer of proof by the defense regarding what should be searched for in an in-camera review. I'm obviously not in a position to do an in-camera review of those records right now, nor have I been provided with some glaring thing that the shooter said. I lied when I wrote X in my journal, whatever it is. So,
Your Honor, I am going to put together an offer of proof of exactly what these doctors would testify to. I understand the court has not ruled yet about these doctors, aside from the fact that the privilege is absolute. I understand that. I cannot file that because of the protective order.
No, you can't file it.
So I'm going to put it together. I'm going to get it to everyone, and obviously we'll go from there. But I also want to state the privilege. Obviously, we all know the Fifth Amendment. This shooter has pled guilty. He's been sentenced. It's our position that at this point, he does not have the same Fifth Amendment rights as, for example, James Crumbley.
It's just not the
whose
law.
trial is not.
Okay, support it, because every lawyer in this room knows that that sentence is going to be appealed until well after I retire.
Well, and the other thing is the evidence I intend to put in front of this jury, quite frankly, is evidence that the entire world knows about because it came out at the Miller hearing.
That's not the test for the law or the evidence.
You're telling me why it's relevant and why it would be fair to you to admit it. I understand why you want it. I understand why you want it. I haven't seen it. I understand why you want it. But I have to follow the rules. Believe me, I have been researching this issue.
Well, and I'm sorry, that's why I'm pointing to the rule about when the privilege holder won't waive it and when the privilege holder won't testify and can't testify. I'm going to the third option, which is that evidence just can't be used. If I have no
I'm sorry,
way...
this is non-testimonial evidence that's being admitted today, not testimony. Non-testimonial evidence, I'm not finished. Not testimonial evidence, and that's the basis of this court's ruling. There's no Crawford issue. There's no confrontation issue. It's non-testimonial. If it were, we'd have an issue. We don't.
And I believe the Crawford issue is preserved, and this is testimonial because this is information that is tantamount to testimony in this case.
It's not the law.
The rules of evidence, 803.3 specifically, I'm sorry, 803.1, talk about present sense impression. I did a thorough evaluation of some of those statements at that time, which was, what, a year and a half ago? What month was it? Maybe I'm blocking it out. I evaluated all of those statements, and I made a ruling based on a hearsay exception where the declarant whether the declarant is available or not is immaterial. So whether he testifies or not is immaterial, which says to me it's separate. Those statements are separate from any testimony of the person who made those present sense impression statements, whether they testify or not. That's what 803 says. The theory behind it is that it's done in a contemporaneous way. So I made those rulings a year and a half ago, and I invited anyone to appeal anything that you wanted to appeal. There was a motion to quash. There was a lot of things appealed, and that could have been appealed as well. So it's not that people that either side hasn't had the opportunity. So I will read any case you provide. I have been researching whether or not those records could be admitted, and I have found nothing that would direct me to allow doctors to testify about privileged records that have not been waived by the person who holds the privilege, and that person is the shooter. And that privilege has been asserted repeatedly by Ms. Lofton and by Sato. I will read any case you give me, and I've been frankly trying to help you. I can't find a case that allows for that. So,
Your Honor, the only cases I can find, and I think it's because this is a unique issue, and there has probably never been a case like this, with parents who are also charged with murder-type crimes, and the shooter is charged with a murder crime that he pled to. So this is a very unique situation. Unfortunately, it's a case of first impression. I know the court knows this. And so when I look at the cases, I agree with the court that most of the cases deal with a complaining witness or an alleged victim and their rights. But the court rule says privilege holder. It does not limit it to complainant. And I agree with this court. There's not case law. And that's why I'm asking this court to make a decision to not allow these statements pursuant to the court rule, because I have no way to defend them. But if the court's ruled, the court's ruled.
okay, well, I didn't plan on ruling on that this morning. I mean,
I will still file an offer of proof, and I will still file a list of what the evidence would have shown. And I understand the court will make a decision about the doctors testifying. That's the best I can do.
All right, you're watching the trial of Jennifer Crumbley, the mother of the Oxford shooter.
We have to take a quick break. We'll be right back.
The court rule says is that testimonial evidence, what we just said. There's nothing more. This isn't a case of first impression. This is the law. It's been the law for a very long time.
Well, the problem is I want the testimony, and I'm being told I can't get the testimony.
That is directed at a person who puts, like someone who is in a car accident and they're suing an insurance company and they're putting an issue. They say that I've been depressed, I can't leave my house since this accident, whatever it is. If they testify to that and then they object to having their mental health records admitted, it's problematic because that person, the witness, put their mental health issue in that case at issue. They put their mental health at issue. And so you can't use your shield as a sword. That's what that is about.
Correct.
So if you are a witness who's alleging damage to your mental health, yet you will not waive the privilege with regard to your psychological records from mental health treaters, then that testimony is stricken. There's a reason for that. You can't use your shield as a sword. That is the reason for that. That is wholly separate from this issue. With regard to asking the shooter to testify, it's not that I'm saying you can't call him as a witness, but two of his attorneys have said in no uncertain terms that he's taking the fifth. Both sides, not just the prosecutor. Again, I think that's a baloney. I don't know. All of this stuff is sitting in my desk. You are not allowed to put someone on the stand knowing that they're going to take the fifth. And I cannot think of a single question beyond what is your name that would not implicate his Fifth Amendment rights. So I don't know what you could even ask him that he would answer or that his lawyers would let him answer. So it's not. I am going to prohibit you from putting any witness on the stand who takes the fifth in front of the jury. That is strictly prohibited.
Welcome back to CBS News Detroit and our special coverage of the Jennifer Crumbley trial.
I want to take you back into the courtroom right now where testimony continues.
I do. And if you knew how much time I have spent and my staff attorney have spent on this, it's mind-boggling. But at the moment, I have nothing that lets me say I have to rule in a way that is the most fair for the defendant, but goes against the law as I know it. I don't have something that lets me do that. If someone has something that lets me do that, I would be happy to hear about it. Okay, I'm bringing the jury in. Okay.
Thank you, Judge.
All right for the jury?
Good morning. You may be seated. Thank you for being timely.
Good morning, progress.
Who is the next witness?
Ed Woodgrowski.
Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth so help you God?
Yes, ma'am.
All right, could you take your seat there? Could you have a seat? And then could you state your name for the record and spell your first and last name?
Edward Wogrowski, E-D-W-A-R-D, last name W-A-G, R-O-W-S-K-I.
Go ahead.
Thank you. Good morning. And how long have you been with the Secret Service?
Just a couple weeks.
Now, prior to this current job, where did you work?
The Oakland County Sheriff's Office,
How long were you with the Sheriff's Office?
28 years.
Okay, in those 28 years, where did you work?
I started out in dispatch and went to corrections after that, the road patrol, and then eventually to computer crimes.
Okay. And tell me, when you say computer crimes, what does that mean?
Do anything that has to do with the computer, cell phones, forensic examinations of computers, DVR equipment, call detail records.
Okay. And how long were you in computer crimes?
10 years.
In your time in computer crimes, did you receive specialized training with forensic analysis of electronic devices?
Yes, sir.
May I approach the witness?
Sure.
This is Exhibit 422. Sir, just confirm for us that that's your CV.
Ms. Smith, you object to submission?
Oh, no, I'm sorry. No objection is admission.
Yes,
Also, no
correct.
objection to disqualifications.
CV, so you would stipulate his qualifications, you would stipulate he's an expert in forensic examination of computers?
Yes, Judge.
Forensic.
Cellular cell phone forensics, historical cell site analysis.
Yes, the defense stipulates to both of those, the CV and that he's qualified as an expert.
Historic, say it again, please.
Cell site analysis and cell phone forensics.
Historic cell site and cell phone. Okay. You may consider him as an expert in the area of historic cell site analysis analysis and cell phone analysis. Is that right? Yeah, okay.
Yes, sir. Thank you. Well, sir, now we don't have to go through the entire CV, but let's just talk a little bit about your training as it pertains to cell phone downloads and forensic analysis.
Okay.
Okay, so is it fair to say that this field is evolving?
Always.
So you said you spent 10 years there?
Yes, sir.
What sort of things did you do in computer crimes 10 years ago?
Well, things were a lot different. It was actually a lot easier to do forensics back then because with updates of how the phones operate, how Apple or whoever Android operating system, they just make it more difficult, and now we have to figure that out.
What do you mean more difficult?
With encryption, file-based encryption on a hard drive, so data that you hold personal can't just be taken off the phone and given out to whoever.
So talk to me about what a detective in computer crimes, or first of all, what your current role as a Secret Service, what exactly do you do there?
I'm a network intrusion forensic analyst.
Okay, so would that be the same sort of duties you had in computer crimes?
Yeah, the same thing that I did, cell phone analysis, computers, just with more network intrusion, like someone hacks into a bank or something like that.
Okay, so walk me through, what is a typical day for an expert in the area of cell phone forensics?
Typical day is you come into work, you just see what work needs to be done. The case, depending on the case, how important it might be to get that, to either examine those phones or contact the detective that brought that stuff in to see exactly what they're looking for on those devices.
So you'd be somebody to receive the cell phone, seize an investigation, and then conduct an investigation into that device?
Correct.
Okay, so what does that entail?
That entails, depending on the device, we have tools that are able to obtain the data from the phones, and then we then take that data because it could be voluminous, thousands and thousands, hundreds of thousands of pages, and then put it into an easy readable format called Celebrate is the company, and they make a forensic analyzer reader, which makes it easy to look at.
So that reader, that's one of the tools, forensic tools you mentioned?
That's not the tool that we use. That's what we give out to investigators. The tool that we use is a little bit more than that reader tool, with the functionality that it gives us. But the reader tool makes it easier for the average investigator to look at.
Okay, so help me understand this. So a phone is taken as part of the evidence, a search warrant is obtained for that phone, and then you're given the phone itself. Is that right?
Correct.
Okay, so tell the jury, please, what do you do with the phone? Walk us through that step by step.
Depending on the phone, again, if it's passcode protected, or if it's not passcode protected, there's different steps that we have to do. We hook it up to the tool. In this case, it would have been Celebrate, again, as a company, and the tool is their Celebrate Premium platform, and that's able to obtain what's called a full file system, which is everything on the phone, everything you can get off of it, as long as there's not encryption on it.
What is encryption?
Encryption is, how do I describe it? I don't make it easy. It just jumbles up the information. It makes the word "the" look like absolutely nothing that you could understand.
Okay. So, as an investigator in the area of digital information, you don't confine yourself just to a cell phone. Would that be right?
Oh, that's correct.
Okay. So, what other sources of information would you draw upon as an investigator?
Someone's social media accounts, Facebook Messenger, Snapchat, all that stuff, anything you would download to your phone. And obviously the phones are cell phones, so you'd want to get the cell phone records from the carrier.
Okay. Now, talk to us about how you obtain that information from other sources other than just the device itself.
Via search warrant.
Okay. And before a search warrant is sent, do you send something else?
Yeah, there's something called a preservation letter. What that does is in order for us to get a search warrant, you have to have probable cause or reason a judge to believe that the information you're looking for is going to be there. So while we're trying to gather that probable cause, we tell AT&T, don't destroy these records under any circumstances for 90 days until you hear back from us.
Okay. Now, as an investigator, why is it important to not confine yourself to just the device itself? When I say device, I'm talking about a cell phone. So why would you not confine yourself just to that cell phone?
Because sometimes the stuff isn't always stored on the phone. It could be stored on a server, and the computer system, like, again, Facebook, for example, or Instagram, that information isn't always stored directly on your device. It's stored on a server that your phone just accesses.
Okay. So is it your goal then as an investigator in computer forensics to gather as much information as possible?
Always.
And then when you gather that information, what do you do with it?
Start talking to the OIC, as it's called, the officer in charge of the case. What are you guys looking for? What do you need? How can we help you, basically?
Okay. Now, is every cell phone the same?
You're watching the trial of Jennifer Crumbley, the mother of the Oxford shooter.
We have to take a quick break, but you can watch the trial uninterrupted on our stream. We'll be right back after this, right here on CBS News Detroit. It continues.
The phone to keep the cost down, to not have as many developers and all that stuff. You just keep the cost down by not having that as part of your platform.
So if the user of a phone is spending more money for the device from a certain manufacturer, they can expect to have a higher level of encryption. Would that be right?
Yeah, and features, yes.
And features, okay.
Yes.
So then, is it possible to recover deleted content from a phone?
Potentially.
And why is it potential?
Potentially because, again, you go back to that file-based encryption that I've said over and over. Is if it's, once you delete something on your phone, it's not necessarily always deleted on the phone, it's just encrypted. You telling it to delete it just erases the path to get to that encrypted data. And so we can't find it.
So it has nothing to do with the forensic tools at your disposal, it's regarding the manufacturer of the device itself?
That's correct.
Okay. Now, you talked about how some information can be stored on a server as opposed to a device. If something is deleted from a phone by the user, are you still able to recover it from the server?
Potentially, yes.
Okay, and tell me in what circumstances.
For this situation in particular, I did some research. Facebook Messenger, for example, two people are having a conversation. I delete it on my phone. All I do is I tell my phone I don't want to see it anymore. Where Facebook, as the other person wants to see that conversation, won't delete it so that person can still read the conversation on their end of the phone.
Okay, so let's say you and I have a Facebook Messenger chat with each other, and I delete that from my phone. If the investigator wanted to recover that information, it wouldn't be on my phone. Is that correct?
Possibly, yes, correct.
Okay, but then you could send a search warrant to Facebook, to the server, and obtain that information.
Correct.
Okay. Now, what if you and I both deleted it from our phones? What would happen then?
According to what I looked up and looked into Facebook's website, that it won't be available.
Okay, so then it's deleted completely if both users of the chat delete it.
Correct.
Okay. Now, what about deleted text messages on the device itself? Tell me how that works.
Yeah, it just comes back to
Welcome back to CBS News Detroit and our special coverage of the Jennifer Crumbley trial.
We're going to take you back inside the courtroom. That testimony continues. Let's listen in.
all that data is stored in the phone, and I tell it to delete that app, then it could possibly be totally gone.
So if you were to review, let's say, screenshots from one person's phone and then a forensic analysis of somebody else's phone, if the screenshots didn't match up with the forensic analysis, what would that tell you?
That was possibly deleted.
Okay. Now, during the course of this investigation, People versus Jennifer Crumbley, did you uncover evidence of deleted content from Jennifer Crumbley's phone?
That's correct, yes.
Okay, and we're going to get into that later. But before we do, could you tell us just in general terms, what does a cell phone do that maybe a layperson wouldn't know?
It's continually working in the background, talking to a cell tower. One, so your carrier knows where you're at, so it can give you the phone the phone call if someone's trying to get a hold of you, or the text message. Or it is updating your email account without you telling it to do it, because the application is just constantly looking for the signal. So you open it, and there's most updated information.
So that's when the phone's powered on, right?
Correct.
Okay, so when the phone's powered on, it's constantly doing things. Would that be right?
Yes, sir.
Okay. And what about when the phone's powered off?
It's doing nothing. It's just off.
Okay, so it can't update?
Correct.
Okay, so when a phone's powered on, is it possible to obtain the location of that device?
Yes.
How so?
Because there's a feature, whether you have an Apple product or an Android product, each one of them has what they call location services, and it's actually to benefit the user of the phone. So, because that information is sold to McDonald's or whatever, and next, you're near McDonald's and your device says, "Hey, I'm near McDonald's." Oh, cool! I'll send you an ad for McDonald's or a coupon for McDonald's. So that's
okay.
Yeah.
So you have, as an investigator, a fair amount of reliability in that because of the capability for somebody's phone to sell the device basically to an advertiser.
Correct, yes.
Okay. And are you able to obtain someone's location from their phone based upon other data as well?
That's correct, yes.
And how so?
Through the carrier themselves, AT&T or T-Mobile, whoever you may have. Again, your cell phone's constantly talking to a cell tower. Then they try to triangulate your position on where you are based on the signal back and forth from each tower.
Okay. Now, on an Android phone, for example, it automatically comes with a Gmail account. Is that right?
No, you have to make a Gmail account.
Okay, you make a Gmail account.
Yes.
Okay. So if someone were to have a Gmail account, would that also help an investigator determine the location of that device?
Absolutely, yes.
Why is that?
Because again, that information at location services is stored within that particular Gmail account that someone might have. So if we would search warrant Google for your particular email, the Gmail, they would have, if that's turned on, the location services would be given to us.
Okay. So I want to talk about the evidence in this particular case. There were a total of 7 phones recovered, and I'll go step by step with you. So I'm going to review with you, I'll show you a slide here, of some of the sources of available information. So EC, that is the school shooter, his initials.
Yes, sir.
Now, is it true that you reviewed a T-Mobile phone, last 4 digits, the phone number 1551?
That's correct.
A Facebook account?
Correct.
And an Instagram account?
Correct.
And you were able to determine, and we heard testimony yesterday, that both James and Jennifer Crumbley followed that particular account?
That's correct, they did.
Okay. So you were able to review not only the shooter's phone, but also social media, Facebook and Instagram for that individual?
Correct.
Okay. Now regarding Jennifer Crumbley's electronic information, you reviewed information from 3 phones.
Correct.
Okay, so we have one listed as an original phone. Are you aware that her original phone was seized on November the 30th in the evening?
Yes, sir.
Okay. And then you're aware that she purchased what we refer to as a burner phone or a track phone that night?
Correct.
Okay. And then that's the number, the 947 phone number?
Correct, that's right.
Okay.
Yep.
And you're also aware that subsequent to turning over her original phone and prior to arrest, she obtained another phone?
Correct.
And that was with her same original phone number?
Correct.
Okay,
Yes.
so you reviewed that device as well?
Exactly, yes, sir.
So just so we're clear, when I say you review the device, we're talking about forensically analyzing the data on that cell phone?
Correct, yeah, exactly.
Okay. You were also able to obtain information from Facebook, from 2 different Facebook accounts?
Correct.
Okay. And information from a search warrant served on Google regarding her Gmail account?
Correct.
Okay. And that Gmail account and that Yahoo account, does that include location data?
The Gmail account, yes, yes, it does.
Gmail account did?
Yes.
Okay. Now regarding James Crumbley, again, 3 cell phones. Is that right?
Correct.
Okay. His Instagram account?
Correct.
His Yahoo account?
Correct.
His Gmail account?
Correct.
An email through Charter Communications?
Correct, yes.
And then a search warrant was served on DoorDash to obtain his DoorDash driving location history?
Correct.
Okay. Now, your goal with obtaining all of this information as an investigator into digital evidence is to obtain the who, the what, the where, the why, and turn that information over to the officer in charge and ultimately the prosecutors in the court. Would that be right?
Correct. Everything we can get.
Okay. Okay. So I'm going to show you People's Exhibit 76. I don't believe we have an objection to any of the evidence coming through Officer or Investigator Wilgrafsky, do we?
No, we have several objections. And I believe many of them have been placed on the record already, but let me open up 76.
This is 76?
We have no objection to 76.
Okay, 76.
And I'm sorry, with this witness, we're going to have to go exhibit by exhibit.
That's all right. 76 is omitted.
Okay. So what are we looking at?
That is what it would look like, a printout from the Celebrate Reader or Celebrate Physical Analyzer program of someone's information that was obtained from their phone. And it's Jennifer Crumbley's followed her son's Instagram account.
Okay, so just to give us an idea of what we're looking at here, this is a snippet from a PDF export from that forensic tool they use.
Correct, yes.
Okay, so tell me how that digital information comes to you and how it ends up looking like this.
The reports, the information that we have, you can put it in any number of formats. You can put it in a PDF like this is, in a Word document or Excel spreadsheet. And you just tell the software what you want it to show you and export the software, and this is what it produces.
Okay. So moving on to Exhibit 77, this is a portion of James and Jennifer's Facebook messages. And Judge, I did want to place on the record that we do have an additional exhibit, 423, that'll be introduced through this officer too. That's the entire Facebook message thread between James and Jennifer Crumbley. Counsel placed an objection on the record yesterday regarding that, so we're introducing the entire 2,000-page thread.
And Your Honor, I until I look at that 2,000-page thread, I object to it. My objection, I need to look through it. I might not object to it.
Okay.
My objection yesterday was about the exhibits the prosecution was showing, those individual exhibits. They deleted parts of those.
Hold on. Nobody deleted anything. Okay. This is
Well,
demonstrative aid. The exhibits are the same, and
Okay.
we're giving the whole thing.
Okay.
Okay, and
They're admitting an exhibit and showing the jury portions of it. They're permitted to do that, right?
right. So, but I'm just saying, my question yesterday about the parts missing did not mean I'm asking for all thousands and thousands of texts to be introduced.
Okay.
So I'm going to take a look at them and see if we do have an objection, and we may not.
Okay.
The other...
You've had them for a while.
What's that?
You've had.
You're watching day 2 of the trial of Jennifer Crumbley, the mother of the Oxford shooter.
We have to take a break, but we'll be right back. It continues here on CBS News Detroit.
Portions of that exhibit that they think are relevant for purposes of this witness's testimony. In the event that you want the entire exhibit in, the prosecution is saying we don't object to that.
Right.
So it's up to you. You can let us know.
Right, and I believe the only problem is this court's made other rulings where things are discussed in those texts that are not a part of this.
Okay.
So when I reviewed their exhibits, as a whole. They're allowed to show different pieces of the exhibits, but that didn't mean I was suggesting we just admit the whole thing, because you've made other rulings about.
Okay.
Okay.
They don't want the jury to think that they're not willing to provide the boxes and boxes of evidence. I'm sure that there are in both of these cases, but I'll leave it to you. They want to ask this witness questions about specific portions of those 2,000 pages. They don't want to show the jury 2,000 pages and then ask questions about it. So.
I completely understand that. I get that. The other thing I would ask the court is, until the exhibit is admitted, I would ask that the exhibits are not being published to the jury.
Yeah.
Yes.
That's
correct.
fine. Yeah,
Correct.
that's fine.
Okay. Well,
Correct. Agreed.
Okay. Thank you.
Yeah.
So I'm sorry. We're on exhibit 78.
This is 78.
Okay. And
Okay.
let me just find my list really quick.
Okay, so 75 is admitted.
In 78, we have no objection to.
Okay, yeah. Tell us what the
76 was admitted as well.
Yeah, just try to put tell us what the exhibit is prior to, so that she knows which one.
I have that 76 was admitted, 78 was admitted. The prosecution indicated they are skipping what was
77.
proposed exhibit 77.
Correct.
Okay, so
Although we have no objection to 77.
okay, so you don't object to 76 or 78, so they're admitted. Okay. All right, go ahead.
Thank you, Judge. Okay. Do you remember my question?
No, sir, I apologize.
I don't either.
Okay.
Welcome back to CBS News Detroit and our special coverage of the Jennifer Crumbley trial.
We're going to listen in the courtroom as testimony continues.
You talked for a little bit before about deleted content, specifically a Facebook Messenger thread between two people.
Correct.
Okay. Now, in the course of your investigation, you came to learn that Jennifer Crumbley had a Facebook account.
That's correct.
And that James Crumbley also had one.
That's correct.
Okay. Did you uncover this particular chat thread on Jennifer Crumbley's phone?
No.
Okay. How did you obtain it?
Through a search warrant to James Crumbley's account.
Okay. So if there is an actual chat history, in this case a 2,000-page chat history between two people, but it's not found on a device, but it's found on the server, what does that indicate to you?
That one person deleted it.
Okay. And in fact, Jennifer Crumbley had the Facebook Messenger app on her phone.
That's correct, she did.
Just this was deleted.
The chat thread, correct.
All right. Now 78 is a few slides, so we'll go through it together. Okay, we have the date and time up there. We're going to start with March the 9th of 2021. We're going to backtrack a day to give it context, and then we're going to go through late winter, early spring of 2021. Okay. So before we get into this, is it fair to say that as an investigator who analyzes all this electronic and digital information, you're able to provide a digital footprint for the individuals you're investigating.
That's correct.
Okay, and that's the goal of your investigation, generally speaking?
Yes, sir.
All right. Blue is who?
That is Jennifer.
That's Jennifer, okay. So she wrote, leaving at 4 today, what time you done? And that was March 9th at 2:55 p.m.
Correct.
Okay, now it says UTC -5. What does that mean?
The UTC is, that people might know as GMT. It's where all time starts in Greenwich, and then it goes plus or minus depending on which way you go from that line. At that time of the year in March, we were -5 hours from the start of time. So if you add 5 hours, it would give you what the UTC actual time is on the Earth.
So when we see UTC minus a number, that indicates to us that that's real time.
That's correct. It's already been factored in. The software did that.
Perfect, okay. So March the 9th, you able to get an idea what James and Jennifer were doing and talking about in this conversation?
Yes, sir.
Okay. So she wrote, leaving at 4 today, what time you done? James wrote 5. He's in green.
Correct.
And we know that because that's his Facebook ID as well as his name that came with the Cellbrite reader.
Correct, yes, sir.
Okay. And she wrote, okay, see you at 5:30.
Correct.
Sir, in all the information that you recovered, is it fair to say that James and Jennifer Crumbley communicated quite a bit through Facebook Messenger?
Yes, sir. They did.
And so the Facebook Messenger thread is substantially more so in volume and data than any text message thread you found between the two of them.
That's correct.
Okay. All right. 3:46, March 9th, Jennifer wrote, bring me socks in a drink, LOL. What did James write?
A drink? Nah.
Okay. Jennifer, got myself a drink at 4:31 p.m. And James's response?
Okay, you grab smokes too. Almost out, I think.
Okay. And she writes, yes. Did you check the front porch? And what did James write?
Nothing on the porch. What were you expecting?
And she wrote, their new blankets. Now, are you able to determine where they go later that day?
Yes, sir.
Okay, so need hoodie, NOL socks. I believe that was supposed to be wool. He wrote hoodie check. What are no socks? On my way. Okay, now this is Exhibit 79. Actually, I'm going to approach, unless there's an objection to the photograph found on her phone.
I have no objection, but again, I would ask.
That's fine. That's fine.
Before they.
Yeah, I agree with you.
Thank you.
I agree with you.
But no objection to 79. Thank you.
79.
There are two exhibits on one side, so this is 79, and underneath it is 80. Have you seen those items before?
Yes, sir.
And how have you seen them?
There were pictures on Jennifer's phone.
Okay. So I'm going to move to admit 79, I believe, stipulation, as well as 80.
I'm sorry, can I have a moment, please?
Sure.
I have no objection to 79 or 80. That's correct.
79 is admitted and 80 is admitted.
Now, as an investigator, are you able to tell when you look at a photograph that's saved on a phone where the photograph was taken and when it was taken?
Potentially, yes, sir.
Potentially. Okay. And what circumstances?
If the camera is set to record, that you want it to tell you the date and time that it was taken and the GPS location of where you're at on the Earth.
Okay. So 79 and 80 on the screen. 79 is the picture itself, and then in the text box on the right, that's the metadata?
Correct.
What's metadata?
Metadata is, we call it, it's the data within the data. The main data here is the picture of the horse. The metadata inside that data is all the stuff, the camera make, the camera model, that's captured that you just don't usually ever know that happens.
You know, I think before we get into your investigation into the phones itself, I want us to back up a little bit and talk about your involvement, how you got involved in this case. So November 30th, 2021, you were a detective in computer crimes.
Yes, sir.
Okay. And do you remember that day?
Yes, sir.
Okay. Were you working?
Yes, sir.
Okay. Where were you at At 12:51 p.m. on November the 30th.
At 12:51 p.m., I was sitting in my office, I believe, at the Oakland County Sheriff's Office.
Okay. Did you learn of the school shooting in Oxford?
Yes, sir.
Tell me how you learned that and what you did next.
Our captain came in, and well, prior to that, our sergeant, who was off that day, had said that there was a shooter at the high school, and we thought in the office like it was just somebody near the area that fired a long gun or something like that, you know, from a house, and you know, the police are going to show up and do their job. And then probably a few minutes after that, our captain came in and said that there was a shooting at Oxford High School, and the phrase used was all hands on deck.
Okay. So what did you do?
Being what is referred to in the business as a computer nerd, you just grab your stuff, you know, your computer, your laptop, what you think you might need. What we had no idea what we were getting into, and I knew Oxford was a long ways away from the Pontiac area. I figured by the time I got there, it was going to be long over, and me and my partners were just going to do what we do.
Okay. So, did you get in a squad car? Did you get in an unmarked car?
I have an unmarked. At the time, I had an unmarked white minivan with emergency lights and siren in it.
Okay. So did you start heading north then?
Yes, sir.
All right. Tell me about that.
Well, at first it didn't seem real. I remember pulling out of the parking lot, and I looked to my left, and there was some patrol cars coming around the corner. There's the medical examiner's office down there. And I'm like, then it like really came real. Like, holy crap! Like they know about it. It was the state police. I'm like, they know about it. Like this is serious. It's bigger than I could ever have imagined. So I flipped my lights on at that point and just drove north.
Okay. How fast were you going?
As fast as the van will let me.
How long did it take you to get there?
I have no idea. It seemed like eternity, I can tell you that much.
So, Oxford High School, it's a large school. It's one level. It's one story, rather.
Yes, sir.
As far as area, it's got a pretty big footprint. Okay. So, where did you go when you pulled up?
When I was driving there, there was a lot of radio traffic, a lot. I remember I was actually at 24 and Lapeer Road, M24 Lapeer Road and Updike, and they called that S1 was in custody. And I was still, I know, a ways off from there. But that, you know, we didn't know what was going on. We didn't know if there was a second shooter, a third shooter, a bomb planted somewhere. So, you know, it just didn't stop. And I drove north on 24. Again, it seemed like eternity. And with every half mile I drove, it seemed like there was another emergency vehicle falling in behind me.
Yesterday was described as a caravan. Would that be accurate?
Oh, it was definitely a caravan. There was one time we got into, I remember we were approaching a light, we were getting closer, and there was, the light had just turned red, so cross traffic was going to start, which obviously a dangerous situation, being in a car, actually the white minivan that no one believes is a police car. And so as I approached, I got up into the intersection, I inched my way in there to stop traffic and hold the intersection, and I counted every vehicle that went past me, and there were 18, or SWAT trucks, ambulance, patrol cars from agencies that were nowhere even near our area.
So tell me what you see when you pull up on the scene.
Like I said, there's a lot of chatter on the radio. I wasn't familiar. I'm not familiar with the area of Oxford at the time. I had no idea where the school was. All I could hear was the staging area and Ray Road. And so I'm just thinking, I'm just going to drive north. I'm going to follow this caravan. We're going to go up there, and as soon as I see the Meyer, I'm going to stop there because I have no idea where the heck I'm going. I didn't bother putting in my GPS, of course. And I turn onto Ray Road, and all I see is I see kids that look like my kids. There were girls wearing real, small clothing, and one kid, I didn't have a shoe on. They were coming down the road, coming towards the Meyer, and just like walking across the snow. And I remember God, it was cold that day. I had 2 coats on, and I was shaking when I got out of my car. And there's kids just walking past me, dressed like anybody in this courtroom is right now, they're not ready for the weather.
All right, a former detective with the Oakland County Sheriff's Office becoming visibly emotional there during the trial of Jennifer Crumbley. We have to take a short break, but we'll be right back.
If you are watching with us over the air, we are taking a break, but you can watch this trial uninterrupted on our stream, cbsdetroit.com, also by downloading the Pluto TV app. We'll be right back.
Just everywhere, just staying in the cold or making their way into the, I'm sorry.
It's okay. It's okay. What did you do when you arrived? Where did you go?
Like I said, I went to the garden area. I picked up on what they were trying to do. They were passing out notebooks just to write down everybody's names and phone number, all the students that were coming in. So I first started just collecting that. And then they started telling everybody, you know, we got to go outside and get all the kids inside because again, it was freezing out there. And so I go back outside and I start like trying to direct people like to go inside. And I know the trauma they just experienced, so I'm not gonna force them in the building. I'm not gonna grab them and drag them in there. And I remember putting my arm on a couple of the kids' shoulders and like they didn't move, they didn't nudge, they didn't do anything. There were parents there, just standing there. There were some parents that had made it reunified with their kids. I remember seeing school buses pull up.
School buses with who?
Students on it that had made it out of the school.
Did you go to the school?
Yes, I was probably at the Meyer for like 15 minutes, 10, 15 minutes maybe. And then Detective Jeff Enger had called me and said that he was attempting to obtain the security footage from the school.
Where does Jeff Enger work?
He's also a detective in the computer crimes unit, worked with me.
So you were asked to go to the school?
Yes, sir.
Why were you asked to go there?
At that time, I was a little more versed in DVR systems. Jeff had told me, Detective Enger had told me that he was looking to trying to get that off of there, and he just didn't, you know, he wanted to get it right, of course. And so he asked me to come up there and help him.
Okay. So you drove to the high school from Meyer, or did you walk?
Welcome back to CBS News Detroit and our special coverage of the Jennifer Crumbley trial.
That trial continues today. Now, day 2, we're going to listen live.
And tell me what you saw when you walked in.
When I first walked in, well, there's vehicles people walking in and coming in and out, crazy chaos. And I walk in and Sergeant Sean Wilson was standing at the door, keeping security, so to speak, you know, at the time, making sure people aren't coming in that shouldn't be there.
Okay. And where did you go?
I asked where the security office was because that's where Detective Enger told me he was, and people pointed me. Eventually, it was back behind the main office.
Okay. So tell me what you did when you arrived and who was there.
Jim Rourke was there, who was a school security at the time. He was trying to get the video footage. Detective Jeff Enger was in the room. Lieutenant Marsban was in the room. Deputy Lewert, who was a school resource officer, was in the room. And ATF agent was also in the room.
That was Mr. Brandon?
Yes, exactly, yes.
Special agent, not Mr., I'm sorry.
Yes.
Did you know him at the time?
I had no idea who he was.
Okay. And you said you had a familiarity with DVR systems, that's why you were called?
Correct, yes, sir.
Okay, so what was your specific role at this part of the investigation?
I'll be honest, I wasn't given a direct mission or anything at that time because they were looking for a second bad guy or a third bad guy. And so I knew that people would want to know, the bosses would want to know what happened, like where did it start, who was it if they didn't know that, or were there more people or whatever. So we just starting to look for the shooter in the hallway that it started.
Was the school made safe at that point? They were still clearing the school?
No, it was not.
Okay. So the officers were still conducting their searches because, like you said, they weren't sure if it was one shooter, two shooter,
yeah.
Two shooters?
It might have been, I'm sorry. It might have been 1:30, 1:45 at this time, maybe a little bit later than that.
Okay. That's the time you arrived at the school?
And got to the office, correct?
Got to the office. Okay. Thank you. Did you learn how many surveillance cameras were active in Oxford High School on November the 30th of 21?
Yes, there's well over 90 of them.
Okay. And so it was your job at that point, or your role as you saw, to identify who the shooter was?
Correct.
Okay, so how did you go about doing
We started in the hallway, the 200 hallway where it all started, in the bathroom that the shooter came out. And we attempted to backtrack him going in there. I remember it took us like 15 minutes to try to figure out because he had actually changed his clothes. We didn't know who the shooter was. We didn't know his name in the office at that time. He was in custody at the time, but we didn't know. And I remember someone in the office, someone saying, eventually giving us his name, and then saying that he was in the school counselor's office earlier that day. So we went back to that time of day when he was going in and out of the school counseling office to find out what he was actually wearing at that time. And we were able to follow him into the bathroom then.
How long did that process take you?
Well, because we didn't know what he was wearing, it took us 20 minutes to try to figure that out.
Now, are you the person, so you backtrack to the point where the shooter walked into the bathroom that he emerged from to begin the shooting, is that right?
Correct, yes, sir.
Okay. So are you the person, the investigator, who actually put together the footage of the shooting itself?
Yes, sir.
So you're familiar with the path the shooter took in the school?
Very much so, yes.
I'm going to ask you to walk us through that. So he said, you told us that he went into a bathroom. That's the bathroom adjacent to room 258?
Correct, yes.
Okay, tell us what happens next.
You're watching the start of day 2 of the trial of Jennifer Crumbley, the mother of the Oxford shooter.
We have to take a quick break if you're watching with us over the air, but we are uninterrupted on our stream, cbsdetroit.com and the Pluto TV app. We'll be right back.
Is a victim, and he shoots her in her neck, and then her boyfriend was there and shot him in his. He put his hand up and shot him in his mouth.
And that's right outside 258?
Yes, sir.
What happened next?
He then quickly turned his gun to a group of 4 girls that were just standing there. He shot Hannah St. Julian, and she immediately fell to the ground. And then he continued shooting in the area that those girls were, and they sort of just like fell on top of each other, because they were hit as well.
May I first witness?
Sure.
This is a map. It's already been admitted. You can use this to describe.
What exhibit?
That's 5, Judge. Thank you.
Judge 5. Okay. Exhibit 5.
Exhibit 5. Thank you.
At this point, it's under a minute that all that shooting happened, and then so at that point, obviously, it must have really, again, kicked in, for lack of a better phrase, to the victims in the hallway, and they started running. Then the shooter, with just a one-arm grab, just started firing rounds down the hallway, with no regard for obviously anything, and bullets are flying, and there's one girl who was, you see at the end of the hallway. She just, as the shooting starts, she drops down into the fetal position in an attempt to protect herself. And
Welcome back to CBS News Detroit and our special coverage of the Jennifer Crumbley trial. Currently, former detective with the Oakland County Sheriff's Office, Edward Rugrosky, has taken the stand.
We're going to take you back into that courtroom.
One stops at a classroom that obviously the victims inside have already locked the door, so you can't pull it open. You see her trying to tug on that door. And there's another girl with dark hair that comes running up behind her and like grabs her while the shooter is just shooting down the hallway. And then they just take off running further down the hallway. Now he's rounded the corner from where it all started. Continues going down the hallway. I think at that point he might have reloaded his gun and continued down the hallway. I'm sorry. And then he stops as he gets to, like, there's a courtyard, what they call the cubby. Jim worked on what they call this area the cubby, where the cameras are. And you see Tate Muir, he comes in the door, and then just takes a left. He must not have known what was going on. And that's when the shooter leveled the gun, like if you were at a gun range and practicing. Leveled the gun, appeared to look down the sights of the gun, and fired a round. Tate just fell instantly. He continues on down the hallway, walks past Tate, doesn't care to acknowledge the fact that even happened. I'm sorry. Prior to walking down the hallway, that's right, while Tate's body was laying there, you see the shooter with the gun still level fires another round, and it causes Tate's body to jerk. I don't know if it hit him in the hip or the backside or whatever. Tate's body jerks. And then the shooter walks past him. You see his feet at the top of the camera frame. There's not a camera that picks him up because if there's not enough movement, they don't start recording. But you see his feet stop in what I later found out to be a teacher's classroom. And he turns, and then he fires into that classroom. He continues on down the hallway, looking into classrooms and stuff like that. There was one, as he gets so far down the hallway, he had fired a couple rounds down the hallway. Once he gets to a certain point, all the children are gone at this point. The teachers had gotten him out of there. They had ran, out of the building and out through the door, wherever the heck they could get out of there. As he's coming back, you see him stop because the way that classroom was, if you're walking away from it, it's on your right-hand side, you don't see the classroom because it's actually behind you at this point. But as he's coming back, he must have seen people hiding in a corner because he can now see through the window. And he fires off a few rounds through that window. He keeps coming down. He's coming back down the hallway now at this point. And then the assistant principal, Gibson Marshall, I didn't know her at the time. He walks right past her. And sort of, I don't know what she said to him, but if she said anything. But you see the shooter as he's walking by, and the gun's in his hand, and he sort of just turns his head and just I don't know why, but he turns his head and looks away from her, doesn't even look at her, doesn't acknowledge her as he's walking past.
You're watching testimony in the trial of Jennifer Crumbley, the mother of the Oxford shooter.
We've come to the end of our broadcast over the air, but we will continue our coverage over the website, also on our stream.
Yes.
How many times have you seen this footage?
Like I said before, I don't know, it's burned in my brain.
And it was your responsibility to obtain that footage, to get the information to officials at the sheriff's office and federal law enforcement as well?
Yes, sir.
So you were the person that had to watch, rewind over and over again?
Countless times, yes.
Judge, this might be a good time for a short break.
Okay. Your Honor, my client could use a second if we could, please. She's like, I'm trying to
Okay.
we've had.
Okay, I understand.
Thank you.
I understand. Okay, so we're going to take a 10-minute break, so if you can be ready to come back here at the time. Sergeant, I'm in the habit of demoting and promoting people while they're in the stand. You're sergeant?
No, ma'am, I'm an analyst now. I'm a
Analyst.
civilian employee, I'm
You're a
sorry.
civilian.
I'm sorry, ma'am.
You dismissed her. Okay.
Yes, sir, ma'am.
You are still a witness and still under oath, so you can't discuss your testimony with anyone during the break.
Yes, ma'am.
Okay?
Yes, ma'am.
All right, you can step down.
All rise for the jury.
You can take her downstairs. You can be seated.
Welcome back to CBS News Detroit and our special coverage of the Jennifer Crumbley trial.
We're going to take you back into the courtroom where testimony is continuing now on day 2.
All right, so we no longer have that audio, but we can tell it looks like they're taking a break for now, just about an hour after it began this morning. And we're back with our experts, Richard Convertino and Terry Johnson. Thank you both so much for being here. So what was happening just then? Because we've had one witness this morning.
Yeah, so far you've had a former Oakland County deputy who's now a U.S. Secret Service agent, you know, after 28 years. And he's just testified to, it's kind of interesting, he testified to his knowledge of computers, what he did with computers, and I was a little surprised that they allowed him to go into him going to the scene. I mean, he was called as an expert witness to talk about these text messages and other things, and I'm not sure, because obviously there was a slight break in there, if the prosecution has finished their direct and it's now up to the defense to put on the cross. I'm not sure where we are right now. But.
Yeah, and it seems like even though all of these things overlap in a way, we're kind of losing a bit of the focus on Jennifer specifically.
This is a classic example of the merging between a fact and an expert witness. That's totally inappropriate. You have an expert witness who was qualified by the judge to testify about the CART procedure of the Secret Service and the CART procedure, the computer analysis response team that analyzes phones, computers, etc. And that was why he was called and qualified as an expert. He merged into a fact witness, and not only a fact witness, but a devastating fact witness, because he was allowed to put the jury in Oxford High School. He showed the jury and spoke to the jury and told the jury step by step by step in a devastating way each and every act of the defendant, of the shooter. From the time he left the bathroom, he said he thought he changed clothes. He was so detailed as to say at this point in time he changed magazines, callous and concise in his shooting. Took a stance at one, very devastating fact witness, the type of witness that you would never be able to get. The defense didn't object at all, which is stunning, absolutely stunning. And so you had this person who is now qualified as an expert. The jury looks at him in this different, has a different perception as an expert as opposed to a fact witness. But he, in fact, was so far the most devastating fact witness, and probably will remain such throughout this case. It's absolutely mind-boggling that there were no objections. So this is the type of witness you can have a merger between a fact and an expert witness, but they testify at separate times. So you have a witness who testifies as a fact witness, then you can recall them, qualify them as an expert witness, and they testify to both. So I don't know how she's going to cross-examine this guy, given the fact that there's this merger of fact expert. But it's absolutely stunning.
Terry was saying throughout, you were like, why is there no objection? Why is there? This is what you guys do. So you're sitting here.
No, it's not what we do. It's what we don't do.
Right. But I'm saying you're here saying what you would be doing in that situation. Saying why is there no objection to this?
You know, from the time the testimony started until right now, there has not been one objection on the record to break the prosecutor's rhythm, to even leading. There were so many leading questions. Sometimes you've got to get the prosecutor back to the standpoint of, oh my God, I need to make sure I ask the right question because she's going to object, and you don't want those objections sustained. I've seen nothing. And again, I'm not making this about the defense attorney by any stretch of the imagination. I'm merely talking about the fact of what I'm seeing looking at this point that, number one, this witness got on and he's talking about what happened at the scene, but he comes on at, you know, as Rick said, as an expert. I mean, there should have been an objection there. There should have been a complete break. And if they want to call him back, that's something different. But this was all done for emotion.
The other thing that he's doing, he is very emotional. He's becoming emotional as he testifies, which is powerful. The other thing that he's doing is he's commenting on the surveillance video itself. So the video speaks for itself. It's an exhibit, a separate exhibit. But to walk through, and he has this jury, you know, in absolute, you know, focus, and he's talking about almost as if he was, you know, he was there. And he's saying this is what he did. He fired a shot into the still body of Tate Meir, and the body jerked.
Yeah.
We hadn't heard that detail
powerful
before.
testimony.
Yeah.
That should not have been allowed.
That should not have been allowed.
Yeah, I mean, there should have been an objection at that point because he's seen something that hasn't been brought into evidence, and he's giving, you know, he wasn't there. That's not allowed. That's not allowed.
When we started off talking about the text messages via Facebook between Jennifer and James, and it seemed like he was maybe going somewhere with that, but then we got off on a different path and started talking about the day of. Does it seem like we're losing some of the relevancy, at least tying Jennifer to that testimony?
Well, and that's the interesting point in all of this. If you look at it, and again, defending this case, what do they have to show? That she had knowledge, she assisted or didn't do something in order for involuntary manslaughter to go forth. The prosecution is pounding on emotion, what happened, somebody's dead, and the response should be, listen, we're sorry for what happened. However, my client had no knowledge of this. My client could not have stopped this if she didn't know. That theme is not being brought out, and that should have been the theme. And hopefully during the cross-examination, I would ask a simple question, you know, detective, what knowledge do you have that she absolutely knew something was going to go down? That's how you start to break that down.
Well, you ask a question like that, I'll tell you what, this witness is going to answer. Exactly, he's going to answer with a devastating answer. If you ask, you know, what knowledge did he have? Well, based upon my review, you remember one thing that an expert can do that a fact witness can't do is testify about opinion. Based upon my experience and professional expertise and having reviewed all this evidence, it's my opinion that, boom, she had knowledge, and he,
Well,
you know, that's the kind of thing that I would anticipate a witness like this would answer, and
Well,
so I wouldn't ask that question.
I would disagree with him being able to do that simply because that is, he's not an expert in her head. He's an expert on what this data pulled from this point to that point, what it said. So at that point, I believe it really gets into the point of, you know, even asking the question, maybe even in a more specific way, show me specific evidence where it said, do not go in that school and shoot anybody. Do not carry a gun to school. Those are the specific ones. And I agree with you. You got to be careful how the question is asked. So.
You had something you wanted to add about special agents being called. What does it mean to be a special agent?
The term special agent.
The term special agent.
The reason they're referred to as special agents is each department within the government, within the United States government, has a law enforcement component under Title 18, and it allows them to investigate, carry firearms, etc. So the Department of Agriculture, the Department of Interior, all of the departments, IRS, they have special agents, and the reason they're called special is because they are confined to investigate crimes within either DEA, Title 21, FBI, Title 18, IRS, Title 42, etc. So the Department of Agriculture, under the agricultural codes and the CFR, they have the ability to make arrests and investigation, and they're called special agents as well. The agency with the broadest investigative powers is the FBI. They can investigate any crime. And Secret Service, the reason he's testifying now, I think, as a Secret Service agent, is because Secret Service specifically has the authority to investigate computer crimes and electronic device crimes as well. So that's why they're called special agents.
Interesting. You learn something new every day,
Yeah.
don't you? Yeah, so we were also speaking just between us as we were watching this, how interesting it is that this husband and wife, James and Jennifer Crumbley, were communicating on Facebook Messenger. They were sending screenshots of a drawing that the shooter made that he was called in for the morning of the shooting on Facebook Messenger. It just struck us as odd, didn't it, that you wouldn't communicate with your spouse on just a text message.
Yeah.
I wonder if they'll ask about that.
You know, the relationships, people do things differently. Some people use Instagram, some people use text messages. You know, I don't know that it's one way or another that, hey, we're trying to hide something because it's on Messenger. That might just be the way that they communicate with
I
one
had a
another.
question for you. I didn't know you were a firearms expert, and so yesterday there was testimony from the BATF agent, the special agent who testified regarding the types of rounds that were purchased and used.
Yes.
And they were the Patriot Defense rounds. Now I have a CPL and I carry, and I use different rounds for target practice that I do when I carry. And so I use the Patriot Defense when I carry because it has a higher grain.
Yes.
And is that significant? There were no questions regarding the Patriot Defense ammunition as opposed to 115 target grain ammunition,
Right.
which has a lesser kick. Can you tell us if there's a significance to loading as you carry the Patriot Defense rounds?
There's really no difference. I mean, most people are taught, generally you have rounds that you take to the range. Most of those rounds, and again, I don't know if these were full metal jacket or not, that they were referring to. I'm not sure if that came out. I missed that part of the testimony. But there's really not a significant difference. I think it's just the name Patriot. Rounds that you use at the range are cheaper. They have a tendency to pass through, not as much grain. But using the Patriot versus anything else, I don't think is really significant. I don't think it opens up the shooter for more liability per se. I mean, using a Patriot versus a basic round that was used at the range isn't really going to make a difference in terms of the effect that it had on the individuals who were wounded at that case, at that school.
Something else that happened yesterday, the defense was arguing that there's no way that Jennifer knew that gun would be used to kill. Any thoughts on that argument, and also how she's trying to, again, help her client in that way?
Well, I mean, she has to go down that road. She has to say, I had no knowledge. I can't stop something if I don't know what's going to happen. So that has to be the theme throughout. And we saw little flushings of that yesterday, but it just wasn't enough. You know, I mean, that needs to be the constant theme if you're talking about involuntary manslaughter. I couldn't have stopped something that I didn't know was happening.
Mm-hmm.
Yeah, certainly, it's hard to impute that she knew that the gun would be used in a killing. I don't think that's a reasonable representation of the facts as they are, but that's not the standard, that's not the law. It is whether she knew, based upon her awareness of her son, his mental stability, all of the problems that he was causing, that he had, the school, going into the counselor's office, the drawings, the past history, with animals, denigrating and abusing animals, etc., and whether or not she was aware of the potential consequences and ignored them. That's the prosecutor's position. She was criminally negligent. If she were aware, then specifically aware, if she thought, well, this gun's going to be used for a homicide, then she'd be charged with second-degree murder.
You know, one of the interesting things, we talk about, and you're a former federal prosecutor,
Yes.
right? Did you notice that the feds in this case haven't been involved? I mean, if you look at this, there's been so much talk about the Crumleys purchased a gun for their son. That's obviously a straw purchase in this case. But they purchased the gun, and that's been going on, that it was purchased specifically for him. And I don't know that that's been debunked, per se. I mean, I'm just surprised that the federal government especially seeing everything that's happened thus far, has not charged the Crumbleys, the parents, for something like that?
Well, they're charged with involuntary manslaughter. So what would you suggest they be charged with federally? The purchase was legal. They purchased a weapon. They were entitled to purchase a weapon. They did the background check. They satisfied the background check. Right. So he was the owner of the weapon, and that the weapon got in the hands of a minor, and the minor used it to proceed with this horrific act is being charged with involuntary manslaughter. So I don't think that if you're intimating that they should be charged with some form of reckless handling of a firearm after it was purchased or something in that regard.
Well, actually, no, I think you've answered very well. You know, I'm saying this was not a straw purchase. This was a gun, as you stated, that got in the hands of a minor. And if this were, the prosecution has been saying all along, they bought this gun for their son. This was bought, oh, they bought him a gun, they bought it. And it's like, no, they didn't. You know, I'm just trying to debunk that particular argument that this was purchased for him. It wasn't purchased for him because, again, legally, you can't do that. As you said, they did the background check, they did everything they were supposed to do. The gun was still at the house. Just because the kid made the statement, hey, this was brought for me, doesn't mean that it was so.
Well, you both go to gun ranges. I mean, you're gun owners. Is it common to see young people there, even children, using weapons?
In my perspective, I haven't seen that. I think it is fairly common. I think that in our society, younger people are and have for some time been taught at an early age to properly handle weapons and discharge them and go to the range and hunt and all of those recreational things. I think that is fairly common. I can't speak to anything other than what I've personally seen, which is I've never seen juveniles at the range when I've been there.
And with that being said, considering Jennifer and the alleged negligence that led to the shooting, do you think that's a strong argument to say that it's irresponsible to take a child with those issues? No,
again, I'm a CPL instructor, and I've had kids in classes. There are a lot of safe gun handling classes that are out there that are literally designed for parents and kids. So that's not out of the ordinary to see a minor. And now when you say a kid, I'm not talking a 7 or 8 year old, but again, we're talking a 14, 15-year-old minor child. That, you know, that's some of the things you want. You want kids to understand what a firearm is, you know, how dangerous it can be, things along these lines. Obviously, this shooter took it to a different level. I don't think anybody was there training him okay, next week you're going to go into school and you're going to do this and you're going to do that. I don't think anybody was training him for that.
It's an interesting point. You know, there really are two sides to this argument, to gun control, to gun rights. Like you said, should children, some people would say children should not be around firearms at all, period. Full stop.
That's my position.
Some others say we're gun owners, we have children in the house, we think they should understand how to use it and feel comfortable with it and be responsible with it. So there really are, so that's your side. So we have both sides here. No, it's interesting to unpack this because there are a lot of people in this state, in this country, who would say it looks like, according to these gun range videos, he was using these guns as a 14, 15-year-old who would go with their parents would do.
Yeah,
he had training.
And what about outside of the metro area? You know, when you go up north and some of the rural areas, those families actually teach people how to use shotguns and guns, and they take them outside. But for whatever reason, in the metropolitan area, a lot of people see it as taboo, and I'm not sure. I'm not saying it's good or bad. But again, I believe education on any level, you know, what to and what not to do is very important. You know, when I was a minor, my dad had a firearm in the house, and the only instruction I got was, you stay away from this, right? And that actually raised my curiosity. Why? Why do I have to, what is it? There was never any education on it, just stay away.
But shouldn't there be extra safeguards in place if you have a child who's especially dealing with mental health issues?
Oh, absolutely.
No question about that.
No doubt about that. No doubt about that.
And how did he access the gun the morning of? He was able to access
Was unlocked.
It was unlocked.
Seemingly unlocked. That's the intimation. That's the circumstantial evidence, based on the fact that there's no evidence that that the lock, which was at one point when it was discovered, was underneath the foam inside the safe case. So there was no evidence that it was ever used. That there's no evidence of any other external lock that would show that the gun safe was ever locked, other than just simply closed. The combination was 000, never changed. So there's evidence, circumstantial, that the gun case was never effectively used, and so it seems that he just went in there, removed it, if it were in there at all, but had access to it unfettered. I think that's the important thing. There was never any ordinary and reasonable steps taken by either parent to secure the gun from the shooter.
But at the time, that it wasn't a law here in the state of Michigan. I mean, that law that Rick just talked about, or I'm sorry, that what Rick was talking about is actually now codified and will be a law in February. So even if it was not locked away or not properly stored, there was no law against that. Now
there's
again,
common sense. You know,
there's common sense.
You don't leave a firearm, especially someone who discussed suicide in the past,
Right.
who had these wild and absolutely disturbing images that he would draw both at home and then the one that he drew at school. I mean, under no circumstances should he have access to anything close to a gun, let alone a gun itself.
And that's going to get back to this case, because again, if in fact Jennifer Crumbley knew he had the thoughts that Rick's talking about, and she left that firearm out. And again, one of the arguments that the defense has made is that she being Jennifer Crumbley, didn't know anything about the gun, didn't know how to use it, didn't know how to store it. And I think she started yesterday by saying it was Dad, James Crumbley. He's the one that should have stored it. He's the one that should have did that. And if those things are true, does that take some responsibility off of Jennifer
See, what
Crumbley?
obviates it, you're right, there was an empty chair defense yesterday for sure. It was James, if anyone is James.
Right.
But what obviates that is Jennifer took him to the gun range. So
She went to the gun range. She didn't, when you say took, you're saying, you know, hey
accompanied,
son, come
traveled
with
with,
me.
went with, participated in. Well, I don't know what other words to use.
Well,
she was
I
at the
don't
gun
know.
range.
She went to the gun range with her son.
Yes, that's what I said.
And I
yeah.
believe the testimony, or what I've heard so far, is this is only her second time using a firearm. So and we all saw, you know, with the shooter, how efficient and
He was actually
proficient.
showing her how to
Right.
reload.
Right. So how am I taking that? That doesn't mean that she knows how to use a firearm, and that doesn't mean that she's teaching him how to use it.
Well, she doesn't necessarily have to teach him how to use it. She has, but what the point you were making was that she may not have been aware of the magnitude and dangers that follow the use of a firearm, and including the fact that it should be secured safely. That she wouldn't have any idea whether or not it had to be secured safely. And,
Well,
and I'm saying these,
kind of.
these facts that have come out, including the testimony that this kid's telling his mother and father that he sees demons in the house, that they're after him. He's pleading for help. He's asking his mother and father to please help me. So,
Gentlemen, let's pick this back up in just a few, because we've
Sure.
resumed in the courtroom, so we want to listen in. Some of what you may hear and see is disturbing, but we'll be back and continue this conversation.
Sir, those are text messages exported from Jennifer Crumbley's phone. Have you seen that in the past?
Yes, sir, I have.
Okay, and how did you come to see that?
From the phone extraction.
Okay, and you extracted the information and you reviewed those messages?
Correct, yes.
People moved to admit 82.
Any objection to 82?
I'm sorry.
Remember?
82 is a text message between shooter and Jennifer, pages 105 to 106, dated March 9th, 2021.
Yeah, I believe that the court, I've previously said,
lodged an
thank you.
objection that I ruled on. Correct, it's preserved. 82 million.
Thank you. Sir, I'm going to publish that because there's multiple slides, and then you can look at the screen. So this information is from Jennifer's original phone. Is that right?
Correct.
Okay. And so People's 82, we have multiple slides here. The blue is the defendant's son. Is that correct?
Correct.
Okay. And what is he writing at March 9, 2021 at 7:50 in the evening?
He's asking if Jennifer could come home. There's someone in the house, I think.
Okay. And what's the next text he writes?
The third one says someone walked into the bathroom and flushed the toilet and left the light on.
Okay. That's March 9, 2021 at 7:50.
Correct, yes, sir.
Okay. And then March 9th, 7:50 and 52 seconds. What does he write?
And I thought it was you, but when I came out, no one was home.
And then he writes, there's no one in the house, though.
Correct.
Dude, my door just slammed. That's at 8 p.m.
Yes.
Maybe it's just my paranoia. That's at 8:01 p.m., March the 9th.
Yes.
Okay? And then this is 8:01 p.m. text to his mother, the defendant, but when are you going to get home? And when was the next text response in the phone download that you recovered?
The next response was the following day on March 10th, where she said, "Where's your dad?" at 10 a.m., 10:21 a.m.
May I approach the witness?
Sure.
This is People's Proposed Exhibit 83. Sir, take a look at that and tell me if you recognize what I just handed you.
Yes, sir.
And how do you recognize that?
It's an extraction report in a PDF format of a call log from a cell phone.
Okay, and that call log specifically was recovered on the shooter's phone.
Correct.
Okay, and this is from March of 9th, 2021 to March the 20th, 2021.
That's on the last page. Yes, correct.
Okay, thank you. People move to admits 83.
And I have no objection to that.
83 is admitted.
So the slide I'm going to show you is it's a snippet of that. We're going to go back to Exhibit 83 throughout your testimony.
Okay.
Specifically because we're talking about March the 9th right now. March the 9th, 2021, the phone call to either his mom or dad to his father, James Crumbley. It was a missed call at 7:31 a.m. Is that right?
That's correct, yes.
And his mom called him at 8:38 p.m., March the 9th. I'm sorry, March the 10th.
Correct, on the 10th.
Okay, so the time those text messages were being sent to his mother, there were no phone calls or texts back in that relevant time period.
Correct.
Now, I'm going to back up a date to March the 8th to give this context. May I approach the witness?
Sure.
This is People's Proposed Exhibit 84. Sir, 84 is the portion of the Facebook thread between James and Jennifer Crumbley, pages 386 to 388 from March the 8th of 21. Is that right?
Correct.
And you've seen this before?
Yes, sir.
People move to admit 84.
No objection, Your Honor.
84 is admitted.
Okay. So I'll direct your attention to the screen. This is blue again is Jennifer, green is James. Is that right?
Correct.
Okay, and that's because this chat specifically was deleted from Jennifer's phone.
That's correct, it was.
Okay. So Jennifer's words, Ethan going to bowling, and what does James write?
IDK, I don't know.
Okay. And she writes, what do you mean, IDK? His response,
I don't know exactly what I said. We'll know after he gets home.
okay. And Jennifer wrote, does he have his phone? Why isn't he home yet? He should be home by now. That's March 8th, 21 at 3:12 p.m.
That's correct.
Okay. Then she writes, freaking out. And James's response,
He does not get home until 3:16.
okay. And then Jennifer wrote, I told you to pick him up because he's upset and I don't want him to do anything stupid, goddammit.
Correct.
That's March 8th, 21, 3:13 p.m.
That's correct.
Okay. And James writes, dude, chill, he is fine, I'm trying to fucking work.
That's correct, he did.
Okay. So for context, this is the day before those text messages were sent by the defendant's son to the defendant.
Correct.
Now I want to move on to March the 17th of 2021. May I approach the witness? Sure. This is People's Proposed 85. Sir, 85 is the Facebook thread between James and Jennifer Crumbley, pages 432 to 435 from March 17th. Do you recognize that?
Yes, sir.
And how do you recognize it?
Again, it's a printout of a Facebook chat.
Okay. And you've, of course, seen that before?
Yes, sir.
Because you were the one to pull the information?
Correct, yes, sir.
What number?
85.
85.
People moved to mid-85.
Your Honor, I'm trying to pull it up right now.
Okay, sure. It's hard for me to determine from this list
Your Honor, I
which
believe,
exhibits have been subject to previous rulings, just so you know.
Thank you, Judge.
Your Honor, I do object to 84 because there's portions of it that don't need, are not admissible, in my opinion.
84 is
I'm sorry, 85. I'm sorry, 85. There are portions of 85 that the defense objects to, and they have not been previously ruled upon by the court. May we approach?
Yes. Do you want to go in the hallway? I don't know. Because
I think we first need to find what the actual objection is.
The
Because we have
objection,
a foundation to chain, we have a foundation to found, I'm sorry, we have a stipulation to chain and a foundation. He's already testified to a number of portions of this very same Facebook thread.
it's hard for me to know if I've seen this one before or if I know what it is.
this has not been the subject of a prior ruling.
Okay.
I object to portions of page 432. It does discuss a topic that has been ruled to be inadmissible. So I am asking that those portions of 85 be struck. They're irrelevant.
Okay, can I see it?
May I approach?
Yeah, that might help.
May I approach?
That may or may not help.
I'm sorry, you have 85. Thank you.
Because they muted because they've approached. On 3. Okay, we're going to have a conversation now because they're just you made the parents with parents. Okay, so there's no audio because the attorneys have approached the stand, and so we can't hear what's happening right now. But they're continuing this examination of Edward Wogrowski, Richard. He's a U.S. Secret Service agent, formerly of the Oakland County Sheriff's Office. Just give a little bit about his testimony this morning and how you feel it's actually been damaging for the defense.
It's been devastating for the defense. Now, as they broke, they're at sidebar. The witness was a Secret Service agent, was testifying about Facebook posts, and he was going through the Facebook posts. There's been an objection by the defense because she wants to exclude some of the Facebook testimony or Facebook posts. And the prosecution has said that that they've had this, that there was no objection prior, that it was stipulated to, and he has no idea why now there are these new objections to this evidence that she's had for, months and months, if not years. So it's a very incongruent defense. All of the sudden, you recall yesterday, she wanted all of the Facebook posts to be included. She said there were some that were deleted or excised, and she wanted them all. The prosecution said yes. This morning they came in with an exhibit, I think it was Exhibit 423, and the defense attorney objected and said, no, I haven't seen them. The judge, right before the break, a previous break, the judge, I think she was somewhat angry. She said that you've had this evidence for a long, long time. And so I think now the judge is getting a little tired of these objections because there's no congruity to what she's doing. It's either you want them in, you don't want them in, you want parts of them in or not, but you've had plenty of time to go through this. You stipulated to all of this, and now you're objecting over and over.
Even the judge said herself something to the effect of, even I've been over this for an unbelievable amount of hours.
Yes.
Sort of like, we've all had this. Where were you?
Yeah,
Almost. It was
and one of the things that the ancillary results of these types of objections is that the jury sees that the defense is kind of being obstructionist, and they become tired of it and upset themselves.
So we haven't had a cross-examination yet of this expert. What do you think will be her plan? What sort of questions will she be asking?
I have no idea what how this defense attorney will attack this. Now the expert, right before the break, the expert is back on to testifying as an expert, not a fact witness.
Right,
So
we
remember,
see those messages on the screen there.
Yeah, remember there was this mixture of fact expert testimony, which is extremely hard to cross-examine. And I think this witness is prepared to take liberties with his answers, and probably, if this defense attorney is not surgical, concise in her questions, I think she'll be very unhappy with the answer she's going to get from this particular witness. Remember, he's a very experienced sheriff's deputy. He's testified hundreds of times.
Well, we have audio back. Let's listen back
Thanks.
in and see what happens.
And then there was a ruling about, I don't think I have attention.
Oh, I'm listening, Judge.
What's your,
Sorry.
okay, what,
Sorry.
yeah, what's your, okay,
He's just bringing me up to speed. There wasn't room for me to turn.
okay, all right, so, there was a ruling about,
Counsel moved to exclude certain pieces of evidence, and this court made a record that was June the 27th of 22.
okay,
And in that record, actually it was page 40 of the transcript, the court specifically said, the court indicated that it was based upon a preliminary examination transcript. As the court recalls, neither party stipulated the exam transcript for the factual basis, and the court indicated that more evidence is being found even as we speak. I don't want to paraphrase because that's not a verbatim quote.
okay.
And in defense counsel's opening, so to bring the court up to speed on the record, counsel asked to approach and objected to any reference of alcohol. There's one text in this text message thread, or Facebook thread, between James and Jennifer. Jennifer, on March 17th, says, "Gonna get drunk and ride my horse." James responds, "Well, don't get drunk." They have a couple of more text messages in the midst of a conversation that is pertinent to our proofs. And that's because the next exhibit will be text messages from the school shooter to Jennifer Crumbley about seeing demons. And then there'll be evidence of a lack of phone calls, lack of text messages back. And to get back to the court's ruling, the court said no evidence of alcohol or substance use unless it does show some type of parental neglect.
Okay.
So these particular messages are the same time, the same date, where the defendant's son is experiencing or stating that he's experiencing hallucinating. So this is all relevant.
And Your Honor, my point is, on Exhibit 85, there are texts that do not need to be included to make the point that Mr. and Mrs. Crumbley were at the barn and not with their son. We're objecting to the texts that include buying beer, being drunk on a horse. They are irrelevant. They are also irrelevant to someone being a hypervigilant parent. I would consider myself a hypervigilant parent, and I have some cocktails once in a while. That issue is not relevant. The alcohol is not relevant. It's just an unnecessary part of this text to make them look like they're out drinking, when the whole point is that they're out with their horses and not with their son.
Judge, it's not counsel's idea of what the point is.
No, it's not just that they're out with their horses and not with their son, and there's no crime, there's obviously no crime committed by people with children having cocktails, and half this room would probably be in jail. But that being said, the issue is whether or not the shooter's texts are being ignored. That's the point of it.
Right, Judge. And there is an offer of proof, there is substantial evidence that has been excluded that shows the substance use of James and Jennifer Crumbley. Substantial. We're not introducing any of that because of the court's ruling. But directly on point to this, in the midst of a conversation, it is relevant. It's material, it's probative, it's under 401, people do know.
Okay, well, am I able to see a specific picture of because some of it might be, some of it might not be. So I don't love to do this while the jury is waiting. Is there more things like this that, if the shooter is having some trauma, feeling some trauma, and reaching out to his parents and her ignoring him, that evidence to me is obviously relevant.
Correct.
So
That's
I'm not objecting to all of 85. I'm objecting to the portions about alcohol.
okay.
because the door has been open. Counsel specifically said, I think more than once, that her client is a hyper-vigilant mother.
That is not-
Hang on, nobody says anything about having a cocktail, but when there's evidence to show that they are drinking when the son is texting things to the mother, no call back, that's important, and it's important to show the jury what they actually did and spent their time on.
Okay, can I see the text right again? And is that the only one, because the jury's pulling their heels on that? Is there any more like this?
There are more like this. And
Okay, well, maybe we need to do this at 6 o'clock tonight. Or should have been raised last night. Okay.
Judge, these exhibits were turned over a long time ago.
I know.
No. I got all these text messages a long time ago.
Okay.
I found out what they were planning to use from the boxes and boxes of information. I found that out
Ridiculous.
on,
Okay, you-
excuse me, on Tuesday night. Yeah, I've had this discovery, but I can't file a motion to exclude every single line of these things. I filed many motions.
Okay.
I filed a motion about the alcohol. This part of the text that they told me 2 days ago they're going to use includes alcohol. I'm just asking that the alcohol portion be struck.
Okay, I understand that, but I know that there's a lot of exhibits, and I know there's a lot of documents, but we could have had a massive motion in limine fest a while ago, right? So I am loath to make the jury sit there while we're going line by line through evidence. That's very problematic to me.
I didn't intend for this issue to take a long time. I thought this would be a simple objection to just take out the text about drinking, and that's it.
Okay, okay, so she says, I'm going to get drunk and ride my horse. Okay, so that might not be specifically relevant, but at what time does he?
When she's on her horse, that's when he's texting her.
Okay.
And just because she's on her horse and he's texting her doesn't mean she's looking at the text and ignoring him and saying, I'm going to have a drink instead of I mean.
Okay, my understanding was there was a large period of time where he was texting her and she was with her horse. And then maybe some picture of a horse. I don't know.
Correct.
Tell me.
Right,
Yes,
she's
that's
on.
it, Judge.
You're going to hear testimony from other witnesses that the cell phone signal doesn't work out where the horse place is.
Well, then that's argument for counsel to make.
It is.
Right, but the fact that they're having beers out there with the horses is not relevant to the point the prosecution's even trying to make about the fact that they're unavailable and not responding to their son.
Okay, there's a text from James Crumbley. This is not when I like to do this. Okay, she says, gonna get drunk and ride my horse. That's at 1:30 in the afternoon. When do you say he's trying to contact her?
That was a day during the week when she was at work. After work, she went to the barn, the text being around 5:50 p.m. When she's at the barn, we know that from pictures and metadata.
Okay, then Cam's.
And so the court is aware there are no other, we took all other reference out prior to trial of alcohol use in accordance with this court's order. Of course, that's subject to the door being opened.
The door was not opened by me saying that she's a vigilant mother.
Okay, so they go to the barn after work. Is that correct? Do we know what time approximately they go to the barn? Because this text is at 1:30, right?
Those texts are from during the day when they're making plans to go to the barn after work.
Right.
And then I
Wait,
believe,
that's not what I asked.
I believe the text says something about leaving now at,
Okay, so when are they at the barn in relation to his texts about demons?
At the same time.
Okay, but is that at 5 o'clock, 6 o'clock, 7 o'clock?
The first text, the house is not haunted, 6:03 p.m.
Okay.
There's a picture of James on a horse taken by Jennifer. There's a picture of Jennifer on a
and we have
horse
no
at the same
objection to
time.
that.
Okay, all right. So she says, I'm going to get drunk and ride my horse. That she's expressing her intention for that evening.
Correct.
I'm going to allow that text, but not the next one about, well, don't get drunk. We are definitely going to have some drinks. I need to stop and get me a 12-pack of Budweiser bottles, please. I'm going to keep that out. All right, and all right, I'm going to keep that out. She is indicating her intention to go later and ride her horse and get drunk. And when she's riding her horse, when she's at the barn later, is when he is texting and getting no response. So I think that could be relevant to her ignoring her son. All right?
Yeah, bro.
Sure. But this text from James Crumbley, I'm going to exclude. Is there anything else in there that
Okay,
needs
so
to be excluded?
just for the record, page 432,
Yeah.
the second text, or
Yeah,
message
the one
back
from
from James Crumbley.
Crumbley. Is there anything else in there?
I'm looking now.
Yeah. Because I don't want to.
No,
We were making good headway yesterday, but now we're moving at a snail's pace. So.
well, Your Honor, there's also a text responding to the one about buying beers. Jennifer just says, okay, but glass is not a good idea. I mean,
Yeah, that, you can strike that too, because it's referring to the text above. It's not relevant.
so it would just be those two portions.
Okay, yeah, can you strike that? I don't know how easy it is to do it up here, but,
It'll just take a minute.
okay. All right.
This one?
Are there any other issues such as this?
I'm looking right now, Your Honor.
Okay, well, we should be looking right now.
Your Honor, I mean, the next exhibit has been the subject of a prior ruling.
Okay.
I'm,
Good, that's a good way to do it.
okay, exhibit 87, 88, 89, 90, 91, 92.
We're trying on the fly
Okay.
to edit an exhibit.
Okay, go
Or an
ahead.
objection we just got, and now there's like,
Okay, I want to find out if there's any looming issues, because
we do too.
they're going to
because
get their 10,000 steps here.
we do too.
Your Honor, I did not think this objection would be such a process. I simply was asking for like one little part of this to be struck, and
Okay.
objections during trial are common. This is
Okay.
just a very simple.
All right, but is there anything else coming up that would require the jury to step out? There's photos.
Well,
I don't know what objections to such photos.
I have objections to many photos that are going to be brought in through a different witness, but what are they planning to use? Because I have 450 right now. If I know what's coming, I can tell the court.
Okay, well, there's a list of exhibits, and there's coming after that, after the text messages, are pictures. It looks like there's pictures of James and Jennifer.
And we have no objection to those.
Okay, I just want to know if,
Your Honor, if I could just say, there's
Yeah.
there's a lot of inquiry as to exactly who we're calling next, which exhibit we're, and this isn't a math formula. We really are changing this organically because we're working.
I get it.
So we're trying to be cooperative, but things
Okay.
do change.
I know, and you're not required to divulge your trial strategy and your order and all that. I'm moving a lot of people around, and I just want to know if there's anything else that needs to be handled right now on the record.
The only other objections, I believe, with respect to this witness, at least for the next very long time, are objections the court's already ruled on. So,
Okay, thank you.
okay, so at least we can get through, this whole page of exhibits with no problem.
All right.
Okay. Perhaps counsel can meet with us after court today to go over the next proposed exhibits, and then we can see what objections.
Oh, okay, yeah, it's just because I don't want to take your time.
That sounds great.
All right?
Thank
Okay.
you.
All right, so,
So 85 is modified, and we're,
yes.
thank you.
Okay. Are you ready for the jury?
I think so.
Okay. We're ready.
With all, when you say all of those, what do you mean?
Everything. We're at 85 right now.
Yeah, no, okay. These ones, just tell me how far you want to go, because I do agree with all those. Up through 100.
All rest for the jury?
Right, which is already preserved, and that'll be easy.
That's fine.
And then I don't have any objections. I mean, yeah.
That's fine. That's fine.
Issue. I didn't expect it.
You may be seated. I apologize, there's a large volume of information. We want to streamline it for you as much as possible. All right? You're still on here?
Yes, ma'am.
Okay, go ahead.
Thank you. Okay. We're on Exhibit 84, I think. All right. This is between James and Jennifer Crumbley. Again, Jennifer is in blue, James is in green. We'll start at the top because I don't recall where we left off. Does he have his phone from Jennifer, March the 8th?
I'm sorry, you said you're on exhibit 84, but I believe it's 85.
84 was admitted.
84 was admitted. Yes, because 85 is March 17th.
The 84 was on March 8th.
Okay, so you're on 80, I'm on 84, okay, but mine
84 is
is,
on March 8th, and this one is on March.
Yeah,
Yeah,
this is 84 on the screen.
That's 84, yeah.
okay, I'm sorry, there,
He went
it's
back.
scrolled down, so okay, thank you.
James responds with, yes, but he won't answer while he is walking. I will let you know the minute he walks in.
Okay. Jennifer's response, I'm serious freaking out. Is he home yet? And then, okay, now we're moving on to 85. So, James and Jennifer Facebook messages. This is from March 17th of 2021. And you've seen this before?
Yes, sir.
And this is admitted pursuant the order that we just had on the record, correct, Judge? Thank you. Okay, March 17, 2021, 1:23 p.m. Jennifer writes, cool, leaving at 4 today. Fuck this place. James's response is what?
LOL, you have your stuff for the barn?
Okay. And then Jennifer's response, yes, gonna get drunk and ride my horse. That's March 17, 2021, 1:30 p.m.
Correct.
There's a response back. And then what does James say?
James says, okay, then cans, you have the debit card.
And Jennifer's response, I know, hate my job. Can you bring out last, please? He says yes. Correct?
Correct, yes, I'm sorry.
Okay. All right. Okay. Now, on that same day, did you find any text messages from Jennifer's son to her of a concerning nature? This is March 17, 2021.
Yes, sir.
Okay. This is People's Proposed 86. I don't believe we have an objection to this.
No objection, thank you.
This is 86.
86.
86 in here.
Okay. All right. What does Jennifer's son write to her on March 17th, 2021 at 6:03 p.m.?
He says, okay, the house is now haunted.
And then what?
Some weird shit just happens and now I'm scared. Then it follows with, I got some videos.
Okay.
Okay, Your Honor, I apologize. This was previously the subject of a motion. I do object, however, the court has already ruled it's admissible. I'm sorry, I misspoke.
Yes, I
Okay.
yes, I have already ruled on this here.
Okay,
Yes.
sorry about that.
No, that's all right.
Okay, please. At the top.
And then Ethan says, continues with, and a picture of the demon. It's throwing bowls. The word bowls is in all caps. He then says, I am not joking. It fucked up the kitchen.
And the next message after that?
He says, I'm just going to be outsider for a while. Can you at least text back?
Okay, so that's from 6:03 to 6:29. The last text, can you at least text back, was 6:29 p.m.?
Correct, yes.
Okay. And the next response from the defendant to her son is when?
2 days later, at 4:11 in the afternoon, where's your dad?
Now, this is people's 87 and 88. I don't believe there's an objection to either of these two exhibits.
No objection.
Okay, 87 is the picture, 88 is the metadata with the picture. So, could you please tell us when and where this picture was taken?
It was taken, the GPS is similar to the previous ones at a horse barn. He's on a horse. It was taken on March 17th at 6:03 p.m.
Okay, 6:03, that's the same time that the text messages regarding the house being haunted and saw a demon?
Correct.
Okay. And this is actually found on Jennifer Crumbley's phone?
That's correct, it was.
And who was that a picture of?
That's James Crumbley.
And that's St. Patrick's Day, correct?
Correct.
All right. This is exhibit 89 and 90. 89 is the photograph, 90 is the metadata.
And we have no objection to 88, 89, or 90.
Thank you. And this is also St. Patrick's Day.
Can you move for their admission before you put them on the screen?
Yes, Judge.
Okay, thank you.
This is also St. Patrick's Day 2021, is that correct?
Correct, same day.
And this is an image also on Jennifer Crumbley's phone?
Correct.
Okay. And when was this taken?
On March 17th at 6:03 p.m.
Okay. Same location?
It appears so, yes.
Now I'm going to move you on to Exhibit 91 and Exhibit 92. I don't believe there's an objection to either of these pieces of evidence.
There's no objection.
91 and 92 are admitted.
Thank you, Judge. Again, we're still talking about St. Patrick's Day 2021. What time was this picture taken?
This was taken at 6:28 in the evening.
Okay. And again, is that time and date significant to you as an investigator in this case?
Yes, it is.
Why?
It was the time when the shooter was sending the text messages.
Okay. And this is also on Jennifer Crumbley's phone?
Correct.
91 and 92. '93 and 94.
We have no objection to 93 and 94.
93 and 94 are admitted.
Thank you, Judge. Exhibit 93, also a picture captured on Jennifer Crumbley's phone. This is also St. Patrick's Day, 2021, and this is at 6:30 p.m.
Correct.
Okay. Same location as the other photographs we
It
just
appears so,
mentioned?
yes, sir.
Okay. I'm going to go back to Exhibit 83. This has already been admitted. This is the phone log found on the shooter's phone. So the time we're speaking of, those text messages where he sent his mother indication that he was seeing bowls fly off the shelf from the demon, that was between 6:03 p.m. and 6:29 p.m. Is that right?
That's correct.
Okay. So we already saw that there was not a text back from Jennifer Crumbley, but tell us about the phone log. What do these show?
It shows a phone call from Jennifer Crumbley at 7:24 p.m.
Okay. So that's about an hour and a half after he texted about the house being haunted.
That's correct.
And that was a 19-second call?
Correct.
Okay. Now I'm going to move on to March the 19th, 2021. This is a Facebook conversation between James and Jennifer regarding their son that day. This is People's 95. I don't believe we have an objection to this.
No, there is no objection.
95 is admitted.
Thank you. Okay. Again, Jennifer in blue, James in green.
Correct.
Okay. She said, is he awake? And what did James respond?
James responds with, yeah.
Jennifer wrote, how is he?
James then responds with, he woke up looking like he had way, in all caps, W-A-Y, too much to drink last night, complaining about a headache.
Okay. And then her response is, well, he was really worked up and out of control, so I can see why. That's March 19th, 21, at 9:41 a.m.
Correct.
About 48 seconds later, she wrote, all I know is he needs to eat go to work and work hard and not complain, and he can get his stuff back.
Correct.
And then March 19th later on, you responded and didn't get it. That's Jennifer Crumbley's words?
That's correct, yes.
Yes. Just you did have marked 95 down for admission, correct?
Yes, it's.
Thank you. Okay. Now, the next day, March the 20th, did you find text messages from the school shooter to his mother, the defendant, of a concerning nature from that day?
Yes.
Okay. This is Exhibit 96. I believe this was subject to a previous ruling.
Any objection, aside from what was already noted?
No.
96 is admitted.
Thank you. We're still on, I'm sorry, we're still on 95 on the slide. James wrote, Jesus, yes, he said, referring to their son, let me ask you a question. Why am I in your guy's room? LOL. And Jennifer's response is what?
OMG. Oh my God.
Thank you. Just-
Which exhibit is it?
I have to back up just a little bit, Judge. Sorry, thank you. So just to make sure everybody's on the same page, this is Exhibit 95. This is from March 19th, 2021. We had already gone through these. At 9:41 a.m. when Jennifer wrote he was really worked up and out of control. In the same text message conversation, there's no breaks in this exhibit. And the conversation continued. James wrote what?
I totally thought you were giving him a Xanax last night. ...
And Jennifer's response was,
Does he seem better?
and then,
No melatonin.
and James wrote what?
I know.
And Jennifer wrote,
But he hasn't had one before, so I should have only given him half.
and then James' response is, he is doing his school, says his head hurts. He took Tylenol.
Correct.
Okay. And Jennifer's response was, is he okay to work? That's at March 19th at 11 a.m.
Correct.
And James's response,
Was yeah.
and that's
Yeah.
also, it's 11:13 a.m.
Correct.
Okay. And then Jennifer wrote 11:38 a.m. on March 19th. Does he remember what he did?
Correct.
Okay. And what was James's response?
James responds with, Dude, I am working on a demo right now. I have not talked to him, and he is doing school.
Okay. And then her response is?
Okay then, geesh.
Okay, thank you. Now, this is 96 that we just admitted. This is from March the 20th of 2021. And again, did you find text messages from the school shooter to the defendant of a concerning nature?
Correct.
Okay, in the blue, that's all the school shooter's words?
Correct.
Okay, what did he write to her?
He starts with, I finished picking up the room. That was at 2:38 on the 20th.
2:33?
2:33, I'm sorry,
Okay.
yes. He then says, I cleaned until the clothes started flying off the shelf.
And then what?
This stuff only happens when I'm home alone.
Okay, it's March 20th, 2021 at 2:34 p.m.
Correct.
And this is the same date and time?
Yes, it is.
And what did he write?
I picked the clothes back up, though.
Okay, that's March 20th at 2:34.
Correct.
And when was the next response to that?
By Jennifer was on the 22nd of March at 8:17 p.m.
Okay, so I'm going back to Exhibit 83, which is the phone log found, recovered off of the school shooter's phone, specific to these days. Okay, so we just went through March the 20th, and those messages were sent about 2:30 in the afternoon, if you recall. Is that right?
Yes, sir.
Okay, and were there any phone calls in that time period?
No, there was not.
Okay. In fact, the next call was 6:37 p.m. on March the 20th.
Correct.
No objection. Oh, sorry, you can say the numbers and also no objection.
97 and 98, Judge, I believe would be admitted.
We have no objection.
97 and 98 are admitted.
Thank you. So, sir, were you able to tell where James and Jennifer Crumbley were yet again on that day?
Yes, sir.
Okay. This is 97 and 98. 97 is the photograph, 98 the metadata. This is March 20th, 2021 at 1:51 p.m.
Correct.
Okay, and if you recall, the text messages from the school shooter were sent to his mother about 2:30 in the afternoon?
Correct.
Okay, so tell us where Jennifer and James Crumbley were at this date and time?
They're riding the horses again.
$99 and $100
No objection.
Is it 99?
and $100.
No objection to either one?
No objection to either one.
99 and 100 are admitted.
Thank you, Judge. Okay, now this was taken off of the last picture. Was taken off of James Crumbley's phone, 9798.
That's correct.
99 and 100 were taken off of Jennifer Crumbley's phone.
Correct.
Okay, so the capture time here, March 20th, 2021, 11:58 a.m.
That's correct.
Okay, so then that would indicate to you that they were at the barn at least from that period of time until at least 1:51 p.m.
Correct.
Okay. Sir, during the course of your investigation, did you come to learn that the school shooter had only one friend?
Yes.
And did you also learn that that individual was abruptly taken from the state of Michigan about a month before the shooting occurred?
Yes, he was.
And did you review the text message thread between the school shooter and that other individual?
Yes.
You've looked at the entirety of the phone of the school shooter as well as James and Jennifer Crumbley's phone, is that right?
That's correct.
If you could give us an idea, the volume of the data found in the text message thread between the school shooter and his friend.
There was over 20,000 text messages just between the two people. I've done exams on phones where the combined number of text messages isn't that much.
So what's the relative size and data between that particular text message thread and any other thread between the school shooter and anybody else?
I think the most text between any other person might have been near 500, an individual person.
Okay. I'm going to show you a portion that's been previously admitted by this court of that text message thread from April the 4th of 2021, April the 5th of 2021. That's Exhibit 101.
And the court's previously ruled on this.
All right. One one's admitted.
Thank you, Judge. So we have names redacted. 101 was found on the shooter's phone, is that correct?
That's correct.
Okay. So in this instance then, the green would be his words, the shooter's words.
Correct, yes.
Okay. Tell us what he wrote to his friend on April the 4th of 21.
The shooter wrote, like, I hear people talking to me and see someone in the distance. Okay. And then corrected the spelling of the word distance.
It's April 4th, 11:56 p.m.
Correct.
Okay.
PM.
What else?
The shooter said, I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to, quote, suck it up.
And then what?
He then says, like, it's at the point that I'm asking to go to the doctor. Then he says, my mom laughed when I told her.
So that's April 4th, 2021, 11:57 p.m. His words, my mom laughed when I told her.
That's correct.
Okay. Now, April the 5th at 12:06 a.m. So we were looking at a conversation right up until midnight on April the 4th, and now we're in the early morning hours of April the 5th. What did the shooter write?
The shooter wrote, but I'm having bad insomnia, RN, for right now, and paranoia.
And then what?
He then says, I need help.
Okay. And the next text?
I was thinking I calling 911 so I could go to the hospital.
And then there's a response from his friend on April the 5th.
Correct.
At 12:12 a.m. And then what did the shooter write?
The shooter writes, but then my parents would be really pissed.
Now, April the 5th, 2021 at 12:38 a.m. What did the shooter write?
The shooter writes, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. Then he says, but this time I'm going to tell them about the voices.
Okay. Next text.
He then says, like I am mentally and physically dying.
Okay. Before we get to Exhibit 102, in the course of your forensic examination of James's phone, Jennifer's phone, and the school shooter's phone, you're able to look at certain apps that are installed. Is that right?
That's correct.
Okay. And did you discover if an app called Life 360 was installed on Jennifer Crumbley's phone?
Yes, it was.
Okay. And what is Life 360?
Life 360, it's a tracking app that friends and family can install on their phone so they can know where they're at. I have it on my phone, and there's a family group that my kids are on it, and I'm on it, my wife.
Did you find that app on James Crumbley's phone?
Yes, it was.
And through that app, you can see where someone's at and where they've been. Is that right?
That's correct.
And you looked through the school shooter's phone as well, the defendant's son?
Correct.
Was that app installed on his phone?
No, it wasn't.
So it was just installed on James's phone and Jennifer's phone?
Correct, it was.
And that was on April the 5th of 2021?
I believe that's when it was installed, yes.
Okay. That's the same day as these text messages, like I'm mentally and physically dying and asking to go to the doctor?
Correct.
Exhibits 102 and 103?
I'm sorry, are these, this is 102 and 103? We have no objection, sorry.
102 and 103. I'm sorry, did you say that the date of the installation was April 5th? Is that what you said?
Yes, ma'am.
So on the screen here, we can see the timestamp purchase date, April 5th, 2021. That's on Jennifer Crumbley's phone, correct?
Correct, yes.
Okay. And Exhibit 103, on James Crumbley's phone, we have April the 5th, 2021 as well.
Correct.
During the course of your evaluation of all the electronic information, digital evidence available to you, did you uncover evidence in the spring of 21 of Jennifer Crumbley talking to a friend about what she saw as depression in her son?
Yes.
And were you able to review a Facebook conversation between Jennifer Crumbley and actually the school shooter's only friend's mother?
Yes.
Okay. So I want to make sure that I'm clear with you. In April of 2021, which is the same month of these text messages, Jennifer Crumbley texted her son's only friend's mother, correct?
Correct.
Okay. And in that conversation is when you uncovered concerning text messages as an investigator to this case.
Correct.
This is 104.
Thank you, and let me just take a quick look, I'm sorry. Yeah, I have no objection to this, thank you.
104 is in the middle. That's just 104, right?
Yes, thank you, Judge. Okay, this is April 29, 2021. Now, this is from Jennifer Crumbley's search warrant return, correct?
That's correct.
So she's agreeing in these.
Correct.
All right. So what does she write?
She starts with, Ethan isn't bowling tonight. Just want to let you know. Not sure if they need a partner or not.
Okay, and then her son's friend's mother, also named Jennifer, writes, is he feeling okay?
Correct.
And the defendant's response?
She responds back with, yesterday he wasn't, and he's been acting kind of depressed, so I don't know what's going on.
Okay, this conversation continue?
Yes, it does.
What does the defendant write?
The defendant says, I'm not sure if there's something bothering at school. He really doesn't feel good. I can't get anything out of him.
Okay. And the person she's communicating with writes her son's name too. He stayed home from school today. The only time he's happy is when he's with the school shooter.
Correct.
And then her son has 2 E's and 2 D's. I'm wondering if he's worried about that. That's the other individual worried about her own son?
Correct.
Okay. That's 5:24 p.m. on April the 29th?
That's correct.
The conversation continues. What does the defendant write?
The defendant says, yeah, this is all new to me. I'm not used to Ethan being moody. He's usually pretty happy, and we'll talk about anything. I do know Ethan's been stressed about school and his grades. We called the school, but she wasn't in. Social, do it tomorrow. I think his grades have a lot to do with it. He just got to a point where he got so far behind, and we were out of town. He's having a difficult time making it up.
And then the other individual writes, I'm sorry, her son's struggling too. To be honest, I'm sick of fighting with him about it. Stupid online school really messed him up. I'm thankful her son has the shooter as a friend. They laugh and have a great time together. That's April 29th at 5:31 p.m.
That's correct.
Okay. And then what does Jennifer respond?
Jennifer responds with, yeah, me too. I'm just glad they're still getting along. And it wasn't an issue with those two as to why he was being depressed. The online school is horrible. I've given up too. I just told him to do the best. Don't worry about it. Next year is a new year.
Okay, and then what's the next text?
She says maybe if, is referring to the shooter's friend, feeling better, if he wants to come over after work on Saturday, he can take him up to go bowling and make up their scores. He's more than welcome to stay the night and go to work in the morning. We set up a little shooting range in the backyard for Ethan's BB gun. They could do that.
Okay. Okay, and the response was her son's been excited to shoot.
Correct.
Okay, and that was April 29, 2021?
Yes.
Okay. Now, around this time frame in the text message conversation and the videos on the school shooter's phone, did you discover extremely disturbing information?
Yes, sir.
Okay. And I'm not asking you to go into detail, but as an investigator, it was important to you.
Yes, it was.
Okay. And in fact, it was in the days after these messages were sent?
Yes, it was.
Okay. And the school shooter shared that with his friend, his only friend he had.
That's correct.
And you mentioned that his only friend was taken out of the state?
Correct.
And it seemed to be without notice to the school shooter?
Correct.
Okay. Did you uncover evidence that either James or Jennifer Crumbley commented on the fact that his only son was taken, or his only friend was taken out of the state?
Yes.
This is Exhibit 105.
Yes, I have no objection to 105, thank you.
105 is admitted?
And you said that was around about a month before the shooting at Oxford High School?
Yes, it was.
Okay. So, this is from Jennifer Crumbley's Facebook, again to the mother of her son's only friend.
Correct.
Okay, and this is October 31st, 2021, 9 o'clock in the morning?
Yes.
Okay, and what does she write?
Jennifer writes, James filled me in on Ethan's friends last night. I'm so sorry you guys are having to make such a hard decision. Please let me know if you need anything.
Okay, and then November the 3rd, she wrote what?
She says, how are you guys all doing? Been thinking of all of you a lot.
Okay. And you know from your investigation, this is the time frame when the shooter's friend was taken out of the state?
That is correct.
Okay. In this conversation, November the 4th, that other individual writes what to Jennifer Crumbley?
She writes, hi Jen, we're doing okay. It was the hardest thing I've ever had to do. I worry about him constantly and miss him terribly. I know that he's where he needs to be to get better though. Thanks so much for checking on us. I appreciate you and your family. She's referring to her son, the shooter's friend, was only happy and relaxed with you guys.
And in response?
Jennifer responds with, please keep us updated. I know Ethan misses him. If you guys need anything at all, please don't hesitate to ask.
And that was, again, in November of 2021 before the shooting.
Correct, on the 4th, yes.
Okay. Now I'm going to direct your attention to the days around the shooting and what you were able to obtain as far as a digital footprint of the Crumbley family.
Okay.
All right. Starting November 26, 2021, is that date significant to you?
Yes, it is.
Why is that?
That was the day the gun was purchased.
Okay. And we heard yesterday that the gun as in the murder weapon?
Yes, sir.
Okay. That was a 9mm Sig Sauer handgun?
Yes, it was.
Okay. That's been admitted in evidence, and we heard it was bought from a firearms store in Oxford.
That's correct.
Okay. This is 106?
I have no objection to this.
Okay, 106 is admitted.
Okay. This is just as an example what information you can obtain from a search warrant on a Gmail account.
That's correct.
Okay. And so this is from James Crumbley's Gmail account, November 26, 2021, confirming that he was in fact at that firearms store at 12:08 p.m.
Correct.
Okay. Now, we talked about obtaining locations from somebody. This is 107.
We have no objection.
107's admitted.
Before we get into 107, Exhibit 417, it's a video. Sir, in your analysis of the shooter's phone and Jennifer Crumbley's phone, social media accounts, you were able to obtain videos taken by the school shooter with that handgun, the murder weapon?
That's correct.
Okay. So 417, people move to admit, published to the jury. It's a video taken from November 26, 2021.
And Your Honor, I'm sorry, I have to just take a look really quick, because we just jumped ahead like a couple.
Yeah, it's 417.
Yeah, let me just take a quick look, I'm sorry.
No, that's all right, there's one.
And actually, I don't have 417 in the exhibits that I was given. Can I see? It wasn't on my hard drive that I was given. Okay, Your Honor, I have no way to play this, and I don't have this.
All the
Can I
exhibits
just
are-
have?
it's a very short video.
It's not on our. I just need to see what the video is. Can we just unplug the computer and can you just show it to me really quick?
Is there audio?
No.
Was it provided to the defense?
Yes.
It's.
We're shown at the preliminary examination as well.
Your Honor, I'm sorry, it's not on the exhibits they gave me on the disc, so there's a million videos in this case, and I have no idea which one it is.
Okay.
I probably have no objection. Can I just see what video it is?
Sure. Well, I guess I thought for a moment when he said it was played at the preliminary examination, it might refresh your recollection about what it was. But if you can take a quick look, that'd be great.
I don't have a flash drive player on here, so can we just turn the screen off for 1 second and just take a quick look?
Yeah.
And I apologize.
No, it's okay. There's a lot of stuff. I don't want to release the jury because their lunch is not made. I haven't made your lunch.
Oh, yeah, sorry. Yeah, sorry.
I'm having lobster today.
Okay, and so this is 417.
417.
Okay. Can you just show me? Okay, we have no objection to this one, and I apologize.
That's all right.
Just
That's all
didn't
right.
have it.
No,
Thank you.
I get it. It's a lot of stuff. Okay, so 417 is admitted.
Okay. May I, Judge?
Sure.
Thank you. This is what you obtained from the shooter's phone, and it was captured 6:39 p.m. on November the 26th, 2021?
That's correct.
Okay. So that video was taken the evening the firearm was purchased?
Correct.
And that is in fact the murder weapon, the 6-hour 9mm?
Yes, sir.
I have no objection to those.
What number is it?
107 and 108, Judge?
107 was previously admitted, 108 is admitted.
Thank you. Okay, now, Agent Brandon testified yesterday to much about the evidence regarding the firearm, so I'm going to move you ahead to November 27th, which is the next day, the day after the 6-hour was purchased.
Okay.
All right. So, all right, 107. This is evidence obtained from James Crumbley's Gmail account, is that right?
That's correct.
Okay, so you were able to tell what James Crumbley was doing from 8 a.m. to 8:59 p.m. on November 27, 2021.
Correct.
Okay, and tell us what was he doing?
He was delivering DoorDash.
So these dots, these data points, are what? What do they signify?
Those are the GPS locations that were provided when the location services was turned on from Google.
So we know he was out of the house basically the whole day.
Correct.
Okay. Now, 108, we have Jennifer Crumbley's Gmail data points, and from what time period?
That's from 2:29 p.m. to 3:32 p.m.
Okay, and this is Exhibit 108. It shows she's out of the house from about 2:30 to 3:30. Is that right?
That's correct.
Okay, thank you. Now, the next day is Sunday, November the 28th, 2021. Could you get a feel for what Jennifer Crumbley was discussing based upon her Facebook messages, what her plan was doing on November the 28th, 2021?
Yes.
Okay. And in fact, you recovered chat history with an individual named Kira Pennick?
That's correct.
Okay. And did the course of this investigation, did you come to learn who that person was?
Yes, I did.
And who was that?
She was the owner of the horse farm.
Okay. That's the horse farm where Jennifer and James Crumbley would board their horses?
Correct.
Okay. So she's going to testify later on in this trial, but you reviewed their Facebook chat history?
Correct.
Okay. So that's 109. People who commit 109.
Your Honor, can I just have one moment? This is a...
It says it's a thread between your client and Kira Pennick on November 28th. That's what the reports to me.
Okay, and the exhibit that I received from the prosecution is 967 pages long. So I'm thinking that what I got is not...
It's pages 930 to 933. We're not going to go through 1,000 pages.
Well, no, I'm
just do it.
Okay, I'm sorry. So what pages are they admitting as
930 to 933.
Okay, 930 to... Okay, give me just a moment. I'm
Okay.
sorry. I got the whole file, like...
It's on the exhibit list.
Yeah, but the exhibit list indicates, this exhibit list is what I got on Tuesday. I'm not sure when it was shared with the defense if it was the same day or not, but it says pages 930 to 933 are the only ones they're seeking to highlight.
I know, I'm just scrolling.
Okay,
It's just taking me a little bit to scroll through. I need to use my computer. I'm sorry, I'm trying to get to 900. It just takes a little bit to load because it's such a big file. Okay, so it's pages 901 to
930 to 933.
Exactly what was written on the exhibit list.
And I'm trying to get to the pages. The file they gave me is much larger than 3 pages.
Okay. The exhibit list.
On every other exhibit, they have narrowed it down, and this one is much bigger. I just need a moment.
Okay, you're good. You're good. The exhibit list says the pages that they're.
I know, but I can't pull it up fast enough because my computer's. I'm trying to go as fast as I can.
Okay.
Okay, I have no objection to this.
Okay. Thank you.
All right.
109 is in there.
Thank you. And this is a portion of exhibit 1. Okay, so green is who?
It's Jennifer.
Okay, and what's she writing?
Was his front swollen again?
Okay, and then the response?
That is from Kira Pennick. Right, I'm the same. I'm not sure. I'm not doing chores, but I'll ask my dad when I see him.
Okay, so did you come to learn when Jennifer writes, was his foot swollen again? She's referring to one of her horses.
Correct, yes.
Okay. And Kira's response?
If Billy keeps stocking up, I think you should have the vet out for him. Just want to make sure it isn't anything serious.
And Billy's who?
The horse.
And Jennifer's response?
He's got mid-fever. James is coming out in the morning to put some stuff on him and calling vet for antibiotics. And then she corrects with mud.
Okay. Billy's one horse, and they have 2 horses at this point, right?
Correct.
Okay. And then what does Kira say?
Kira, then, that's crazy. Never seen it react like that. Want me to just put stuff on it daily? I can. I didn't do chores this weekend, so don't know if it got done.
So the last message in this exhibit from Jennifer Crumbley to the individual who boards those two horses is November 28th, 2021. That's Sunday, 8:18 p.m., Sunday night.
Correct.
And she writes, yes, let's do Tuesday. I'll have James leave the mixture out there. I don't think he's sore from the ground. He's just fine lunging. Just need to keep moisture off his scratches and get him on antibiotics. Should be clear in a week.
That's correct.
And that's, again, in reference to one of our horses.
That's correct.
Okay. Now, did Jennifer go to the barn that day?
Yes.
When you say that day, you mean the 28th?
Yes, thank you, Judge. This is 110 and 11.
No objection to those.
110 and 111 are admitted.
Thank you. 110, this is from her Gmail search warrant return. We can tell that she's at the barn at noon on November 28th.
That's correct.
Okay, and she's back at home. This is Exhibit 111 at about 2 o'clock.
Correct.
All right. Now moving on to Monday, November the 29th. That's the day before the shooting, right?
That's correct.
Okay. Now, what's the first thing that you see of importance to you as a forensic investigator from the day before the shooting that occurred on one of her devices?
It was a web history search or a web search.
Okay. This is Exhibit 113.
We have no objection. I just want to make sure, I'm sorry, 112 was admitted.
No, 112 was not omitted. That's
Yeah, 112 was not admitted. yes.
correct.
Okay, so 113, we have no objection. Thank you.
113 is admitted.
Thank you. Okay, 113. This is a snippet from a Cellbrite extraction report of Jennifer Crumbley's web history.
That's correct.
Okay. So, tell us, please, what was she researching November 29, 2021 at 3:05 in the morning?
In the second column, you can see where it says research clinical depression treatment options. It was Yahoo search that was used.
Okay.
In the third column, you can see exactly that's what was in the URL bar, the web address bar that you typed.
And that's the day before the shooting in the early morning hours?
At 3:05 a.m.
All right, now let's talk about the Facebook conversation between James and Jennifer from later that day, Monday the 29th. This is 114.
I have no objection.
114 is admitted.
Thank you. Okay. November the 29th, 2021, 8 a.m. Jennifer writes to James, "Are you at the barn?" And then about 40 minutes later, she sends a question mark. Is that right?
That's correct.
Okay. And then James responds to what?
He responds with, starting with the question mark, working on Billy.
Okay. So it appears, at least from this message thread, that he's at the barn with their horse, Billy.
That's correct.
And then he sent a picture.
That's correct.
Can you tell what that's of?
It's the horse's legs, it appears.
Okay. And what does Jennifer respond to that picture?
Do the fronts, too.
Okay, and this is 9:21 a.m. What does Jennifer say?
Jennifer asked, did you call the vet?
And then what?
Make sure you get back in between his heel bulbs.
Okay, and James's response to that?
He responds with, I did, and then fronts, too.
And that's at 9:34 a.m. on November the 29th.
That's correct.
At 9:35, what does James say?
He texts, what exactly should I tell vet? Type out for me, leaving barn now.
Okay. And then Jennifer responds, Billy looks to have scratches / mud fever. He's starting to stock up on all fours and concerned about infection. He's not lame, sensitive to the touch, and they go down when he moves. Is there an antibiotic I can get him on? We just put Desitin and antibacterial on his legs today. That's November 29th, 9:41 a.m. Is that right?
That's correct.
Okay. And then she sends a message to him?
Correct.
And what does she say?
She says, was he stocked up this morning?
And then James's response?
James responds with, he was stocked up more in the back than in the front. In fact, the front didn't really look stocked up at all, so I launched them for a few minutes before I put the stuff on it. And it took the swelling down a little bit, but I got the cream all over, in between his heel bulbs and stuff like that. I'll call the vet here in a minute.
Okay. Now, sir, it's been a little tedious going through all of the messages regarding the horses. Give us an idea, because you're the one who actually extracted that information from Facebook and reviewed it. How often will they show concern over their horses?
Quite often.
Okay. Okay, and Jennifer's response, this is the same conversation, November 29th at 9:58 a.m.?
She responds with, "It made sense, LOL."
Okay, and then James responds more about the horse, is that right?
That's correct.
Okay. And Jennifer responds to that message?
Yes, she did.
And that's at 10:15 a.m.?
Correct.
Okay. Now, this same day, same time period, did you uncover evidence that someone from Oxford High School left a message for Jennifer Crumbley?
Yes, correct.
Okay. And in fact, that was at 9:41 a.m.
That's correct.
Okay, so that was in the midst of the Facebook conversation between James and Jennifer about their horse.
Correct.
Okay. And were you able to obtain that voicemail from Jennifer Crumbley's phone records?
Yes.
Okay. People move to admit 115.
No objection, Your Honor.
1:15 is a minute.
Thank you.
Crumbley, my name's Pam Fine. I'm calling from Oxford High School, and I'm here with Mr. Hopkins, who's Ethan's counselor. I was just calling to let you know that we just spoke with Ethan, had a really nice conversation. One of the teachers texted us emails to the office. She was concerned because Ethan, when she was walking around the room, checking assignments, but he was on his phone looking at bullets and that sort of thing. So she just wanted to have a conversation. We did. He said he was at the shooting range with you this weekend, and we were like, yep, guns are a hobby for a lot of people, and shooting ranges, and that's perfectly normal. And that we just wanted to make sure, had a conversation with him about the things he searches at school, and things versus searching at home, like Mr. Hopkins gave a good example of, like, if a teacher makes beer at home, perfectly normal and healthy, but can't be using searches for making beer at school. So we had a conversation. He was great. He said, yep, I get it. So I just wanted to let you know we did have a conversation with him, and about 5 minutes, and he went back to class. All right, if you have any questions, you can give me a call. Otherwise, it will be a great holiday. Thanks. Bye-bye.
Okay, that was the day before the shooting at 9:41 a.m.
Correct.
Okay. Did Jennifer Crumbley access that voicemail?
Eventually, yes.
Okay, this is Exhibit 116.
We have no objection.
1:16 is a minute.
Thank you, Judge. And according to your analysis, she accessed the voicemail at 11:49 a.m.
That's correct.
Okay. So that's still in the midst of the conversation she was having with James about their horse.
Correct.
Did you uncover evidence that Jennifer Crumbley texted her son about that voicemail?
Yes.
Okay. This is Exhibit 117.
I have no objection.
1:17 is a minute.
Okay. Now, owner, Green, this is Jennifer because it's from her phone. Is that right?
Correct.
Okay, and in fact, you were able to take the whole text message conversation that existed between between Jennifer Crumbley and her son. Is that
Right.
And if it were to be printed out, it'd be over 200 pages or so. Is that right?
Sounds about right, yes.
Okay. So I'm going to show you portions from November 29th, and we'll refer back to this. So November 29th at 11:53 a.m., this is a few minutes after she listened to the voicemail. What did she write to her son?
She says, seriously, 2 question marks, looking at bullets in school, question mark, question mark.
And he writes back, what? And then, oh yeah?
Correct.
And then he wrote what?
I already went to the office for that. It was in first hour. All I did was look up a certain caliber at the end of class because I was curious. It was on my phone.
Okay, that's 11:53 a.m., November 29th?
11:54.
11:54, thank
Yes, sir.
you. And then what did he write?
Completely harmless. Teachers just have no privacy. They said I'm all good.
Okay. And then the next message?
The shooter continues, I understood why. They talked to me and they said, that is, I'm good.
Okay, and then he wrote, this is nothing I should get in trouble. This is nothing I should get in trouble about.
Correct.
He wrote that to the defendant at 11:55 a.m.
That's correct.
And what was her response to that?
You're not. They left me a voicemail with the hand over face emoji twice.
Okay. And then what did she say?
She then says, did you at least show them a pic of your new gun?
So she wrote at 12:14 p.m., did you at least show them a pic of your new gun?
Correct.
And his response?
No, I didn't show them the pic. My God.
And then what?
I only told them I went to the range with you on Saturday.
Okay. It was, I only told them I went to the range with you on Saturday.
Correct.
Okay. And then what did he say?
It was a harmless act.
Go ahead.
I have this bullet cartridge in my room that I didn't what kind of bullet it was, and it said it was a 22. So at the end of first hour, I just looked up different types of 22 bullets. And I guess the teachers can't get their eyes off my screen, SMH.
And then what did Jennifer respond to that?
She responds with, LOL, I'm period, not mad. You're not, you have to learn, not period, to period, get caught, period.
And his response to that?
IK, or I know, LOL.
And then?
2 laughing emojis. And then he responds with, I just didn't want something this little to get me in trouble because, well, I didn't want to get in trouble, LOL.
Okay, and then what did he write?
The shooter says, I want to hear the voicemail when I get home, though. Also, I never tried to hide me looking up the bullet. I just didn't think a teacher would be staring at my phone.
And then what did she say, the defendant?
She says, okay, I saved it.
Sir, did you find evidence that Jennifer discussed this incident with her husband, James, that day?
Yes.
This is 118.
Thank you. No objection to 118.
118 is admitted.
This is a Facebook message between James and Jennifer Crumbley?
Correct.
Okay. And then Jennifer's now in blue?
Correct, yes.
Okay, and what did she write?
She writes, Ethan, tell you what happened today.
And his response?
James' response was, yeah.
And correct me if I'm wrong, but there's no further discussion between the two of them on Facebook Messenger.
No, there's not.
Now, sir, I want to take you back to the day of the shooting, November the 30th, 2021. And what we'll do is go step by step with what you were able to discern from your available sources of information.
Okay.
All right. Exhibit 119. Well, first of all, we already talked about how you were the individual who went through all the surveillance video.
Correct.
And it was your responsibility to put together that timeline?
Correct.
Okay. And did you also put together the timeline when the school shooter was dropped off at school?
Yes.
Okay. And he was dropped off at 7:46 a.m. on November the 30th?
That's correct.
Okay. Any objection to this?
No objection.
119 is admitted.
Do you see him being dropped off?
Yes. It's him with the gray hoodie and had a black t-shirt on.
Right there?
Correct.
Okay. Judge, in looking at the time, this might be a good time to break for lunch, given the fact that we're starting to go through the evidence from the day of the shooting.
If your lunch is ready.
Yeah, well, that's a good point.
Just because this is now it's a transition.
Oh, okay. All right. Your lunch is here, so I want to let you know that because you're on the stand right now, you're not allowed to discuss your testimony with anyone until you're finished testifying, okay?
Thanks.
Oh, I'm sorry, ma'am. I apologize. I apologize. Yes, ma'am.
I didn't mean to wake you up.
No, I'm awake, ma'am. I'm sorry.
All right.
I was thinking.
We're in the middle, don't do that. We're in the middle of your testimony, so you can't discuss your testimony.
Absolutely.
with the other
Yes,
side.
ma'am.
Okay,
You can't
start
eat
now.
lunch.
Ideally lunch,
You
yes.
need lunch. All right, so you can step down. All right, so if we come back at quarter to one, that's enough time, right? So your lunch is ready and in your way, okay?
All right,
I thought you were dismissing them first, no, I'm sorry.
No, it's all right, it's all right.
All right, welcome back. We've been watching the trial for Jennifer Crumbley, listening to this second day of testimony.
Yep, we're still joined by legal experts Terry Johnson and Richard Convertino. Thanks so much for being here. So we understand a lunch break has been called. That's for about an hour. So what did we just hear now in this testimony? We were really getting into text messages. What was really laid out there by the prosecution?
Well, you remember me talking about yesterday in particular that the prosecution was going to show evidence and did show evidence regarding the Oxford High School shooting incident itself, and that they would have to create a bridge over to the defendant herself to show and impute relative knowledge or criminal negligence. And I think that's what's being done today, and it's being done expertly, I believe, through the use of the text messages, the juxtaposition of the text messages between the calls from the school, the contact that she had with the friend of the shooters, and her, what I think was particularly devastating, although it just kind of slipped in, was Exhibit 113. Exhibit 113 was the metadata on the phone of Jennifer Crumbley, the defendant in this case, regarding her searching on the internet. She did a Google search of clinical depression treatment, ostensibly for her son. The text that led up to that, including the text that in April regarding her son's acknowledgement that he saw demons in his house, that resulted in him essentially destroying his bedroom, clothes all over the floor. His reaction the next day was exhaustion, as if he were drunk and had a terrible headache. He then asked for, he told his friend in text messages that he needed help. He even considered calling 911 to get emergency help, emergency assistance for his psychological state. He recognized personally that he was in the throes of a mental illness, of a deep depression, and he said, "I'm going to tell my parents." So there's this imputed knowledge of his severe mental illness that seems to be escalating in time and place, and they've shown that and interweaved through and filled the interstitial gaps with these communications that show during the time that he was crying out for help, they're worried about their horse's foot.
Yes.
Not only in general worried about it, but on the specific date and time that there's communication from the school, that there's communication with her son about his difficulties, and then of course there's the voicemail that says that he was searching the internet for particular bullets, caliber bullets. So all of this information that they've really done a fantastic job, the prosecution, in laying this out and weaving in different and disparate pieces of evidence that in and of themselves wouldn't be particularly important. So text messages between two people regarding a horse, okay. But that juxtaposed with what was going on with the school and her son's text messages to the mother, to the defendant in this case, show that that she knew or should have known that his mental health was in such a disparate and desperate place as to keep to have a weapon in the house that he had access to. You'd be incredulous if you were told that she had no particular information or awareness regarding her son.
Terry,
I guess I'm
questioned some of
incredulous.
this.
I did not see any of those things you're talking about.
Well, were you paying attention to this evidence that was coming in?
I sure was, and what I was paying attention to was that I see a woman in Jennifer Crumbley who was concerned, as she said, to her friend, "I don't know what to do." What I also saw, and you know, we want to talk about the horse. A horse, these are pets. I don't know if you have a pet or not.
I have several pets.
Yes, pets, for the most part, other than a parrot, don't talk. They can't communicate with you. Ethan Crumbley, and I'm not calling him a pet, this young man stated, you know, or you heard Jennifer Crumbley say, he won't talk to me. What was the quote she said? I can't get him to say anything. She was trying, okay?
He told her he saw demons, and that he told her that...
Sure, I understand.
That's communication between the shooter and his defendant mother.
That's one sliver, but let's really look into this more. People want to talk about now, I'm looking at this phone call, and I finally heard it that came on the day before. And what was said? Happy holidays. It wasn't, oh my God, your son's doing this, your son's doing that. It was happy holidays. In addition to that, there's no reason to call us back. What did she do? She immediately communicated through text messages. She immediately communicated with her son. And when that went on, one of the interesting things is, as you look at that, what's going on? He never once said, oh my God, I'm seeing demons again. Oh my God, these things are going on. You want to talk about a depression that happened months ago. People, that doesn't mean he was depressed on that day. We're talking teenagers. Any of us who have teenagers know they go through highs and lows. I've gone through depression. I will gladly say I've gone through it. But to connect all of this to say this happened back in April, they're more worried about the horse than the kid. No, to me, this is a stretch. I believe if the defense were to come up and ask a few key questions here, you know, again, going back to previous conversations we had about a firearm in the house, what you're saying is they should have known this back then and they did nothing. But we don't know that he was depressed on the day of, the hour before. There is no indication of that. All we know is he was looking up a bullet, and you saw his explanation of it. He never said, I am going to look up a bullet, a .22, and by the way, has nothing to do with a 9mm, two different calibers. But looking up a bullet all of a sudden makes him a school threat that the parents didn't do anything. I think this has hurt the prosecution at this point. And I think they've given the defense an opportunity to make hay. One man's opinion.
They did call a break before they're introducing new evidence. They felt like it was a good natural breaking point. We are also going to take a break. Thank you so much for both of your insight throughout the morning. And do stay tuned for more coverage of the Jennifer Crumbley trial here on CBS News Detroit.
With hope.
Haiti is on the brink of transformation, a radical shift. Haitians are coming together and saying things must change.
Fighting for Haiti, now streaming on the free CBS News app.
Since childhood, she never stopped reaching for the skies. Now she's spent more time in space than any other American.
I like being a part of something bigger than me.
Peggy Whitson's extraordinary career as a history-making astronaut when we go person to person.
An original documentary from CBS reports.
I always tell people that Twitter would not be Twitter without Black Twitter. It's just us being in fellowship with each other.
And there becomes a conversation you don't want to be left out of.
People really started to recognize the power of activism on Twitter.
Based on that one tweet, the hashtag #OscarSoWhite was trending around the world.
If anything has really powered Black Twitter, it's been humor.
If your food ain't right, oh, we're going to tell you about that too.
We tend to create change, create culture and cool.
That's how movements happen on Black Twitter and go beyond more than that.
Black Twitter, the Twitterverse that changed a generation. Now streaming on the free CBS News app.
Our story's just begun.
Why did you want to share your story?
Water up this high?
Where are these coming from?
That's the million-dollar question.
I'm a very curious person. I wake up every morning asking, what's happening in the world? Why is this happening? And how do we answer that question on the CBS Evening News?
King Charles III was admitted to a London hospital today for a scheduled corrective procedure on his prostate.
He's being treated at the same hospital where the Princess of Wales, Kate, is recovering from abdominal surgery. Joining us for more on this is BBC News correspondent Charlotte Gallagher in London. Charlotte, thanks for joining us. So what is the royal family so far saying about the procedure?
Well, we heard this morning from Buckingham Palace. King Charles was taken from his home at Clarence House, which is just steps away from Buckingham Palace. He was driven to the hospital behind me for a scheduled procedure. They're calling it a corrective procedure on an enlarged prostate. Now, it's really unusual, actually, for the King or any member of the royal family to be so open about their health. Often when they're admitted to hospital, we don't really know the details. But this time, the King decided to say what was wrong with him in the hope that it would encourage other men right around the world to get their prostates checked. And he said, actually, before going into hospital, he was really pleased that he had managed to raise a public health awareness about getting prostates checked. So the procedure today is called corrective procedure, as I said, and it's a fairly straightforward procedure. It will be taking place on millions of men right across the world will have those kind of procedures. Usually it takes around 3 days to recover in hospital, so the King could well spend the weekend in hospital, but it's very different for each patient. Now, as you mentioned, the Princess of Wales is also in the same hospital, very unusual situation, and the King actually visited his daughter-in-law before he went in for his own procedure. And we've seen as well Prince William has been to visit his wife, and surely she'll be speaking to her children. And the King as well, he arrived into the hospital today with the Queen. Queen Camilla accompanied her husband when he went in for his procedure this morning.
Do we have an update at all on how the Princess of Wales is doing?
We have no update. What we'll probably hear is when she leaves hospital, and of course you can probably imagine there's lots of photographers, lots of camera crews around her at the moment, that we'll get perhaps footage of her leaving in a car, probably from the back entrance, which is behind the hospital. But what they'll usually say is they'll release a statement when she's home, that she's back home, she's with her family. But we really don't expect her to be back to public duties until Easter, really. She's going to be in the hospital for around 10 to 14 days, and then she's going to be recuperating at home, surrounded by her family, and then probably back in the public eye by Easter. So a much longer recuperation period for the princess as opposed to the King.
All right. Charlotte Gallagher, thank you so much. That'll do it here for now. Our colleague Lana Zach takes over after a short break.
She's covering all the day's top stories, plus the push for a shorter work week and a look at the NFL's Conference Championship games. Keep it right here. You're streaming CBS News.
The grief of losing a child is immense. You can't breathe.
After decades of the war on drugs, things have only gotten worse.
Every shipment of fentanyl is a ticking time bomb.
50 times more powerful than heroin.
CBS Reports goes deep into Mexico.
What is your role in the Sinaloa cartel?
To find out why the cartels keep getting stronger and wealthier.
This is a war, but we're not fighting it. Our citizens are dying.
Funding Cartels, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education.
Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides, Monday through Thursday at 5 p.m. Eastern.
This is CBS.
The justices ruled that Harvard and the University of North Carolina violated the Constitution.
In the aftermath of the Supreme Court decision to end affirmative action in college admissions, uncertainty sets in for some students of color.
Affirmative action really gave us an equal opportunity.
CBS Reports explores the historic decision and what it means for those chasing an opportunity to change their lives.
I knew that college was the ticket to break this cycle.
The end of affirmative action, now streaming on the free CBS News app.
When weather turns extreme.
The threat of severe storms and dangerous tornadoes is expected to last
the 7th straight day of terrifying weather.
CBS News and the Weather Channel bring you virtual weather technology so advanced, so real.
Now 6 feet of water, imagine that. Cars that can act like battering rams.
These hyper-realistic simulations show you what the weather will look and feel like before it happens.
Feel the forecast, streaming on CBS News.
The film we'd set out to make was a story of a comedy superstar turned president.
There's currently a major Russian buildup.
The war in Ukraine has begun.
We are looking at people who want to live in our country.
Everything that happens here is going to affect every other place in the world.
When stakes are so high, we will keep fighting.
While Tate's body was laying there, you see the shooter with the gun still level fires another round, and it causes Tate's body to jerk. I don't know if you hit him in the hip or the backside or whatever. Tate's body jerks.
It's day 2 of the Jennifer Crumbley trial. The mother of the Oxford High School shooter. This case will determine if a parent should be held responsible for their child's fatal actions.
Good afternoon, and thank you so much for joining us here on CBS News Detroit. I'm Terrence Friday.
And I'm Meredith Bruckner. Today, we're continuing our gavel-to-gavel coverage of the trial. Court is currently in break now. We'll head back to the courtroom once they restart. But for now, let's bring in next weather meteorologist Kylie Miller. Good morning to you, Kylie. It was quite a wet morning out there. How's it looking now?
Yes, so we have drier conditions now. The good news is the rain has moved out of here, but we are still going to be watching out for areas that drizzle and a little bit more rain later on today. Right now, we are holding on to cloudy skies all across the region, so don't expect to see the sunshine for today. As you can see off towards our west, more rain is expected, and that rain is going to continue to roll through the region closer to about dinner time. Now, we do have some flood alerts to talk about. We have some flood warnings in place for a few rivers, creeks, and streams. The first one I want to point out is River Raisin in Monroe County, the Clinton River, that's in Macomb County, Wayne County, Ecorse Creek, and then we do have flood advisories for St. Clair County and portions of southern Sanilac County. So with that said, if you live in a flood-prone area, you might want to grab stuff up off of your floor, especially if you have a basement. Now, visibility numbers have been low, but they are doing much better. As we go through this afternoon, you can expect temperatures to be climbing once again in the low 40s for most of us. It's going to be a cloudy day, but again, more rain showers are going to be building on in. So for the big game coming up, if you're doing any of that Lions gear shopping, today is going to be okay to do so, but we're going to see a little bit more in terms of wet weather roll in for the weekend. We'll talk about that coming up.
All right, thank you, Kylie. We'll check back in.
We're objecting to the texts that include buying beer, being drunk on a horse. They are irrelevant. They are also irrelevant to someone being a hypervigilant parent. I would consider myself a hypervigilant parent, and I have some cocktails once in a while. That issue is not relevant. The alcohol is not relevant. It's just an unnecessary part of this text to make them look like they're out drinking when the whole point is that they're out with their horses and not with their son.
This moment coming from day 2 of the Jennifer Crumbley trial. The judge goes on to say that the issue is not that they're drinking while not being home with their son.
But the question is whether or not they were ignoring their son's messages when he said he was left home alone and paranoid. Let's bring in our team of legal analysts now for their expert opinions. We're joined today by Terry Johnson and Richard Convertino. Thank you so much, both of you, for being here.
Thank you.
Before we came into the show, we've been streaming this all morning. We just had this really interesting conversation, how you both had very different takes on the text messages that were presented, how they were presented, and how this looks for the defense. Let's start with you, Richard.
Well, one of the themes of the defense attorney in this case, there are a number, I think, but two come to mind right away. One is that the prosecution is taking slivers, I think was the phrase that the defense attorney used, out of context, storming them together, and then using that as circumstantial evidence of intent or knowledge. And that's exactly what my esteemed colleague Terry believes that they did. I categorically have an opposing position in that, in my opinion, having listened carefully to the testimony this morning, including the physical evidence that was admitted into evidence, I think that they've shown in an expert manner, a seriatim fashion, and interwove the text messages, the phone conversations, the photographs, and the metadata to show that, that these parents were simply unconcerned, but had knowledge and awareness of the deep mental illness that their son was in the throes of.
And Terry, you say that this is a bit of a reach to push this message.
This is a stretch. This is unbelievable that there are things, again, in order to prove what the prosecution needs to prove, they have to show that the parents had certain knowledge that certain things would happen. They can't prove that. They take you to a point and they say, all right, so now you're here, so that means the next step is this. They take you here, then they kind of leave you in an abyss. Give you an example. They played the phone call from the school, and I'm like, okay, I want to hear what the school said. They ended it with happy holidays. There's no reason to call back. We just wanted to let you know your kid looked up something on the internet, a bullet. At no point, and now the prosecution wants a stretch, again, to say, well, because she knew about that, that means, you know, that this happened, what happened the next day, she should have stopped it. She talked to her son about that.
But what about her language? Don't get caught. I mean,
Don't get caught. Okay, don't get caught what? Let's keep that in context. If you're texting, don't get caught. That's what that said. Not don't get caught looking at bullets. If you're on the internet, okay, fine. She didn't say.
That's a stretch right there.
That's a stretch. No,
How about don't get caught? How about don't use your cell phone when you're in class? How about what the heck what are you looking at bullets for?
So you're asserting that as a parent. As a parent, and that now you're saying because she made that choice of words as a parent, she's therefore guilty of involuntary manslaughter.
I'm saying
that's the stretch everyone's making.
Well, I'm not making a stretch. What I'm saying is you take the evidence as it came in today.
Yes.
Couple with what came in yesterday, and in a circumstantial manner, but holistically.
Circumstantial. Go ahead.
The circumstantial evidence, as you know, is just as good as direct evidence. There's
not just as good. It can be used, but it's not just as good as direct. Direct is better if she stood up and said, I had knowledge of this and I knew what he was going to do. That's direct evidence.
Well, the jury's instructed under the law, in the state of Michigan and in federal law, that circumstantial evidence is just as good as direct evidence.
It doesn't say just as good. It says you can use circumstantial evidence.
It says just as good. It said
we'll pull it up at the break.
They're to be judged equally. Circumstantial evidence
to be judged equally
as direct evidence.
I'll wait to see that.
Okay. Well, you can. But what I'm saying is taking the evidence as it was presented today in a manner that not in slivers as you're doing, as the defense wants to do. Not in slivers and taken out of context, but as a whole, the circumstances as a whole show what the prosecution said, a digital footprint of the manner and means of the communication between the parents and the son, what was going on in his world, and what was being made aware to both parents.
On that day, she knew that he was going to go to school and he was going to shoot up that school.
Of course not.
Okay.
That's not the rule. That's not the law.
All right, we do need to wrap here. We have to toss to a quick break. We like a spirited debate. We will continue this conversation coming up after the break.
And our Andres Gutierrez will be live outside of the courthouse on the other side of the break. Stay with us. You're watching CBS News Detroit at noon. Welcome back. Day 2 of the trial for Jennifer Crumbley. We continue our coverage. Andres Gutierrez is actually live now outside of the courthouse where everything has been playing out today.
Andres, what can you tell us from there?
Yeah, Meredith. So yesterday, a lot of the questioning focused around gun storage, the shooter's experience with weapons, how he handled his guns. Today, the theme of the questioning is parental responsibility. The prosecutor, right before break, essentially his line of questioning almost seemed to indicate that the parents cared more about their horse, Billy, than they did about their son. We have been hearing from a computer analyst, the one who did the forensic pull of the 7 phones that they collected from the shooter and his parents, and they've been zeroing in on this period in early spring of 2021, months before the shooting, where essentially there was a period where the mom is spending so much time out at this farm with the dad, and essentially they've been the son says that he sees demons, that he's been reaching out to them. His text messages go unanswered. At some point, the mom acknowledges that he may need some help, but never actually follows through. Meanwhile, the horse is having some issues with his legs, and she wants to make sure that he's taken to the vet, given some antibiotics. So the son has nowhere to turn to, and has a lot, and so essentially is turning to his friend, his best friend. There's over 2,000 pages of text messages between him and his friend. The analyst saying that pretty voluminous context between the two of them, and here's some of those text messages between the friend and the shooter.
The shooter wrote, like, I hear people talking to me and see someone in the distance, and then corrected the spelling of the word distance.
It's April 4th, 11:56 p.m.
Correct.
Okay.
Yeah.
What else?
The shooter said, I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to, quote, suck it up.
And then what?
He then says, like, it's at the point that I'm asking to go to the doctor. Then he says, my mom laughed when I told her. Shooter wrote, but I'm having bad insomnia, RN, for right now, and paranoia.
And then what?
He then says, I need help.
Okay. And the next text?
I was thinking I calling 911 so I could go to the hospital.
And then there's a response from his friend on April 5th.
Correct.
At 12 a.m. And then what did the shooter write?
The shooter writes, but then my parents would be really pissed. The shooter writes, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. Then he says, but this time I'm going to tell them about the voices.
Okay. Next text.
He then says, like I am mentally and physically dying.
Now, when court resumes, we are expected to hear more from that analyst and that back and forth. We're being told that they're going to focus on the day of the shooting and the days that followed, and so we're going to learn more about what the exchanges were between the parents and the shooter during that time. And so court will resume here at 1 o'clock this afternoon. Reporting live in Pontiac, Andres Gutierrez, CBS News Detroit.
All right, and once it resumes, we will have that coverage for you here live. Andres, thank you. We're going to go now to next weather meteorologist Kylie Miller for an extended look at your forecast.
So overall, once again, it is a cloudy day, and we are still going to be seeing a few rain showers passing through. However, the bulk of the activity happened early this morning. We picked up anywhere from about an inch to an inch and a half nearly of rainfall. So when you're talking about totals up to this high, plus the melting snowpack, we are going to be dealing with flooding, and that's currently what we are dealing and battling as we still go through the rest of today. So a few rivers, creeks, and streams are overrising, overflowing their banks, and a few of those are labeled here. So that is for the River Raisin, the Clinton River, as well as Ecorse Creek. Now, these highlighted boxes, those are flood advisories for St. Clair County as well as portions of Sanilac County, the northern fringes, or the southern fringes, I should say, of Sanilac County. So with that said, we're going to be monitoring more flood potential. If you have anything in the basement and you're in a flood-prone area, you might want to actually elevate that so it doesn't get damaged in case your basement does become a little bit leaky. So as you can see, we do have dry conditions right now, but turning on the satellite, we're going to be in for more cloud cover for today. We're actually seeing a few little breaks happening right along the I-69 corridor, but off towards our west, This next cluster of rain is going to be filtering in our direction. So as we head into dinner time and onward, still expect a few sporadic rain showers, nothing too problematic. We're going to dry out for tonight, but for tonight, temperatures are going to be falling into the low 30s. Any standing water will have a chance to freeze over, especially across our northern zones. And then we're not going to be done with the rain or the snow quite yet. It's going to be very active still for the for the next few days, I should say. We are going to be seeing quite a bit of this wet weather rolling through overnight Saturday and into our Sunday morning. By Sunday, late morning, I think we should be done with this system. So for anyone who might be going to Ford Field, doing some tailgating, our weather will be cooperating, at least here locally. We're going to be holding out of cloudy sky conditions. But let's talk about the game that's going to be happening in California, Santa Clara. If you're going to be heading out that way, they're going to see gorgeous sunshine with temperatures in the 60s. For us here, though, on game day, temperatures going to be in the upper 30s. We are going to be monitoring a few of those morning rain and snow showers. And then by next week, temperatures are still going to be above where we should be for this time of year, which happens to be in the low 30s. Upper 30s are expected for Monday, Tuesday, and Wednesday, low 40s by Thursday. But finally, we're going to be seeing some sunshine Wednesday and Thursday. So you guys, I think that's going to be well-deserved because it's just going to be boosting everybody's moods.
Oh, yeah. I'd say we've earned it.
That's right. I agree. Thank you so much, Kylie. All right, we're also tracking flooding in Northfield Township after an overnight water main break. Just take a look at this damage we're seeing. Lee was saying it was a 24-inch water transmission main. Field service crews have been dispatched to isolate the break and determine the next steps needed to repair the main. At this time, there's no boil water advisory, but if you live in this area, you are asked to restrict your water usage.
The Great Lakes Water Authority releasing this map of the area impacted. Lewa says that it was discovered on Baseline Road, also known as 8 Mile, between Novi Street and Oakland Avenue. We'll continue to follow this story for you for more information as well as it becomes available. And the city of Monroe is now under flood watch. The city says it's coming from the River Raisin, with the water rising slightly at 9.5 feet. And homes in that area will be impacted. The city says they will continue to monitor those water levels for you. And we've also got a traffic alert to tell you about in Oakland County happening this weekend. Pontiac Lake Road is expected to close tomorrow between Highland Road on M59 and Fisk Road. The road commissioner for the Oakland County area says that this closure is necessary to mobilize a crane for the removal of a large tree.
And Kelly Road is closed until further notice. Macomb County Police reporting Kelly Road between 14 Mile Road and Groesbeck Highway is closed due to flooding. We'll be right back.
CBS News Detroit.
Anytime, anywhere. With breaking Southeast Michigan news.
And next weather updates.
Just open the free CBS News app, select Live, then look for CBS News Detroit. Discover the difference on your block around the clock. Welcome back. Looking across the country, a first of its kind execution in Alabama last night.
Convicted killer Kenneth Smith was put to death using nitrogen gas, a method that had never been used in an execution or had been tested.
Some of the witnesses say that his death was inhumane. Lilia Luciano reports.
Our son was crying after having just watched his father take his last gasp for air.
Deanna Smith broke down in tears as she described watching the execution of her husband, Kenneth Eugene Smith. The 58-year-old was pronounced dead at 8:25 p.m. Thursday, 22 minutes after he started breathing in nitrogen gas through a face mask, depriving him of oxygen.
He began shaking and writhing, but he was tied very tightly down.
Lauren Layton, with her CBS News affiliate in Huntsville, Alabama, was one of 5 reporters who witnessed the execution. They say Smith appeared conscious for several minutes. Then, for at least 2 minutes, he appeared to shake and writhe in the gurney, at times pulling against the restraints. Following that, they say his breath slowed until it was no longer perceptible.
He struggled against his restraints a little bit, but there's some involuntary movement and some agonal breathing, so that was all expected. So nothing was out of the ordinary.
We didn't see somebody go unconscious in 30 seconds. What we saw was minutes of someone struggling for their life.
Reverend Jeff Hood was in the execution chamber with Smith. He says Smith was not unconscious in seconds like the state predicted.
We saw minutes of someone heaving back and forth. We saw spit. We saw all sorts of stuff from his mouth develop on the mask.
Smith was sentenced to death for his role in the 1988 murder for hire of Elizabeth Dorleen Sennett. The state tried to execute him through lethal injection in 2022, but repeatedly failed to find a vein. His lawyers tried to stop Thursday's execution, calling it cruel and unusual punishment, but the Supreme Court rejected their last-ditch effort.
Nothing happened here today is going to bring Mom back. We're not going to be jumping around, hooping and hollering, but we're glad this day is over.
Alabama's governor said, quote, the execution was lawfully carried out by nitrogen hypoxia, the method previously requested by Mr. Smith as an alternative to the lethal injection. Mr. Smith got what he asked for, and this case can finally be put to rest. Lilia Luciano, CBS News, New York.
All right, our newscast continues after this break.
Watch CBS News Detroit
with breaking Southeast Michigan news and next weather updates.
Free
24/7.
Just open the free CBS News app, select live, then look for CBS News Detroit. On your block, around the clock.
if you're a fan of Sarah Jessica Parker, this story may be for you, or SJP.
SJP, the iconic white skirt worn by SJP in the opening credits of Sex and the City, just sold at auction for $52,000. Now, before the HBO series 1998 premiere, the costume designer for the show found the skirt at a shop for just $5. At auction, it was only estimated to fetch between $8,000 and $12,000. No word on who had the winning $52,000 bid.
The same auction also featured items worn by Whitney Houston, Kim Kardashian, and Paris Hilton. That's hot.
Yeah. Wow.
Isn't that her thing to say?
I was for a second. I was like, did Paris really say that? But then I got it. Paris Hilton. Let's connect
Come on,
it.
work with me here.
Right.
Is it going to be hot with the forecast?
I was going to say, I wish this forecast was hot. It
No.
is not hot by any means, but is going to be hot, in at least my opinion, in California. So for those who are going to be going there for the game, it is going to be nice. But for around here, if you're going to be staying closer to Ford Field, we are going to be seeing more cloud cover and a little bit of a wintry mix too. So there you have it.
All right, thank you, Kylie.
right,
In
thank
half an hour, we will continue our gavel-to-gavel coverage of the Jennifer Crumbley trial.
We'll see you then.
Stone Bison Revival, now streaming on the free CBS News app.
Welcome back to CBS News. I'm Lana Zach. Here's a quick recap of some of the top stories we're following. The UN's International Court of Justice is allowing South Africa's case accusing Israel of genocide in Gaza to continue. However, the court stopped short of ordering an immediate ceasefire in the war against Hamas. Instead, it ordered Israel to protect Palestinians in war-torn territory. Israeli Prime Minister Benjamin Netanyahu called the genocide allegations outrageous and says Israel will not stop until Hamas is eliminated. Former President Donald Trump temporarily walked out of court during closing arguments today in the defamation case involving writer E. Jean Carroll. The jury is expected to get the case this afternoon. And Alaska Airlines says the first of its Boeing 737 MAX 9 planes will resume flying today. The entire fleet was grounded and inspected after a door plug flew off of a flight mid-air earlier this month. United Airlines, the only other carrier to use the MAX 9s, says it will bring back the planes beginning on Sunday. Well, Alabama is now the first state to use nitrogen gas as a form of execution. We want to warn you that some of the details of this story could be disturbing. Convicted killer Kenneth Smith was put to death last night using this new method, but his execution is renewing debate over whether the method is humane. Despite the controversy, the state's attorney general says more death row inmates are now choosing this method.
As of last night, nitrogen epoxy as a means of execution is no longer an untested method. It is a proven one. And it's the method that Kenny Smith ultimately chose, along with now 43 other death row inmates in our state.
Our Lilia Luciano has been following this story. She joins us here in Studio 57. Lilia, what happened during the execution last night, and what did critics tell you about what they witnessed?
So, Lana, part of the concern over this method is, as you heard, it's historic because it had never been used. Some of the people who are in favor of using the method say that, look, it has been used in Europe in assisted suicide cases. But the problem is that Alabama had not only never tested it, it's never been tested in the U.S., but that it was only approved, that the state only presented a protocol for using it in August, so just 5 months ago, even though this person had been in death row for more than 35 years. So what happened last night and what everybody was paying attention to is how would it roll out? Would the state had basically promised that it would only take a few seconds for the person to go out of consciousness and that it would be pain-free. Would that happen? Well, I spoke with one of the reporters who was among 5 media witnesses who saw everything that happened. She said, look, he was flinching, he was contorting for several minutes, that it was a pretty gruesome thing to see, at least for her. He was tied in a gurney, and that he clearly did not lose consciousness within seconds. What we had heard from the state was that it could take between 5 and 15 minutes for him to die. The curtains opened for the witnesses to see at 7:53. They closed by 8:15, and he was declared dead by 8:25. The spiritual advisor who was there also in the room also said, look, this was not a pain-free or a loss of consciousness immediately kind of reaction from him. So there's still a great deal of concern. The international community had said, the United Nations had said, look, this might constitute cruel and unusual punishment, but the state stands by that this is, as you heard.
Yeah, they're calling it now a proven method, and death penalty already controversial. Yeah. Methods now become controversial as well. So, Lily, I have to say I was surprised to hear that inmates are choosing this. What's that about?
Well, perhaps it has to do with the fact that it has been used in other cases. In this case in particular, what happened with Kenneth Smith was that they tried to use the lethal injection over a year ago, November of 2022. They prodded him, they poked him, they tried over and over, and they couldn't find a vein. So they had to stop before the expiration of the application of the death penalty expired at midnight that night. And so, in part, it was part of the arguments from his attorney was this is cruel and unusual because that already happened. He was already traumatized by that experience. The concern also was that maybe he could choke, he could vomit into the mask or something like that could happen, and that could be cruel and unusual and exert an unnecessary amount of pain. But in his case, I think his legal team, just from what I've read and tried to understand, and he himself did not expect that the state of Alabama so quickly would put forward a protocol. But perhaps the reason why people want it is because it has been used in other places. At least people were told that he was going to go unconscious and die, but it seems like it was pretty horrible. Yeah.
All right, Lilia, thank you. Connecticut officials are looking for the cause of yesterday's church collapse. New video shows the moment that the historic First Congregational Church came down. The building dates back to the mid-1800s. Officials say one woman was in the building but is safe. No other injuries have been reported. One witness said the collapse came out of nowhere.
When I first looked up, the church was fine. I heard this loud noise, and then I just saw the whole church just collapse and fall apart. I moved my car away, jumped out, and just started making sure there was nobody around that area.
Some Connecticut college students living in nearby dorms also had to evacuate. Crews plan to demolish the church site once they finish cleanup. The road to Super Bowl 58 has one final stop. The NFL's conference championship games are on Sunday in the NFC. The San Francisco 49ers will host the Detroit Lions. The Niners eked out a win over the Green Bay Packers Saturday night. The Lions are seeking their first Super Bowl appearance in franchise history. And in the AFC, the defending champion Chiefs are seeking their fourth Super Bowl appearance in the last 5 seasons. They're going to head over to Baltimore, where they're going to face MVP favorite Lamar Jackson and the Ravens. Joining us now is four-time Super Bowl champion, a legend, the kicker, Adam Vinatieri. Adam, so good to have you with us, especially as we're talking about what is ahead. Let's start over in the AFC. Chiefs, Ravens. They're playing this Sunday at 3 p.m. Eastern on CBS. The Chiefs were really inconsistent this season, but they've returned to championship form in just the last few weeks. So how do you see them in this matchup against the Ravens?
I agree. It's going to be an amazing game. The Chiefs started off a little bit slow for their standards, but they're really hitting on all cylinders. You always want to be playing your best football at the end of the season, and I think that that's what they're doing at this point. It's interesting because on paper, you look at the Baltimore Ravens and you just go, man, their offense, defense, and special teams, there's really no holes in it, and you always think, defense wins championships or whatever. I just think Baltimore's such a complete team, but then you have the X factor, right? Kansas City has the experience. They've been in this situation. They've been in this game quite a few times over the past handful of years. So how big of a role does that play, So I think, Lamar, with having the year that he's had, this is the step that he has to take to prove that he's the MVP. You knock down the Kansas City Chiefs this weekend, and I think it's done.
Well, Adam, when you're talking about experience, we got to talk about this next game because the 49ers were in the conference championship last year. They have that experience, but the Lions have really been building up a lot of momentum heading into this game. Who do you see ahead? And I got to say, there's some big Lion fans here in this studio.
Well, absolutely. And, I don't have any skin in the game, but I catch myself cheering for the Lions at this point, too. It's been several decades since they've played in one of these type of games. And I think unless you're from the Bay Area or a diehard San Francisco fan, I think the whole country is rooting for that underdog situation. And Coach Campbell has got these guys playing and believing in themselves all season long. So, I think San Francisco, again, has that explosive offense. I don't know if Debo's going to be back or their situation, but I just want to say, I think the whole world's cheering for Detroit at this point, and I would love to see. I would love to see what happens. It's going to be a great game. I'm going to be on pins and needles watching that.
It's definitely going to be a great game, no matter who you're rooting for, 49ers or Lions. Adam, you have actually had multiple game-winning kicks in the Super Bowl, and in light of last week's big miss by Buffalo, I'm wondering if you have some insight into how you approach that added pressure of the playoff versus the regular season.
Well, obviously, once you get to the playoffs, the intensity goes up several notches. It's win or go home. And at that point, a lot of these games, because you've got really good football teams, they come down to and it's not even the point. It's the points, obviously, at the end of the game. But the momentum swing from making or missing a kick early in the game makes a big difference in the outcome as well. So for me, it was always about, hey, listen, believe and trust in yourself. Stay in your own little 3-by-3 foot box. You can't control what's happening around you. Let your guys up front protect and snap and hold. You just got to focus in on your job, and hopefully, if you get to the point, trust the process, right? Just do everything like you've always done. Block out all the noise, and then from there, you kick it and hope it's going down the middle.
Win or go home. I feel like I need to wake up to that emblazoned across from me every morning. Adam, so good to have you. Thanks.
Thanks for having me on. I appreciate it.
And as we mentioned, you can watch the Chiefs and the Ravens face off in the AFC Championship game Sunday at 3 p.m. Eastern. You can also watch the Super Bowl on February 11th, airing on CBS and streaming on Paramount+. Well, still ahead, 2023 was a record-setting year for green jobs. We're going to discuss the growing demand in the field and why some U.S. workers may have trouble adapting. You're streaming CBS News.
Original documentary from CBS reports tensions rising between a powerful country and a vital island.
The supply of this technology came grinding to a halt. The world would grind to a halt.
Absolutely. As Taiwan faces threats and aggression,
Taiwan is on the front line, and we understand our responsibility as a democracy. We cannot fall.
CBS News examines whether they can defend themselves.
Putin, Ukraine, China, Taiwan, they are manifestations of the battle between autocracy and democracy. And that is a fight that we're all engaged in.
Defending Taiwan, now streaming on the free CBS News app.
We love music as much as you do. CBS Mornings.
Your morning routine just got better.
I love that.
CBS Mornings.
Okay, so let's just start at the beginning.
Well, let me start with this. What is at stake here?
What is the answer then?
Do you know why?
You want me to just keep going?
Is that a good thing or a bad thing?
Were there death threats?
How is this possible?
What's wrong with that argument?
Are you saying they lied?
Have you told the government that?
Why won't you say the word crisis?
You're not answering my question.
This really
Is that scary?
Does that make sense?
What do you mean?
What does that mean? Did any of that make sense? What's your response?
What happened?
Why?
It's time for the CBS News Original 60 Minutes, Sunday on CBS and streaming on Paramount+.
Hello, everyone, and welcome to our Dragon capsule here in space.
Sightseers in space, the thrill of a lifetime.
Seeing the Earth from space, it was so exhilarating.
But the risks that come with the territory.
There have been 4 fatal accidents. That's a 1% fatal accident rate.
Might make you look before you launch.
If you had 1 out of 100 airplanes falling out of the sky, we'd have a public crisis.
Space tourism, now streaming on the free CBS News app.
Morning news matters because it sets the tone for your day, and it's a way of getting you started.
We take you places, teach you new things, and we make you feel like, you know, it's not all bad. We're going to uplift you.
People say to me, you always seem to be having a good time. I mean, you know what? You're right.
Your morning routine just got better. CBS Mornings.
When weather turns extreme.
A massive storm with winds of 150 miles per hour. The storm strengthened again overnight.
CBS News and the Weather Channel bringing virtual weather technology so advanced, so real, you'll have time to get prepared. Feel the forecast. Weather when it matters most on CBS News.
I wake up every morning asking what's happening in the world, why is this happening, and how do we answer that question? After the tragic loss of beloved newsman Tim Russert, his son went on a worldwide journey to find himself.
I struggled with his grief for a long time.
How Luke Russert is honoring the legacy of his father when we go person to person.
The latest personal consumption expenditures report shows cooling annual inflation. Prices rose 2.6% year over year in December. That's down from November. Prices ticked up slightly on a monthly basis. They rose 2%. Core PCE, which excludes food and energy prices, rose 2.9% annually. This is the Federal Reserve's preferred method for measuring inflation. It is the first time, though, that it has fallen below 3% since March of 2021. A new report from LinkedIn shows growing demand for eco-friendly jobs. Job listings requiring at least one so-called green skill rose roughly 15% last year. But the demand is outpacing the supply of qualified workers. Joining us now from Dublin, Ireland is Sue Duke. She is a vice president and head of global public policy for LinkedIn. Sue, good to have you. So this report names energy production and transportation as important green industries. That makes sense. But also finance. What's the role of the financial industry?
If we're going to get to net zero, we need a whole of economy transformation. And that means finance will be one of the most critical sectors in powering this transition. We need enormous investments in innovation, in infrastructure, and we're also going to need new financial models and mechanisms to mitigate some of the most adverse impacts of climate change. And today, the finance sector is really in catch-up mode. Just 1 in every 15 workers in finance has a green skill. And so we need workers in that sector now and workers coming into that sector in the future, acquiring these skills and applying these skills so that we can power and finance this transition.
As I mentioned, the U.S. is lagging behind some European countries with qualified workers, but this is particularly true of the auto industry. Talk to us about this discrepancy.
The policy incentives for the transition of auto have been in Europe for longer. And so that's why you see countries like Germany and Sweden having a higher percentage of auto workers with EV skills. But that said, the US is catching up very, very quickly. We have started to see these policy incentives and these investments coming through very, very quickly. We're seeing US auto workers acquire these skills at record rates. And we see particular strength in states like Tennessee, Texas, and North Carolina, where we see workers, they see this opportunity, and they're starting to take advantage of it by acquiring these new green skills.
Get ahead of it. I want to ask you about a very interesting thing I see here. There's another study that found more men than women have green skills, and that there is actually a growing gap on that. Why is that?
That's right. Our own report and our own data shows that for every 2 men considered green talent on LinkedIn's platform, we have only 1 woman. And that means that we really need, again, to start investing in upskilling and reskilling men as well as women, because, of course, as we've seen in our data, these jobs are very resilient. These are the jobs of the future, and we need to ensure both men and women are in a spot where they can take advantage of this transition. In part, it's driven by the fact that a lot of these jobs we see workers coming from a STEM background, because a lot of these jobs are anchored in the fundamentals of maths and science and engineering, and we have a well-documented gap there between men and women in STEM. And partly it's because of the historic underrepresentation of women in some of these green sectors, like auto, like renewable energy. And again, we need to start investing in women, upskilling, reskilling, acquiring these skills, as well as broader workers, so that they can take advantage of the opportunity that the green transition presents.
All right, Sue Duke, thank you.
Pleasure. Thank you.
Well, the King of England is recovering after undergoing surgery this morning. Ahead, we'll look at why the royal family has decided to be so forthcoming about the King's prostate. You're streaming CBS News.
We are about to see American weapons in the hands of Mexican cartels.
A gun pipeline to Mexico.
We are arming the cartels.
100%, no doubt about it.
Happening right under our noses.
Who's doing something about this? Nobody.
A CBS Reports exclusive.
Most Americans have no idea that we are effectively arming the enemy next door.
This is the story the American people need to know.
Arming cartels. Now streaming on the free CBS News app. People from every corner of America facing challenges.
Everyone is just looking for some type of connection.
Just raise your hand and say, hey, I'd like to help.
Coming together to find solutions.
We are going to do something about it.
Their stories are our stories.
Welcome to Eye on America.
Stream now on the free CBS News app. Feel the forecast on the CBS Evening News with Norah O'Donnell.
We aim every night to be factual and fair. That's our goal.
An original documentary from CBS Reports.
Imagine yourself in Manhattan with no police, no army, no mayor.
The people of Haiti stare down poverty, corruption, natural disasters, and violence.
90% of the guns that are used by gangs in Haiti are American guns.
But with an unbreakable spirit and eternal optimism.
There are days where I cry, but we can't be discouraged. We still believe in Haiti.
They're still able to look ahead with hope.
Haiti is on the brink of transformation, a radical shift. Nations are coming together and saying things must change.
Fighting for Haiti, now streaming on the free CBS News app.
Since childhood, she never stopped reaching for the skies. Now she's spent more time in space than any other American.
I like being a part of something bigger than me.
Peggy Whitson's extraordinary career as a history-making astronaut when we go person to person.
An original documentary from CBS Reports.
I always tell people that Twitter would not be Twitter without Black Twitter. It's just us being in fellowship with each other.
And it becomes a conversation you don't want to be left out of.
People really started to recognize the power of activism on Twitter.
Based on that one tweet, the hashtag #OscarSoWhite was trending around the world.
If anything has really powered Black Twitter, it's been humor.
If your food ain't right, oh, we're gonna tell you about that too.
So we tend to create
change, create culture, and cool.
That's how movements happen on Black Twitter and go beyond more than that.
Black Twitter, the Twitterverse that changed a generation. Now streaming on the free CBS News app.
Our story's just begun. Why did you want to share your story?
Water up this high?
Where are these coming from?
That's the million-dollar question.
I'm a very curious person. I wake up every morning asking, what's happening in the world? Why is this happening? And how do we answer that question on the CBS Evening News?
King Charles III is, quote, doing well after prostate surgery early today. Reuters says the surgery went as planned. The Queen consort was seen leaving the hospital after the procedure. The King was treated at the same hospital where Kate, the Princess of Wales, is recovering from abdominal surgery. The King actually paid a visit to her prior to his own operation. Joining us now from London is BBC News correspondent Charlotte Gallagher. Charlotte, tell us what we know about the King's surgery and any impact that it might have on his duties.
Well, we've given quite a few details actually about what was wrong with the King, because it's actually unusual to hear the details of the royal family's health problems. But we know the King had an enlarged prostate and he was given what's been described as a corrective procedure today at the hospital behind me. Now, that's a fairly routine procedure, but obviously with everything that happens in a hospital, there are risks, and recovery times can take different times between different patients. So it's likely the King is going to spend tonight in hospital. The Queen, as you said, she left early.
All right, Charlotte, thank you very much. We'll continue following that. We understand that the royal family usually isn't that forthcoming when it comes to many of their private issues, and we will continue monitoring this. As I say, Reuters reports that it went well. Well, it is Friday, and we have almost made it through another long work week. Some people may already be in weekend mode. You may dream of being one of them. Well, in just a few days, several large companies in the Dominican Republic are trying out a 4-day work week. Corporations can voluntarily opt into the 6-month study launched by the government of the Dominican Republic, with researchers analyzing the results. Employees will earn the same salary but work 36 hours a week from Monday through Thursday instead of 44 hours over 5 days. The government will analyze if the shorter week improves workers' well-being without sacrificing company growth. It is part of an international shift. Take a look at this. Companies in at least 21 different countries have tried a 4-day work week. Each study has worked differently, with the government being involved in some and others being corporate-led, but all of them involved reducing the amount of days worked without cutting pay. Now, the largest of these studies was done in the UK. In 2022, 61 companies with about 2,900 workers took part in the 4-day work week from June to December. Each company set their own program rules. Some implemented Fridays off across the board. Others staggered a 3rd day off throughout the week. And study data showed positive results for the companies and the employees. According to research from 4-Day Week Global, that's the organization that helped run the UK pilot program, 71% of those employees reported less burnout. 54% said it made it easier to balance their household responsibilities. Of course, all of that makes sense. But how did it work for the companies? Well, for the UK companies, 35% actually reported increased revenue during the period. And worker retention rates, particularly important right now, were noticeably higher, 57%. And the following year, of the 61 companies in the study, 51 decided to continue that 4-day work week. Now, there are, of course, critics of a 4-day work week. Some companies say that this structure just wouldn't work for their employees. But of the companies that have undertaken trials, they have implemented it overwhelmingly and have not gone back. Gene therapy has been used for the first time in the U.S. to treat genetic hearing loss. The Children's Hospital of Philadelphia says an 11-year-old boy from Spain received the experimental treatment in October. The boy was born deaf in both ears and now only has mild to moderate hearing loss in the ear that was treated. Doctors say this is a scientific breakthrough.
What we've really accomplished is exciting because it's the first time that hearing has been restored in a child, or really in a human being, for a hereditary type of hearing loss. We've been waiting 30 years for this to be here, and it's finally here now. And that is restoring a defective gene that you're born with.
Such a game changer. Surgeons say that they hope that this research can open the door for future use on other genes that cause hearing loss in children. Well, coming up in our next hour, the jury is getting the case. We are in court awaiting the decision in the Trump defamation case brought by writer E. Jean Carroll. Plus, a mixed ruling in the World Court calling on Israel to protect civilians in Gaza. It stopped short of demanding a full ceasefire. And Alaska Airlines prepares to put the Boeing MAX 9 back into the air. We have a look into the new measures being put in place to keep passengers safe. You're streaming CBS News.
Welcome back. We're resuming our coverage of the trial of Jennifer Crumbley. The courtroom is resuming. Let's listen in.
You were able to put together sort of a digital footprint from that day.
Correct.
Okay. So Exhibit 119, which has been admitted, this is the Oxford High School surveillance video from when the defendant's son was dropped off. Is that right?
Yes, sir.
Okay. You were able to determine that he was dropped off by James Crumbley at 7:46 a.m.?
That's correct.
Okay. We will determine the time that Jennifer Crumbley got to her place of employment that day.
A little after 9 in the morning.
It's Exhibit 120.
We have no objection to that.
Thank you. Sir, this is a screenshot from surveillance footage of her employer from November the 30th, 2021. And that's Jennifer Crumbley on November 30th, 2021, entering that building at 9:04 a.m.
Correct.
Okay. Now, shortly after she arrived, did she receive a phone call from the school?
Yes, she did.
Exhibit 121.
We have no objection. 121 is admitted.
And this is a snippet from her phone log, would that be correct?
That's correct.
Okay, so November the 30th, 2021 at 9:24 a.m. was a missed phone call, and that's from Oxford High School.
That's correct.
Okay. And she called the school back at 9:27 a.m., is that right?
That's correct.
And they had a 5-minute and 43-second conversation?
Correct.
Okay. Now, did she receive a text shortly after that phone call?
Yes.
Right. This is Exhibit 122 and 123.
I have no objection to 122 or 123. 122 and 123.
So 122, this is the text message found on her phone from an individual. It ended up being her son's school counselor at Oxford.
Correct.
Okay. And this is a picture of what we'll call an altered math worksheet at 9:31 a.m.
Correct.
All right. And if you were to click on that link, this would come.
Correct.
Okay. And then did she also receive an email with the original math worksheet?
That's correct.
All right. This is Exhibit 124.
No objection.
And this email, thank you. That was shortly thereafter. And the image in the email was in fact Exhibit 74, which was the math worksheet that her son created on November the 30th.
Correct.
Okay. So she had this information about 9:30 in the morning on November the 30th.
Correct.
Okay. Did Jennifer contact James right after that?
Yes, she did.
Exhibit 125.
No objection.
125 to 2.
So this is the Facebook message chat, the one that was deleted from Jennifer's phone. Blue is Jennifer Crumbley, is that correct?
That is correct.
And green will be James Crumbley.
That's correct.
Okay. So at 9:33 a.m., what did Jennifer write to James?
Call now, with now in all caps, emergency. And then she texted again, less than 2 minutes later, emergency.
Okay. And she sent these two pictures, both the original and the altered worksheet to James?
That's correct.
And this is at 9:38 a.m.?
Correct.
What was James' response at 9:44?
James responded with, my God, WTF.
What is it?
WTF, what the fuck?
Okay.
Excuse me. Then responds, vet not here yet. It's McElmurray for Kira's horse, still waiting on vet.
And we already talked about that they were concerned over one of their horses' medical issues.
Correct.
Okay. And what was Jennifer's response at 9:50?
She responded, he said he was distraught about last night.
And James's response to that?
We talked about it this morning, and then he asked her, you talked to him?
Okay, and that's 9:51. And what was Jennifer's response?
6 minutes later, she texted, can you call?
Did Jennifer leave her work and head to the school?
Yes, she did.
Okay. Did Jennifer Crumbley also text this picture, Exhibit 74, to anybody else at that time?
Yes, she did.
Okay. This is Exhibit 126.
We have no objection.
126 is admitted.
Now, she sent this picture, this text, to Andrew Smith at 10:05 a.m.
Correct.
Okay. Did you learn who Andrew Smith was?
Yes, I did.
And that was her boss?
Yes, it was.
Okay. And what did she text with the caption on this picture?
She said, I have to go to my kid's school. Counselor just called, and this is what I'm dealing with. I'll be back 11:30 to 12 at the latest.
And did she leave her employment?
Yes, she did.
Okay. This is 127.
No objection.
127 is admitted.
Okay, this is her leaving at 10:06.
Yes.
I want to go back to Exhibit 125 briefly. Skipped over it. She wrote, can you call at 9:57, and then what did she write?
She wrote, heading to his school, I'm very concerned.
Okay. So at 10:04, she wrote, heading to his school, and I'm very concerned. At 10:05, she sent that picture right here to Mr. Smith.
Correct.
At 10:06, she walked out the door to the building.
Correct.
Okay. Did James and Jennifer Crumbley have a phone conversation at this point?
Yes, they did.
Okay. This is 128.
No objection.
128 is admitted.
And sir, this is a snippet from the call log found on Jennifer Crumbley's cell phone. Is that right?
Yes, it is.
Okay. So, well, first she got a phone call from the school. This is a phone call to the school counselor at 10:07 a.m.
That's correct.
That's a 40-second call?
That's correct.
Okay. I'm sorry, that was Exhibit 121, not 128.
I'm sorry, you said 121.
That's 121.
121.
Okay, and Your
That's
Honor,
part of the call.
I would just ask that the witness answer questions instead of the prosecutor stating essentially all the information as he goes along.
Okay, so I guess it's the objections leading.
Leading.
I'll rephrase. All right, 128.
No objection.
Okay. Did James and Jennifer have a phone conversation after this?
Yes, they did.
Okay. Well, first, this is part of Exhibit 125. What time is this?
This is at 10:12.
Okay. And then what did she write?
Heading to a school.
Okay. Here's Exhibit 128 from James Crumbley's call log. What is this?
It's a call to Jennifer at 10:29 a.m.
Okay. So at 10:29 a.m. they have a 7-minute and 16-second phone conversation.
That's correct.
Did both James and Jennifer Crumbley arrive at the Oxford High School?
Yes, they did.
Okay. And approximately what time did they arrive?
It was around 10:20, somewhere around there, I believe.
Okay. If I showed you a timeline that indicated 10:37 arrival, would that sound right?
Yes, I apologize. Yes.
That's not.
Yes.
Okay. Now, we had discussed this portion of the case at a previous hearing, and you had indicated they had arrived in one car and left in one car. Did you find that to be accurate?
No, it was inaccurate.
Okay, so tell me what happened.
It was so the video system that they have only starts recording when there's enough motion to save space on the system. So they were too far away from the camera to pick up. When I initially saw them, all of a sudden they just appeared in front of one of the cars. So I assumed that they had come together.
Okay. And when did you come to find out?
That they had drove separately.
Okay. So Exhibit 129 is a portion of the Oxford High School surveillance video that depicts their arrival and the period of time they were inside for that meeting with the counselor. Is that right?
Yes, correct.
Okay. People moved him at 129.
I have no objection, but I'm just wondering if it's the actual video that's the
Correct.
That's the exhibit. Okay, no objection. Thank you.
129 is exhibit.
So there's a timestamp at the bottom. I want to make sure we see this. 10:36 a.m. and it's November 30th, 2021.
That's correct.
Okay. And let us know, please, when you see either the defendant or her husband.
The one vehicle is already backed in, and then there they are walking up.
They as the defendant and her husband?
Yes.
In the magnified area?
Correct, yes.
What's this portion of the video depict?
Them coming into the school.
Well, what area of the school?
The front by where the offices are.
Okay. This is 10:39 a.m.?
Correct.
And what portion of the school is this?
Looks like the front office of the school.
Now, this time right here, that's a broken clock, correct?
It is correct. It never changes.
So this is 10:40 a.m.
Correct. The counseling office.
I'm sorry?
They're in the counseling office. Sorry.
Did you come to learn who this person was who greeted them?
Yes.
Who's that?
Sean Hopkins.
Okay. He's the counselor at the Oxford High School?
That's correct.
Or one of the counselors? I should
One
say.
of the counselors, yes.
And the time skips a little bit. This is now 10:52 a.m. What do you see in this portion?
That's the shooter coming out of the Mr. Hopkins' office.
With the red backpack?
Correct.
So they walked in at 10:41 and the shooter walked out at 10:52?
Correct.
This is 10:53. Who do you see?
That's James and Jennifer Crumbley coming out of the Mr. Hopkins' office.
Now, there was something in his hand here. What is that? If you can tell.
I wasn't able to tell what that is.
Okay. Okay. Jennifer Crumbley has a piece of paper in her hand.
Yes, she does.
Did she have that walking into the counselor's office?
No, she did not.
And then right there, she handed that piece of paper to James Crumbley?
Correct.
So this is 10:54 and almost 10:55 a.m.?
Correct.
Okay. Do you see James and Jennifer Crumbley at the top of the screen walking
Yes.
to the cars?
Yeah, they're at the top of the screen coming from school.
Thank you. What are we seeing in this scene right here?
The one of their vehicles is leaving right there, the black one. Then in that third row on the far right, the other car should be leaving shortly now.
Okay. This is one of the Crumbley vehicles?
Yes, it is.
All right, and this is 10:57, about 10:58?
Correct.
Okay. So we saw them walk in at 10:41 to the office. Their son left at 10:52.
Correct.
And then we saw them leave the parking lot here at 10:57, 10:58.
That's correct.
Okay. So how long total, if you know, were they in the counselor's office?
It was about 12 minutes.
What's the first thing that Jennifer Crumbley did on her phone or social media after that meeting?
She sent a message to Kira Bennett.
Okay. This is 1:30?
We have no objection?
So this is a screenshot.
Correct.
Is that right? Okay. And these were taken from Kira Pennick's phone.
That's correct.
Okay. So the icon there, the picture on the horse, this is Jennifer Crumbley's words, correct?
Yes, that's correct.
Okay. And what does she write at 10:58 a.m.?
Okay, I'll bring some out later. Just had to get my son's school, go to my son's school, and meet his counselor. Shit day.
And then Kira's response?
Oh man, everything okay? Do you still want to do lesson tonight?
And then what did Jennifer respond to that?
Yeah, I still plan on doing the lesson. Everything's okay. He's just having a hard time after losing Tank, his friend going away to a treatment facility, and who knows what else. But he was caught drawing this on his math assignment today.
And then this is Exhibit 74, the math drawing that she was sent?
Correct.
And then what did Jennifer write in this post, or in this message?
As long as I can get out there early enough, because I had to leave work for an hour, and I have a meeting in Southfield at 3, but I should be done with that by 4. I plan on being there. Plus, the vet said it's better for him to move around to keep its circulation going while he's dealing with mud fever. Good times.
She's talking about her horse, right?
Correct.
Okay. And when she said, I had to leave work for an hour, she's talking about when the school called her for the meeting.
That's correct.
And what was the response at 1:26 a.m.? I'm sorry, if you can read that.
It's Kira responded with, "OMG, oh my God, he needs some horse therapy. I bet he," and it cuts off.
Okay, that's fine. The rest of these will be in through Kira later on. What's the first thing that James does when he leaves the meeting?
Starts door dashing.
This is 131.
No objection.
131. So what are we looking at right here?
That was a response from a search warrant served to DoorDash.
Okay. So we have not just the 30th, but we also have the 29th. And I'm going to direct you to the first DoorDash pickup, November 30th, 21, at 11 a.m. Is that right?
Correct. That's when he checks in.
Okay. So that was about 4 minutes or so, 3 minutes after he left the parking lot?
That's correct.
And Jennifer's text to Kira was about 2 minutes after she left the
That's
parking
correct.
lot? Yep. Did Jennifer go back to work?
Yes, she did.
All right. Here's 132.
I'm sorry, I'm just trying to read fast. No objection.
132.
Thank you. And this is what?
Her re-entering her place of employment at 11:24 a.m.
Okay. And that's November 30th?
Correct.
Going back to Exhibit 130. First, what's the next thing she does, either on her phone or social media accounts, after 11:24?
I'm sorry.
If you recall, what's the first thing that she does after 11:24 on either her phone or a social media account?
I don't recall.
Well, that's fine. We have Exhibit 130 already admitted. So 11:26 a.m.
Correct.
Okay. So you read the very top line of that OMG needs horse therapy.
Correct.
This is 11:26 a.m. So she received this 2 minutes after she walked in the door at her employment?
Correct, yes.
Okay, thank you. Go ahead and read that.
It says, "OMG, he needs some horse therapy. I bet he would love Mo. Whatever works for you, just let me know. I only have Bella's lesson tonight at 5:30, so anytime after her lesson is fine."
And what did Jennifer Crumbley write back?
Jennifer responds with, "Okay, yeah, well, he'll be coming with me tonight. James is working. He can't be left alone."
From the context of this conversation, did you take it that he was referring to her son?
Yes, correct.
And what did Kira write in response?
"Does he want to ride?"
And her response?
Jennifer responded, "I don't know. Maybe brush a small horse so he's not intimidated, LOL."
And then Kira?
Kira responds with, "Mo would be perfect." And then Jennifer responds with, "Okay."
Okay.
Kira then goes on to say, "Make it a family event. Coming out to the barn, really though, I've seen some amazing things done with horses with kids."
Thank you. Now, did Jennifer Crumbley text her son after that school meeting?
Yes, she did.
Okay. This is 133.
I'm sorry, sorry. I have no objection, I'm sorry.
Thank you. Now, this is the same text thread that we referred to earlier, found on Jennifer Crumbley's phone between, this was on the shooter's phone. No, I'm sorry, Jennifer Crumbley's phone.
Yes.
The entire text thread.
Correct, yes.
Thank you. Okay. Green is Jennifer Crumbley, blue is her son.
Correct.
Okay. Tell us what she wrote to him at 12:21 p.m. on November the 30th.
She asked, "You okay?" And then he responds shortly after that, "Yeah, I just got back from lunch."
Okay. And what did she say?
About 60 minutes later, she says, "You know you can talk to us and we won't judge."
And his response to that at 12:42 p.m.?
At 12:42, he says, "I care, I know. Thank you. I'm sorry for that. I love you."
Now, we'll introduce the rest of the thread. Did she respond to that?
No. Not immediately, no.
When did she respond to it?
After the shooting started.
After the shooting was made public?
Yes.
How many minutes later, if you know?
Over a half an hour.
Now, you're the investigator who pulled the footage, you reviewed the footage, and you know the timeline of the shooting, the day of the event.
Correct.
Okay. And so at 12:42 p.m., You know that was a few minutes before the shooter went into the boys' bathroom outside of classroom 258, and began to load his firearm.
That's correct.
And he emerged at 12:51 p.m.
That's correct.
Now, what's the first relevant event in either James or Jennifer's phone or email or social media accounts after 12:42 p.m.?
An alert was sent to, an email was sent to James's phone from the high school.
This is 134.
No objection.
134 is admitted.
Thank you. This is an email from Oxford Community Schools sent to James Crumbley's email address at 1:09 p.m.
Correct.
And that's, to your knowledge, the active shooter alert that went out to all parents in the district?
That's correct.
Now, when James received this, he was still making DoorDash deliveries?
Yes, he was.
Okay. Were you able to pull location history from his device?
Yes, correct.
Okay.
Yes.
This is 113. Oh, sorry, 136.
No objection.
Is this 135 or 136?
136, Judge. We skipped 135.
No objection.
I have no objection to 136.
136.
And then, are you going to do 135?
No, we're skipping 135.
You're skipping. Okay. Sorry, I'm just trying to keep my numbers straight.
136 is admitted.
Thank you, Judge. So this is location data from his email, the email that he received the active shooter alert.
Correct.
November 30th, 2021, and this is at what time?
This is at 1:13 p.m.
Okay. And where is this?
This is at the Meyer. He's in the parking lot of the Meyer.
Okay. And that's the Meyer off of Ray Road?
Yeah, it's the one that I responded to, yes.
Okay, so that was the reunification location for all parents?
Correct.
Okay. Did he stay there?
No, he did not.
Okay. How long was he there?
I think just a matter of minutes.
Did he call Jennifer?
Yes, he did.
This is Exhibit 137.
No objection.
137 is admitted.
This is a portion of the phone call from James Crumbley's cell phone download. November 30, 2021 at 1:15 p.m. He called Jennifer Crumbley.
That's correct.
Okay. And that was how long phone call?
Just less than a minute.
Okay. And based upon your analysis of his GPS locations, where was he at when he made the phone call?
He was still in the Meyer lot, I believe.
Still in the Meyer. Okay. Now, did you find out that Jennifer Crumbley left her work around that time?
Yes, she did.
Okay. Exhibit 138 is a surveillance video of Jennifer Crumbley leaving work. Objection?
No objection.
138 is admitted.
So this is 1:18 p.m.?
Yes, it is.
Okay, so this is after the active shooter alert went out at 1:09 and after she was on the phone with her husband.
Correct.
Sir, did it appear from your analysis that Jennifer and James Crumbley spoke on the phone after she left work?
Yes, she did.
1:39.
I apologize, just really quick. 138 was the video we just saw. 139 we have no objection to.
139 is admitted.
And both were admitted, right?
Yes.
Okay, thank you.
It's the call log off of James Crumbley's phone. November 30th, 2021, 1:19 p.m. And how long did they speak for?
They spoke for a little over 10 minutes.
Okay, when I say they, I should be clear.
James and Jennifer.
Thank you. Okay. Could you tell that while she was on the phone with James Crumbley, did she send any messages?
Yes, she did.
Okay. Do you recall who she sent a message to?
I believe it was Andy Smith she sent a message to.
Do you know who else she sent a message to?
I don't recall. I know
Did she message her son?
Yes, she did. I apologize. Yes.
140. This is location data.
No objection?
140 submitted.
Thank you. 140. This is GPS location data for James Crumbley. This is 1:20 p.m.
Correct.
Okay, November the 30th, and this is at their home at 112 East in Oxford?
On East Street, yes.
Okay, so just to back up, just to make sure we're clear, James Crumbley received the active alert email at 1:09.
Correct.
He called Jennifer Crumbley at 1:15 while he was at the Meyer parking lot.
Correct.
And he leaves the Meyer parking lot and he's home at least 1:20 p.m.
Correct.
Okay. And they had a 10-minute phone call that began at 1:19 p.m. That indicates to you that they're still on the phone?
Yes.
Okay. This is 141.
No objection?
141 submitted.
Okay, so about this time of the day, could you tell if Jennifer was on the move?
Yes, she was.
Okay, so this is what time?
This is at 1:20 p.m.
Okay, and this is at her location of her employment, correct?
Yeah, Telegraph at Square Lake,
Okay.
south of here.
So 142.
No objection?
142 is submitted.
So you said that while she was on the phone with her husband, she texted her son?
Yes, she did.
This is 142.
Okay, I'm sorry, hang on. Let me just pull it up real quick, I'm so sorry. Okay, sorry, thank you. Sorry, thank you.
November 30th, 2021 at 1:18 p.m. Did she respond to the message that he sent her at 12:42?
Yes.
What did she write?
She said, "I love you too."
Okay.
Then says, immediately after that, "You okay?" Then 4 minutes later, she says, "Ethan, don't do it."
That was at 1:22 p.m.?
Yes, it was.
That was after James Crumbley was at their home, 112
Correct.
East in Oxford?
That's correct.
That's while she was on the phone with him.
Correct.
You said she sent a message to her boss, Mr. Smith?
Yes, she did.
Go back to exhibit 126. What did she write him at 1:23 p.m.?
1:23, she texts, "The gun is gone, and so are the bullets."
And then what did he respond?
He responds with, "I'm praying everything is okay." And Jennifer says, "OMG," or "Oh my God, Andy, he's going to kill himself. He must be the shooter."
So that's right a minute after she wrote to her son, "Don't do it."
Correct.
That's while she's on the phone with her husband.
That's correct.
Did you come to find out that James Crumbley called 911 that day?
Yes, he did.
Was that at 1:22 or 1:20, or was it later?
It was later.
And was it before or after they had this text message conversation?
It's after.
Phone call.
After.
Okay. So in fact, did you find that James Crumbley called 911 at 1:34 p.m.?
That's correct.
Exhibit 143.
It's the actual cause. No objection, thank you.
143 is submitted.
So just so council knows, it's all listed in the exhibit list. It says 911 call. Easier for you.
It does, but I'm like, there's one of me. I'm going as fast as I can. I'm trying.
No, that's all right.
Exhibit
Okay.
143.
911, what's the location of your emergency? Okay, this is sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer to come to my house right away, please. Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation right now. I understand that. There's a missing gun here. I have a missing gun, and my son is at the school, and we have to go meet with the counselor this morning because of something that he wrote on a text paper, and then I was sitting down and I saw a whole bunch of cops going somewhere, and we didn't sure, but I wanted to get to the hospital so that was going to the high school, and then somebody told me that there was an active shooter, and then I went home to find out. And I think my son took the gun. I don't know. With him, I don't know what's going on. He's really freaking out. My son's name is Ethan Crumbley. C-R-U-M-B-L-E-Y. All right, sir, I'm going to put you on hold for just 1 second, okay? Dr. Cookman, come in and see if I can do anything Okay, Mr. Crumbley? All right, I'm going to get your name and phone number, and I'm going to have my lieutenant that's out there dealing with the situation. He's going to contact you, okay? What's your first name? My first name is James. Is Lieutenant Crumbley? Yes. Okay. And what's that phone number for you? 240-760-6484. Okay, do you know what your son was doing when he left the house this morning? He had on a pair of sweatpants and like a gray shirt. A gray, like, sweatshirt. Okay. Alright, so he's going to give you a call, okay? I can't give you a time frame because they're kind of in the middle of all of this. I can't give you a time frame, but we're going to give you a call as soon as it's possible, okay? Okay. Alright, thank you. Alright, bye-bye.
Sir, we saw the location data that James Crumbley left the Meyer on Ray Road at 117, and he was home by at least 120.
That's correct.
Okay. What's the relative distance between the Crumbley household and Oxford High School?
Less than a mile.
Okay. Now, after this phone call was made, did you learn that James and Jennifer arrived at the Oakland County Sheriff's Office substation in Oxford?
Yes, I did.
No objection.
Well, what is this, 144?
144, yes.
Okay, 144 is a minute.
So this is a call log. James Crumbley's phone call.
Correct.
Are you aware whose number that is, number 17?
Yeah, actually, it's one of the sergeants in Special Investigations, Sergeant Joe Bryan.
Okay, so this is after the shooter is taken into custody.
Correct.
Okay, so you know that he was taken into custody right about 1 p.m. on November the 30th?
Yes, he was.
Okay, and this is 1:50 p.m.
Correct.
Okay, so Sergeant Bryan learned who the shooter's parents are, and he made a phone call to James Crumbley?
Correct.
And shortly after this, did James and Jennifer Crumbley both go to the substation to meet with police?
Yes, they did.
No objection. 146. No objection to 145 or 146.
145 and 146 are in the middle.
Just quickly, this is to verify that they were in fact at the Sheriff's Office 148, both James and Jennifer Crumbley. Is that right?
Correct. I'm sorry, yes.
Correct. 158.
Oh, thank you.
Okay, so they're at the Sheriff's Office at 1:58. Did you come to learn when they went back home?
It was about a half an hour after, or less.
This is 1:48.
Okay, no objection.
So you're able to...
It's 147?
Sorry, 147 and 148. Thank you. So on Jennifer's phone, you can tell that she's at home by 2:30.
Correct.
On November the 30th? Okay. And same with James?
That's correct.
Okay. So this is after they went to the Sheriff's Office and their son was in custody and then went back home?
Correct.
Okay. Now, sir, did you have the opportunity in the course of your investigation to review what we have referred to as the burner phones as well as the replacement phones?
Yes, sir.
Okay. Now, I'm going to move ahead to December the 4th, 2021. Are you aware that they were arrested in the early morning hours of December the 4th, 2021?
Yes, I am.
Okay. This is 149 and 150.
We have no objection to 149 or 150.
149 and 150 are admitted.
So I'm showing you 150. May I approach the 149?
Sure.
Sir, this is, why don't you tell me what that is?
This is a report from Celebrate from a phone.
Okay. And that's from her, what we call burner phone?
Correct.
Okay. And up on the screen, 150 indicates that she had set an alarm on her burner phone.
I would just ask that the witness answer the questions. Leading.
That's fine. That's fine. What is that show?
There's a thumbnail of what is seen on the right side of the screen there, of the alarms being set at 6:30 on Saturday morning and 6:45 Saturday morning.
And that's December the 4th, 2021.
Yes, correct.
Okay. Now, did you find evidence on the replacement phone, which is the phone that was ported with their original numbers, that they had attempted a two-factor authentication for social media accounts?
Yes, they did.
Okay. Now, we had talked at the very beginning of your testimony about deleted content and your ability to recover deleted content. Do you remember
Correct.
that?
Yep.
Okay. Were you able to uncover some deleted content in this particular case?
Yes.
And we've talked about the Facebook message chat between James and Jennifer Crumbley.
Correct.
And you've already indicated that that chat was deleted from Jennifer Crumbley's phone.
That's correct.
Now, were you able to obtain a Facebook thread between Jennifer Crumbley and someone named Brian Malash?
Yes.
And was that through a Facebook search warrant?
Yes.
And did you uncover any messages before December the 1st of 2021?
No.
Okay. So if you were to learn that they had communicated on a regular basis through the Facebook Messenger chat, but you couldn't recover it, what would that indicate to you?
That it was deleted from the phone.
But on both ends, if you couldn't recover it from the server?
Correct.
Okay. Now, going through the evidence that you were able to uncover from Facebook itself, could you tell that some messages were selectively deleted?
Yes.
Okay. This is Exhibit 151.
Is this one ready?
Yeah.
Okay, no objection.
151's in the middle.
So this is a portion of what you recovered from the Jennifer Crumbley and Brian Malash Facebook chat. Is that correct?
That's correct.
Okay. So what are we looking at here?
The first message is an automated one sent from Facebook to the device. You unsent the message.
Okay, and what's the next?
The next one says, from Jennifer, we're on the run again, helicopters, not sure where to, I'll message you.
And when was this message sent?
You can see it says +0 for UTC, so you have to subtract 5 from the actual time that's displayed there, from there. So that would have been 7:31 in the morning.
And what day was that?
8:31. That was on December 12th, or December 2nd, I'm sorry.
Okay. So that was, the shooting was November 30th. That was a Tuesday. Wednesday was December the 1st. This was the morning of December the 2nd.
Correct.
And this indicate to you that they were deleted by Jennifer Crumbley?
Yes, correct.
How can you tell that?
The message, the automated response sent from Facebook saying you unsent a message.
Also 151. What time and day is this?
This is, well, it's 7 p.m. UTC, which is -5 hours, so it's 2 p.m. on December 2nd.
Okay, that's Thursday, December 2nd. And
Correct.
what did she delete from her phone? What message?
She had sent him, we're fucked.
And she deleted that?
Yes, she did.
Go back to Exhibit 126. Were you able to tell that Jennifer Crumbley deleted some messages she sent to Andrew Smith?
That's correct, yes.
And how were you able to tell that?
Because of the screenshots that were obtained from Andrew Smith don't match what was obtained from her device.
It's Exhibit 151.
No objection.
Okay, so before we get to 151, which is the extraction...
151 is already.
Yes, thank you, Jeff. Before we show that on the screen, 126 here, these are the screenshots found from Andrew Smith's actual phone.
That's correct.
Okay, so at 10:05 a.m., this is Jennifer writing this and sending this picture, correct?
Correct.
Okay, and then we just gone through this. At 1:23, she wrote, "The gun is gone and so are the bullets."
Correct.
Okay. And then, what did she write after that?
I'm praying everything is okay.
That's what Andrew Smith wrote?
That's what Andrew said, yeah. Then she responds, OMG, oh my God, Andy's going to kill himself. He must be the shooter.
And then what?
I need a lawyer at the substation with police. Ethan did it.
Okay. And then what did she write him at 3:39 p.m. the next day? Or later that day?
Later that day. I need my job. Please don't judge me for what my son did.
And that was just a few hours after the shooting started, correct?
Correct.
Okay. And then what did he write in response and what time?
At 5:47 p.m., he responded with, I can't even begin to understand what you're going through. I'm praying for you. I asked Carolyn to text you some attorney recommendations. And then she responds with, they're taking my cell phone.
Taking my cell phone, okay. Here's 151, and the top message is what?
The one where she says, I need my job. Please don't judge me for what my son did.
Okay, so that's on these screenshots, so we know that wasn't deleted.
Correct.
Okay, now what about this message here?
I can't even begin to understand what you're going through. I'm praying for you. I asked Carolyn to text you some attorney recommendations.
Okay, and then we also have this final message, they are taking my cell phone.
Correct.
Okay. But in the entire Cellbrite extraction from the text message thread between between Jennifer Crumbley and Andrew Smith on her phone, there were no other messages, correct?
Correct.
So that means anything before that message, she deleted.
That's correct.
Okay. So look, the only thing, I need my job, please don't judge me for what my son did, that was 3:39 p.m. So the gun is gone, and so are the bullets. It has been deleted. OMG, Andy, he's going to kill himself. He must be the shooter. That was deleted. I need a lawyer at substation with police. That was deleted. The picture she sent at 10:05 a.m. was deleted, as was the gun is gone, and so are the bullets at 1:23.
That's correct.
So I'm going to turn now to the Facebook messages between Kira Pennock and Jennifer Crumbley, specifically comparing what was found on Jennifer's phone with what was found from the Facebook search warrant from that particular chat.
Okay.
All right. 153 and 154.
Okay, did we do something with 152?
We have no objection to admitting.
This was 152, Judge. We've added this one.
Okay, you don't have any objection. What 152 is it?
No objection, right? Okay. And then I'm sorry, what was?
153, 153.
No objection.
Okay.
Sorry.
To 153 and 154?
Correct.
153, 154.
Thank you, Judge. Now, first I'm going to show you 153, which was the messages left on Jennifer Crumbley's phone. And I'm just going to show you the top portion of what is the Cellbrite extraction report. So tell us what we're looking at here.
We're looking at the participants involved, one of them being Kira Pennock, the other one being Jennifer Crumbley. At the very bottom of the screen, you see the conversation is the messages of 26.
Okay. And that's not 26 messages that you selected. That's all that's remaining on her phone.
That's correct.
Okay. And 154 is what?
That's you can see at the top extraction report, Facebook warrant return from both Kira and Jennifer, and it says instant messages 4,047.
Okay, so that would indicate that everything other than those 26 messages remaining were deleted by Jennifer Crumbley.
Correct.
And one moment, Your Honor. Nothing further to say.
Thank you, Your Honor. Good afternoon.
Good afternoon.
I want to just start. You've been obviously involved in this case since the 30th of November 2021, correct?
Correct.
And Since that time, you have collected and looked at an abundance of evidence related to the Crumbleys, the shooter, the shooting, everything, correct?
Correct.
And when you were testifying earlier, you testified that at a previous hearing, you had testified about the parents when they first went into Oxford High School, correct?
Correct.
And on that date, you had reviewed many, many materials prior to coming to court.
Correct.
And that hearing was a preliminary examination, which is a hearing that's before a trial, correct?
Correct.
And at that hearing, you did the best job you could in terms of explaining, answering questions.
Correct.
You were truthful on that day.
Absolutely.
As you're being today.
Yes.
And we can agree that you made a mistake about Mr. and Mrs. Crumbley arriving in the vehicle together at the school.
Because of the video, how it jumped, yes.
Okay, an honest mistake.
Correct.
And it's fair to say that when you didn't have more information, you made an assumption that they had been in the same vehicle together, correct?
Correct. I didn't know how many cars they had at the time.
You see them walk into the school together, but you couldn't see before that.
Correct.
And that's why you testified, honestly, you thought they had arrived together, but it was incorrect.
Correct.
And so you would agree with me that the more information you have about any topic, and the less guessing, the more accurate the information will be that you give on this witness stand, correct?
I wasn't guessing before. I didn't know how many cars they had. I just saw them appear in front of the car.
Right, so when you testified and said they arrived in the same car, that was incorrect.
Correct.
And I'm saying that had you had more information about seeing the vehicles pull up or seeing each one get out of separate cars, your testimony would have been different, correct?
It would have been included in the video, correct.
And so my point is, you do the best job you can with the information you have.
Yes, ma'am.
But you're certainly not someone who can go back in time and see and know every detail of every single thing that's happened, correct?
Not every single thing. You could put together a good timeline with all the information that you gather, yes.
And it's fair to say for this jury, you have put together as detailed of a timeline as you can about all of the events before November 30th through 11/30th and beyond 11/30th, correct?
That's correct.
And when you are doing that, you are taking data from cell phones and other investigators, from surveillance, from all these different materials that are a part of the investigation in this case.
Correct.
And it's possible that at times when you answer a question, you may not be accurate, but you're not sitting here intentionally trying to lie, correct?
It's absolutely correct.
Okay. I'm going to go back through the investigation that you did. It's fair to say, and I think you testified, you started obviously on November 30th of 2021, correct?
When the investigation started?
Yes.
Yes.
Okay. And can you give the jury an idea of how much time it takes to get certain evidence, or kind of what it looked like going forward from 11/30 when you received various pieces of information? So on 11/30th, let's talk about what you saw that day. You obviously saw the surveillance camera from the school, correct?
Yes, correct.
Okay, on that day, did you have the surveillance camera from Jennifer's office?
That came afterwards.
Okay, that came down the road.
Yes.
At that time, did you have the text messages between Jennifer Crumbley and James Crumbley?
That came out. No, that would have been afterwards.
Okay, when did that come?
It would have been within a week, 2 weeks of that. We would have had to, like I explained, the process of getting the data from a phone. Depending on how much data there is, it could take a while, and then to sift through all of it. So it could be anywhere from a couple days to a couple weeks to get everything that you're looking for.
And in terms of the investigation, there were materials you had on the 30th, obviously.
Correct.
There were materials you received in the days following the 30th, correct?
Correct.
And there were some materials that law enforcement didn't have for weeks and months that became a part of this investigation. Is that a fair statement?
That's correct.
And as more and more information became available, you would turn it over to the prosecutor's office?
Correct.
And then you would assume that they would turn the evidence over to the defense for it to be used in court by all parties and the judge.
Yeah, I knew my job. I don't know what they're. Yeah, they have to give that up. Yes, I understand that.
Okay, so at the time on the 30th, it's fair to say all of the evidence that you have in this investigation. I'm sorry, not on the 30th. The 30th was the day of the shooting, and Mrs. Crumbley was arrested overnight between December 3rd and December 4th, correct?
Correct.
And it would be fair to say that between November 30th and December 3rd, your office and team and all law enforcement were working as hard as they could to collect information and collect evidence, correct?
Correct.
While you were working as fast as you could, there were a number of materials that you did not see until after Jennifer Crumbley was arrested.
Well, just because of the sheer volume of information that we were pulling together at the time, yeah, I mean, it took a while to go through it.
And when you're looking at all of the information about Jennifer Crumbley in this investigation, much of what you're doing is looking back in time in hindsight.
In hindsight, we're trying to put a story together, a series of events or a digital footprint of what had happened. We're trying to put that together.
And as you're trying to put that together, you're doing the best you can to make the timeline and the evidence make sense, correct?
Correct.
But in terms of what happened in the months before the shooting, the day of the shooting, and the days after the shooting, you obviously were not with the Crumbleys 24/7, correct?
No, I was not. I didn't know them before this.
And it's impossible to have, there isn't any way to have a videotape, for example, of all those months, that shooting day and the days following, correct?
Correct.
So you take bits of information and try to put it together the best you can to make sense of it.
Are you referring to this investigation or throughout life?
Well, both. I mean, I guess we do that in both, right?
I guess if in my life, if my son had hallucinations, I would have taken serious pause with that.
All right, let's stop for 1 second. When you say hallucinations, you're saying that you would take serious pause, but in reality, you did not know the shooter before this shooting, correct?
No, I did not.
You do not have awareness if he was really having hallucinations, correct?
I would have taken some time to look into it.
You're aware that there's this text thread, and we're going to get into it later, where he's telling his parents he's seeing things, correct?
Correct.
But you weren't a part of any of the conversations or a part of that household in those days around that text message conversation, correct?
No, I was not.
You're not. Okay, you're not aware of what Jennifer and James and their son had been talking about in person before and after those text messages.
Well, from the text message, I know the son on a couple of occasions asked or spoke with his friend about seeing a doctor or wanted to go see his doctor. Tell his parents tell his parents that he wanted to go see a doctor.
And while there are texts between the shooter and his friend, you have no evidence that Mrs. Crumbley has ever seen those texts, correct?
That she has read them? No,
Right.
I do not.
So there's text that the shooter sent to his friend, and you have no way to know whether Jennifer Crumbley ever saw those text messages, correct?
Other than his own words saying, I'm going to tell my parents tomorrow that I want to go see a doctor.
That telling his friend, I want to go see a doctor, and I'm going to tell my parents tomorrow, you don't know if he really wanted to go see a doctor or was going to tell his parents, correct?
I understand that's counsel's argument, but it's improper questions. He already answered the question.
Okay, you don't know whether Mrs. Crumbley saw the text between her son and his friend.
No, I do not, ma'am.
And I'm also making the point, Your Honor, and the question is, you also don't know if it's true that he really planned to tell his parents anything. He has a text to a friend saying that, but you don't know whether that's true or not, correct?
Other than him saying on a couple occasions, no, I don't.
Okay. And when you say a couple of occasions, there's text messages on certain days that that you testified about, but there's many, many, many other days, we can agree, that you have not testified about, correct?
In reference to what?
In reference to what he said to his friend, or in reference to what he said to the Crumbleys.
I mean, did he have are you asking, did he have conversations with them? I don't understand the question. I'm sorry.
I'm sorry. My question is, you've given us bits of information about certain days, about March 9th, about a date in April, about a date in November, correct?
Correct.
Okay. There's a lot of other dates that you did not give us information about what exactly was texted to and from Ethan Crumbley and Mrs. Crumbley, correct?
Correct. There wasn't much texting between them.
Okay. You also, there's certain messages that you testified about between the shooter and his friend.
Correct.
There's also a lot of other text messages between them that you have not talked about.
Well, because the stuff that was talked about was not allowed to be talked about. He talked about...
Your Honor?
Yeah.
Well, I think it's important, Judge.
Yeah.
Counsel can't ask questions about evidence that she sought to exclude.
Okay.
Telling this jury that I sought to exclude evidence that was irrelevant is very unfair, and that is improper.
Okay, well, there's a lot of improper things here. No one's hiding any evidence from the jury, okay? So I don't want any implication that this witness is hiding what evidence from someone. So.
Thank you, Judge.
So don't ask about the messages if you don't want to know. So.
Okay. When you're talking about the text messages, let's back up and do this differently. You went through text messages between the shooter and his friend to find evidence to support that the shooter was having issues, correct?
To build... We went through the text messages to try to get an idea of who he was and what he was going through and what he had talked about with his friends.
And when you saw text messages, like you testified about, involving seeing things and dishes flying and demons and things along those lines, you gathered those, and that was the evidence that you've presented to this jury to support your case, correct?
Well, because those are things of importance, that he was hallucinating and seeing stuff flying off his shelves. And there's no other evidence or that we could find on the phones or communication between them to say that that problem was remedied, or that a phone call was made to the shooter to what's going on, or how can I help you, son, or anything like that. None of that was found. So it was important that that was what he was struggling with.
Okay, you're guessing that is what he's struggling with. You're doing the best you can, but you're getting pieces of information out of text messages, and really you don't know these people or what was going on, other than what you see in these texts.
He agrees with that. He didn't know any of them before this. Yeah.
Okay, I apologize. Well, I keep ending up in a situation where we're trailing off and repeating, and I would just ask that stop. Mr. and Mrs. Crumbley were at their home and law enforcement came to their house. It's accurate that the cell phones from the parents were taken by law enforcement.
The first time they came to the home?
Not necessarily the first time. I'm asking, police took the cell phones that Jennifer and James Crumbley used. Police took those phones, correct?
Yes, they did.
Okay. And when police took those phones, Mr. and Mrs. Crumbley obviously went and bought burner phones or track phones.
Correct.
And you've testified that you can see that Mr. and Mrs. Crumbley, or at least Mrs. Crumbley, attempted to get into some accounts that required two-factor authentication.
That's correct.
Can you please explain very quickly what two-factor authentication means for the jury?
It's so someone can't get into your account with just simply your password. When you open up an email account or you open up a Facebook account and it tells you, put your phone number in here. So when you try logging in from a phone or a device that Facebook doesn't recognize, it'll send a text message to the number that you said send a text message to. So then you enter that code into the app as you're trying to log into it. So it's two-factor authentication, your password and then text message from the provider.
And so for things like sometimes bank accounts or portals to get into doctors, things along those lines, sometimes two-factor authentication is required where you would need your original phone, correct?
Correct.
Or at least your phone number to be able to gain access to your own accounts.
That's correct.
There are accounts that will block you out if you're using a device it's not used to seeing when you log in.
If the two-factor authentication is set up?
Yes.
Correct.
And so in this case, you could see that Mrs. Crumbley attempted to do some two-factor authentication and was unable to do so, correct?
I don't know if she was unable to do so. I know there's a text message that was received from Instagram with a two-factor. I don't know what happened with after that.
Okay, so after buying the track phones, the burner phones, it's fair to say that Mrs. Crumbley and Mr. Crumbley went to their phone carrier and purchased new phones that have their regular phone numbers on them, correct?
Was that after the burner phones, is that what you're saying?
Yes.
Yes, they did.
Okay, so when we're talking about the Crumbleys having 6 cell phones between them, the 6 cell phones include their original phones that were given to police, correct?
That's correct.
It includes these 2 track phones that have different phone numbers where you can't do the two-factor authentication, correct?
That's correct.
And it includes the 2 phones that were purchased after that so that they could have their phone numbers back on devices and then access accounts.
That's correct.
And from the phones, when you seize them, there is evidence that Jennifer Crumbley attempted to deactivate and delete a number of social media applications, correct?
There was talk about it in text messages. You need to delete this account or whatever. I don't know if you have something in particular that you're a certain account that you're asking.
There are text messages within the exhibits the prosecution has admitted, and I can put them up, that show Mrs. Crumbley and Mr. Crumbley were trying to deactivate Facebook accounts and Instagram, correct?
I know there were text messages people texting them telling them to do that, yes.
Okay, and part of the reason people in those text messages were telling them to do that is because after the shooting there were threats and there were a lot of threats against Mr. and Mrs. Crumbley.
Judge, respectfully, I don't believe this officer can testify as to the reason why people said that. He can testify that there was attempts to delete and things were deleted, but the reason for the motivation, he can't testify.
Well, he can't testify about the motivation, but did you see anything? Did you see threatening messages to them?
I don't recall seeing any person. No, ma'am, I don't.
Okay. Do you recall that when in the text messages that Jennifer Crumbley sent out, she told Ms. Brian Maloche, she told Kira Pennick, she told multiple people that she was being threatened.
Are you telling me that or
I'm
asking me?
asking you.
I don't recall. If you have something to show me, I don't recall that off the top of my head.
Okay. Okay. Okay, so in okay. I'm going to put on the screen exhibit number 130, which was admitted in your prior testimony. Is it? Yeah, sorry. Okay. Now, within the text message thread between Jennifer Crumbley and Kira Pennick, this is a screenshot that was in that text thread, correct?
This is from Kira Pennick's, a screenshot of hers? Is that what this is?
This is in Exhibit 130 that's been admitted. These are screenshots with Kira Pennick. And I am asking you, this is a screenshot showing threats to Jennifer Crumbley that Jennifer Crumbley showed to Kira Pennick.
I don't know. I don't remember ever seeing. I don't know where it says Kira Pennick in the title of the image, but I don't know.
Okay.
Is there a copy of the exhibit that you could see? Did you say this is in 130?
Your Honor, this is in 130, and I apologize. I am going to have to go in detail through each exhibit. I did not want to do that, but it's very clear I'm going to have to. So I'm going to the top of this. This is a 28-page exhibit, okay?
Well,
this was in...
He's having the same challenge you are, is that there's so much paper that...
Right.
He can't say... If there's a hard copy of the exhibit, that could help him, right? Is there...
May I approach?
Yeah, can he...
Yeah, that's...
Okay.
Okay, so this was admitted... these were admitted screenshots through your testimony. Do you recall that?
Yes, I do. I see the...
Okay.
Does that document refresh your recollection?
Well, this part at the where it says met with his counselors. Yeah, that part, I remember that.
Okay. And in the thread, we see what you testified about in terms of Jennifer Crumbley sending over a copy of the math assignment.
Correct. I see that, yes.
Okay. We see the testimony you gave about Ethan being upset, having lost his friend, and going away, and his dog.
Correct.
Okay. Going further down, this is before the shooting started. Okay, so I'm on page 4 of that exhibit, going into page 5. This is all before the shooting, correct?
Correct.
Okay, and in this part, they're talking, Jennifer has told Kira Pennick, as you testified, about the math worksheet.
Yes.
She's told Kira Pennick about, I had to go to the counselor's office to have a meeting with them.
Correct.
Kira's talking about what horse Ethan could possibly be with that day that might make him feel better.
Correct.
And as the text thread goes down further, Kira and Jennifer, it's fair to say, remained in contact through the time of the shooting and after the shooting.
Correct.
Okay? And on November 30th, Kira Pennock is asking, she says, I heard there was a shooting at Oxford High School. Is Ethan okay? Correct?
Correct.
Okay? Saying, if you need anything, let me know.
Correct.
And after the time of the shooting, at 4:42, Jennifer Crumbley is texting with Kira Pennock again.
Correct.
Talking about how she needs to sell her horses.
Correct.
This is when she knows that the shooting has happened, and she's, well, she says, my head is spinning right now, correct?
That's what. Yes, correct.
Okay? She's talking to Kira Pennock about selling the house back and forth.
Correct.
Okay? And Kira is talking about how she'll take care of the horses for Jennifer.
Correct.
Okay? And Jennifer says, I don't have my cell phone right now. She tells her I'm on this track phone.
Correct.
Because the police have her real phone.
Correct.
Okay? And then Kira tells her about how there's stuff on Facebook. People are figuring out what's going on, correct?
Correct.
And Jennifer indicates, I'm off Facebook, I'm still in shock.
Correct.
Okay? And Kira offers to send Jennifer, can you receive pictures? I'll screenshot it, correct?
Yes.
And then Kira goes on to send Jennifer screenshots of something a mutual friend posted that was about the shooting, correct?
That's correct.
And their discussions are about, it says right in the exhibit, I cannot believe people on Facebook. I'm so sorry you're having to deal with this stuff, correct?
Correct.
Okay. She asks a question about the medication, and Jennifer indicates we're at a hotel in Lapeer and that the news is live at her house, correct?
Correct.
Kira's response, at least in the text messages, is please stay safe, correct?
Correct.
And Jennifer sends her over what appears to be a screenshot from a social media app, maybe Facebook or I'm not exactly sure, but you can see that Jennifer sent a screenshot where she has received nasty messages to her.
Judge, I'm just going to object to the form of the question. Mr. Rogowski can certainly read all of this, but calling it a threat or nasty, that's not for him to answer. That's for the jury to determine.
Well, yeah, they can characterize it.
They can read it.
But definitely they're not nice.
Okay, can you please tell the jury what these messages say? Larry Barton.
I'm sorry, you want me to read them? What
Sure.
it says on there? It says rotten jail next to him.
Okay, Brandon Hegwood.
What a shame on you.
Kaylee Camacho.
Fuck your ugly ass kid, I hope.
Adam Tank.
What a fucking coward, Ethan.
Jennifer Crumbley texts to Kira, I can't go home.
Correct.
And Kira texts back that she's concerned for Jennifer's, and when she says you guys, I'm concerned for you guys, and is expressing concern, correct?
That, yes, to stay away from the horses, correct? Yes.
Okay. She also says she's worried about your horses or hurting you while you're here, correct?
Correct.
Okay. It's fair to say that Jennifer and James are afraid of the public's reaction to what their son did.
Again, Judge, form of the question.
Yeah, I don't understand that.
Well, let me back up. I'm sorry, I can rephrase, if that's okay. Okay, so we know the news has been around the Crumbley's home.
Correct.
Okay, so following the shooting, there was media all over their street, correct?
I wasn't there. I don't know. I wasn't there. I can't tell you if there's media there or not.
Okay, it would surprise you if there was?
It wouldn't surprise me, no.
Okay. There were some nasty messages coming into Mrs. Crumbley.
From the screen, are you referring to? Yes, I'm sorry, yes.
Okay. And Jennifer is saying she doesn't want to put anyone else at risk. And that specifically is on page 15 of the exhibit you're looking at.
Correct.
Kira is telling her about, or is commenting people are ridiculous, also talking about buying horses, other random comments in there. Is that a fair statement? There's some miscellaneous, I don't know.
She also said be honest about things too.
Yep, Kira's saying to her the best thing you can do is be honest about things.
Correct.
Okay. Jennifer's not saying, I don't plan to be honest, right?
She didn't respond with that, no.
Okay, Jennifer's not saying, I've got a big plan to lie, help me put this together.
It's not in here, no.
Okay, we have no evidence to suggest that Jennifer's telling Kira to lie about anything for her.
Correct.
Okay, so when Kira's saying be honest, she's saying be honest, but you have no reason to believe that Jennifer's attempting to be dishonest at this point, based on that message.
At this point, no, yeah. But they were taken into custody for a couple days after they were told to turn themselves in.
I'm sorry?
They were taken into custody a couple days after they were supposed to be taken into custody.
Okay, we're going to get there. We'll get there. Jennifer Crumbley is representing that she's trying to work out lawyer fees, figuring out about being questioned, if she's going to be brought in, amounts she can pay, things like that, correct?
Correct.
Okay, and Jennifer is telling her, I am bawling right now, my son ruined so many lives today.
That's correct.
And he did ruin so many lives that day.
Yes, he did.
And Kira is writing back to her, she wishes she could help more. She's also in shock, correct?
Objection again in the form of question, Judge.
Well, he doesn't know if she's in shock. She texts that.
Okay, I'm sorry. She texted, I am still in shock too.
That's what she texted, correct.
And Kira encourages Jennifer, take it one day at a time, and again, just be honest about everything. It should help you through this.
Correct.
And offers to take care of the boys, which we would guess is her horses.
The 2 horses at her farm, correct.
Jennifer is thanking her for not judging her, unlike the whole world, correct?
Yes, correct.
Okay, meaning that we can assume Jennifer feels the whole world is judging her.
Again, objection to the form of the question.
Yeah, well, he doesn't know. He knows what the text says. He doesn't know how she feels. But that's what she said.
Okay, that's what the text says.
That's what the text says, correct.
Kira says that she's not going to essentially judge Jennifer. It doesn't remotely make her think it's their fault, correct?
That's what Kira texted, yes, correct.
And then Kira says, it sounds like Ethan was a troubled kid.
Correct.
It's unfortunate this happened.
That's correct.
Okay. And Jennifer is texting her back, I wish we had some warnings. Something. That's what Jennifer texted back to her, correct?
Yeah, the hallucinations, back to that, could have been warnings for seeing demons.
Okay. And again, you didn't know these people, you don't know the context, you don't know what they discussed. We've already covered that earlier in your testimony, right?
I do not know them before this prior. Correct.
Okay. So you've talked about the hallucinations many times. The jury gets it. There's a text about hallucinations. We all agree. Those are there. Okay? To you, those would have been alarming. You would have you would have acted differently based on getting that text?
Absolutely, I would have.
Okay. Jennifer Crumbley is texting her friend Kira in this text thread. That's what we're going over right now.
Okay.
And her texts are saying, I wish we had warnings.
Correct?
Correct. That's what she put, yes.
Okay? And Jennifer Crumbley wrote, he's a good kid. They made a terrible decision. And there may be typos, but it says, he's a good kid. They made a terrible decision. Correct?
That's what she typed, yes.
Okay. Kira responds back, there probably were warnings, but nobody saw them. Hindsight is always 20/20. I don't care if you agree with it or not.
That's what's typed there.
That's what Kira says.
That's what's
Hindsight
typed
is
there.
always 20/20, correct?
That's what's typed there, yes.
Then Kira goes on and says, people at the barn are concerned. I'm sorry, I'll go slower, okay? A lot of people have found out Ethan's all over Facebook. That's the next thing she says, correct?
Correct.
And then she goes on to say, people at the barn are concerned.
Correct.
She tells Jennifer, I think it would be best if you didn't go out to the barn, or if you do, you should be escorted by police, correct?
Correct.
When someone's escorted by police, that's usually for safety reasons, correct?
Possibly, yes.
Jennifer says, seriously, those horses are the only thing good in my life right now. And this is after the shooting, correct?
Correct.
And Kira responds, I understand that, but we all need to be careful.
Correct.
So it's fair to say there was a concern about safety regarding Jennifer after the shooting, and also other people around her were concerned for their own safety.
Correct.
And it's also fair to say, and if you don't know, please just let me know if you don't know, a lot of people in this state hated Mr. and Mrs. Crumbley when they heard about this shooting.
Judge, he can't possibly answer that question.
Yeah, I don't know how he can testify to that.
Okay.
There was widespread attention.
There was widespread attention.
Yes, there was, of course.
And there were many news articles.
Correct, yes.
And people on anything like this are naturally upset to see a school shooting.
Absolutely.
And people naturally are angry to hear that children have died.
Absolutely.
And this was the kind of event that sparked a lot of emotion in a lot of ways.
That's fair to say.
That's fair to say for you personally.
Absolutely.
You would imagine that for other people, they were personally affected by this, very emotional.
Yes.
And it's fair to say that this kind of a tragedy it was just horrific. We can agree it was horrific.
The shooting, yes, it was, absolutely.
Jennifer tells Kira to call her on Facebook. She's on a track phone, needs to figure some things out, correct?
Correct.
If they did have a phone call, you're not aware of it. And I'll slow down. The next message says, sorry, I missed your call from Kira, correct?
Correct.
But we don't know what happened in between the text about calling at 11:23 and the text the following day at 2:34. We don't know if there ended up being conversations or not. Is that a fair statement?
Correct.
You can't tell from this
Not
thread.
from this, correct.
So they're going back and forth, talking more and more. about letting her know later today, things like that. There's talking horses in between all of this. Is that a fair statement?
Correct.
And on the bottom of page 22, Kira indicates, I don't want people to follow you or hurt you.
Correct.
And Jennifer says, we are out of the area for a few days in a safe place until we have a better grasp on everything. Correct?
That's correct.
She doesn't say, we are trying to get out of state, we're trying to get out of the country. She doesn't say anything like that, correct?
Not in this chat thread.
Okay. In this, she says, we're trying to be in a safe place.
Correct.
Which would indicate safety is, of course, a concern to the Crumbley parents.
By saying they're in a safe place, yes, I would say that.
Kira says, I'm glad you're safe. I care about you guys, correct?
Correct.
She assures her she'll take care of the horses. They'll talk about buying them, figuring out somebody to buy them, correct?
That's correct.
A few more text messages back and forth about meeting before then. And then on page 24 of that exhibit, Jennifer says, what's your number? I want to call and set up a safe place to meet, correct?
That's correct.
Okay. She mentions that her messenger is probably being monitored.
She does say that, yes.
Okay. And she's talking about she needs to get stuff, discuss the horses, correct?
That's correct.
And let's see, they're going through more about whether cash or checks are best.
What page is that? I would say that, yes, I'm sorry.
25.
Yes.
Okay, and you're aware that after the night of the shooting, the Crumbleys went and stayed in a local hotel.
Yeah, correct. They went to a hotel, yes.
Okay, and the next day they went to a different hotel.
Correct.
Okay, which was also, I mean, maybe an hour from here, a local hotel, not out of state, not out of the country, right?
Within an hour, yes.
Okay, and so in the days following the shooting, the Crumbleys did not return to their home in Oxford.
They did not know.
And as far as you know, since the day of the shooting, the Crumbleys have never returned to their home in Oxford.
No, they've never been back.
See if there's anything else, I'm sorry. Okay, and then the rest of this is talking about possible charges being announced and things. Jennifer is saying she's anticipating there may be charges announced, criminal charges.
Yes, at the night before, I believe. I mean, on page 26, yes.
After the shooting.
Yes.
And when she's talking about charges, she's trying to figure out if they're charges, well, I'm sorry, scratch that. She's talking about charges against herself, correct?
I'm not entirely certain if she's, it doesn't say whether she's referring to herself or somebody else.
Okay, so she's waiting to basically just figure out what's going on.
Judge, again, counsel can't narrate what she thinks her client was thinking. She can have him read the text message. I admitted it into evidence. They can have it all.
Yep. Okay, so there's a text.
Okay, so the text says, Jennifer Crumbley wrote, I'm not sure what's happening.
Yes, I'm sorry, yes.
Okay. From the text message thread that the prosecution introduced between Jennifer Crumbley and Brian Maloche, we also can conclude, and if you can't, let me know, that Jennifer Crumbley was trying to deactivate and delete social media accounts?
I believe she was, yes, I believe they discussed that, yes.
And Jennifer Crumbley is asking Brian Milosh things about, can you still see James's Facebook? Can you see my Facebook? Questions like that, correct?
Correct.
Okay. James and Jennifer Crumbley Jennifer Crumbley in her text messages is very clearly making it obvious. She is telling Brian that she is shutting things down. Like that.
I don't remember the language that she used. I know they talked about it. I don't remember if she used the phrase shutting things down.
If a person has a Facebook account that they deactivate, okay, I'm going to go even slower. When someone has a Facebook account, other people in the world have the ability to see that account, correct?
If it's public or your friends or whatever other security settings, but yes.
However you have it set up,
yes.
You allow who can see the account and who can't, correct?
That's correct.
If you do have an account and you don't want the world to see it, if you deactivate the account doesn't appear when people look for you on Facebook, correct?
That's correct.
So if the Facebook account is deactivated, people cannot send you messages through Facebook, correct?
That's correct.
And they can't send you messages through Facebook Messenger.
I'm not entirely certain if you'd have to deactivate Messenger as well. I don't know, because they are two separate platforms. It's under one company, Meta, Facebook, but I don't know if you have to deactivate both of them.
So with Messenger, if Jennifer Crumbley deactivated Messenger, we can agree that people wouldn't be able to send her messages.
Correct.
And in general, if a person is trying to avoid having people find them on social media, deactivating the account makes it so people don't find them, correct?
Correct.
So, for example, Instagram. Jennifer Crumbley had an Instagram account, and you testified about that to the jury, correct?
There's a two-factor authentication text message that was found, yes, with Instagram. Is that what you're referring to?
I'm not referring to the two-factor authentication, but you testified that Jennifer Crumbley had an Instagram account. Well, we can agree she had an Instagram account.
Yeah, she did. There were posts that were admitted the other day, I believe, right?
Right,
yes.
and in that, on Instagram, the whole point of Instagram is to post photos or videos, correct?
Correct.
And we can see the Instagram account that Jennifer Crumbley had with videos and pictures she had posted over time.
Correct.
And when a person turns off or deactivates their Instagram account, other people in the world don't have the ability to see those photos any longer, correct?
That's correct.
Other people in the world don't have the ability to send messages through Instagram to the person that's deactivated their account.
Correct.
So, as a computer expert, if a person is trying to avoid having people see them or find them or see posts of theirs, even old posts, deactivating the account will accomplish that task.
Correct.
On that Instagram account, you are able to tell from the data that you received other accounts that Jennifer Crumbley followed.
Correct.
So, meaning that from her account, Jennifer Crumbley had certain people she was linked up with where she could see what they posted on their accounts, correct?
Correct.
And on the flip side, people she was friends with on Instagram or connected to could see what she posted.
That's correct.
And we know that Jennifer's son had an Instagram account, e.crumbly, correct?
Correct.
And we can tell that Jennifer's account was connected with her son's in a way that she could see what he posted on that account.
Correct.
And we can presume he could see what his mother posted.
Correct.
When you are looking through the Instagram records, you are not able to tell which posts Jennifer did in fact see or not see, correct?
Correct.
So if the shooter posted something and Jennifer Crumbley had not checked Instagram, it's possible she would not have seen it even though he posted it.
It's possible.
If he posted it and she looked at Instagram and looked at his account, or looked at his profile, is that what it's called? She would certainly see anything he posted.
Looked at his account, you're saying? I'm sorry?
Yes.
Yes, correct.
But in terms of all of the data you have, you don't have any way to determine which Instagram pictures she did or did not see.
Correct.
Now, if she made a comment on a picture, you would know she obviously saw it because you couldn't comment unless you had seen the picture to put the comment on there, correct?
That's correct.
And on the Instagram photos, there are not comments from Jennifer Crumbley to her son about the posts, correct?
On all the photos or a particular one?
I suppose the ones that we've admitted as exhibits in this case, the photograph of the gun, for example.
Correct.
And there's no doubt the shooter liked guns.
Correct.
And there's no doubt Jennifer posted photos of the gun.
Correct.
And videos.
Correct.
And even with what she posted, we can't tell if the shooter could see her posts.
Possibly, correct.
He may have seen them, he may not have seen them.
That's correct.
In terms of people communicating, we know that people can communicate obviously by telephone, voice phone calls. I don't take many these days because I hate them, but in the old days we could talk on the phone from one person to another, correct?
Correct.
And there's the ability obviously to text. People can send messages from one person to another.
Correct.
And in terms of people's habits, some people may delete texts when they get them. Correct?
Correct.
Some people may keep every text they've ever had.
It's correct.
Some phones will delete texts after a certain period of time.
Not unless the user tells it to, no.
If someone gets a new phone, there are occasions where the old text from the old phone may not come up on the new phone.
I mean, I can't say for certain. I don't know. I haven't tested something like that yet. I don't know.
We can agree that everyone's personal habits in terms of how many texts they keep on their phone or don't are individual to each person.
Correct.
So when you're testifying and telling the jury about posts that you can tell or texts that you can tell are deleted or not deleted, you have never sat down and talked to Jennifer Crumbley about her habits with deleting posts or pictures or texts, correct?
That's correct.
The best you can do is look at what's deleted, what's not deleted, and tell this jury your findings.
Correct.
I want to go to March 9th of 2021, you testified pretty extensively about that date. Do you recall the materials from that date? And if not, I can certainly...
Absolutely. Yeah, if you have copies of it, I would prefer that. Yes, please.
Okay. So on that date, I will approach with copies in just a moment. I just need to pull it up on my computer. I'm going to go to exhibit number 78. Okay. So, Your Honor, may I approach the witness?
Sure. I think he has them on the screen.
You said you wanted hard copy.
Either way, it doesn't matter to me.
Okay. Oh, okay.
Are you okay with the
That's
screen?
fine.
Or do you want?
I'll have that, please.
Okay.
Yes. Thank you.
Okay. So March 9th is one of the dates that you talked about.
Correct.
And the text messages that were introduced make it clear that James and Jennifer Crumbley made plans that day to go out to the barn, correct?
Correct.
And you have photos confirming that they were in fact at the barn, photos of horses they took.
Correct.
Okay. The jury has seen that the data shows the times these photographs were taken, so we know they were taken on March 9th.
Correct.
Okay. You've brought in GPS locations to prove they were there on that date.
Correct.
Okay? And it's on that date that Ethan Crumbley, the shooter, is sending his parents some texts that were admitted through Exhibit 82. Do you recall those texts?
I do, yes.
Okay. Now, in these texts, starting at, I'm going to put it up on the screen. This has been admitted as Exhibit 82. At 3:17, we can see that the shooter asks his mom, "Where are you?"
Correct.
And I'm sorry, I have that one in my hand. Do you want me to trade with you?
I should be fine with this.
Okay.
Thank you.
I think counsel misspoke.
I'm sorry, I'm so sorry. Jennifer Crumbley asked the shooter, "Are you home now?" At 3:17.
Where are you? Yes. Is that what
I'm sorry, where are you?
Yes.
Okay. And the shooter responded, it looks like 4 hours later, saying, "Can you get home now?" And then proceeded to send some other texts about, "There is someone else in the house, I think," and it goes on from there, correct?
Correct.
Now, in between the time of 3:17 and 7:50, okay, we can agree there's a couple hours of a gap.
That's correct.
You don't know if Jennifer Crumbley and the shooter had phone conversations or discussions over those couple of hours.
If we looked at the call logs on their phones, we could possibly find that out.
Okay? If we looked at the call logs and the phone calls were to and from cell phones, we would be able to tell that, correct?
Yes. Correct.
Okay, but if, let's say, Jennifer Crumbley called from her office phone, it would not show up the same as if she called from her own cell phone.
Well, the number would be different, correct.
Okay, and when you and law enforcement went through looking for phone calls, you provided over several call records, but not call records for example, Jennifer Crumbley's office with Ethan Crumbley.
There were none entered as exhibits. I can't say for certain right now with all the information I looked at if there were any off the top of my head.
You don't know if there were any?
Right now, I don't know.
Okay. And you also don't know that day, on the 8th, you know that they're planning to be at the barn. James and Jennifer make plans to go to the barn that
Correct.
day after work.
Correct.
Okay? Between the time they make these plans and the time the shooter texts, "Can you get home now?" you don't know if Jennifer Crumbley or James Crumbley has physically been with the shooter?
Right? No, I do not. From that chat thread right there, I do not know that.
You don't know the discussions on that day that may have taken place in between the shooter and his parents.
Right. From this, I can't tell you that. Is that what I'm sorry? I don't understand.
Right.
Correct.
Right. The best you can do is piece together bits of information, but we can agree there's gaps of time where you don't know definitively what happened.
Correct. Right now, yes.
We can agree there are any number of things that could have happened between 3:17 and 7:50 there would not be evidence to show you what exactly happened, correct?
If there is none there, you mean? Is that what you're saying?
Right.
Correct.
And the only people who would know if they can even remember the day years ago would be the people who were present. So Mrs. Crumbley and the shooter, correct?
Correct.
They would be the only people who truly know what they spoke about or didn't speak about on that day.
Correct.
So when you see these texts, and I understand you find them alarming, I imagine that the texts, and please correct me if I'm wrong, that you find alarming are the texts about there is someone in the house, I think, someone walked into the bathroom and flushed the toilet and left the light on. I thought it was you, but when I came in, no one was home. There is no one in the house, though. Those are some of the texts that you found to be problematic, correct?
In the fact that there's no response in between any of those, yes.
Okay. We can agree there's no response, but you don't know if... Okay, we can agree there's no response by text between Mrs. Crumbley and the shooter, correct?
Correct.
But you also have no way to tell when you see text messages like this at what time Mrs. Crumbley read those texts.
Correct. You'll be able to tell it was read, but yes, not what time.
Okay, so for example, when the shooter texts, "Can you get home now?" and then there is someone else, there's someone in the house, I think, a few seconds later, and then about 30 seconds after that, another text. You have no idea if Jennifer Crumbley checked her phone to see the first text message, checked and saw the second. You don't know which ones she saw or when, correct?
I don't know the time they were read, no.
All you know is that you don't see any response to them.
They're correct. There's no response.
So there's a number of possible things that could have happened in between these texts.
From 7:50 to the end of the last text?
Yeah.
She could have texted back, you mean, or called?
She could have, well, she didn't text back. We agree with that,
Correct.
right?
Yes.
Okay. When I say there's a number of things that could have happened, I mean, she could have read the text and thought this is garbage or he's joking and just set the phone down, correct?
She could have.
Okay. She could have not seen the texts because she was busy doing something.
Correct.
She could have been, we know she's at the horse ranch. Are you aware of how strong Jennifer Crumbley's cell signal is out at the farm, at the barn, where the horses are kept?
I have no idea about that. No, I do not.
Okay. If her cell signal doesn't work out where the barn is, it's possible these texts are not getting to her until she gets to a place where data uploads into the phone, correct?
That's correct.
So while we see these texts being sent, we cannot conclude that Jennifer Crumbley is reading these as they are coming to her. Fair to say?
I mean, they were. That's the time that they were sent, the 7:50 and 14 seconds, and then 17 seconds and 39 seconds. That's when they were actually sent, and they were received on the other end. And that's marked at that time. Otherwise, it would have come in at a later time.
Okay, but my point is you don't know when she saw them, when Mrs. Crumbley actually read them.
No, but they would have been on the phone at that time.
if the phone had a signal and was able to get text, they'd be on the phone at that time, correct?
It would have been at a later time, at the time that they came in.
Okay, but if the signal wasn't working, she might not have been able to see those texts until she got to a point where the signal came in.
Correct.
Okay, there's times where you're in an area, people can be in an area with their cell phone, and the signal is bad, and texts are coming into them, but their phone shows nothing. That's a possibility, correct?
Correct.
And then when the person gets to a spot with better cell phone signal, all of a sudden, all the texts they missed over whatever period of time the phone wasn't working will flood into the phone, correct?
That's correct.
And just because they come into the phone at that time, they were still sent possibly hours before.
No, without testing, I can't say for certain.
You don't know.
I can't say for certain without testing, correct.
Okay, so the text messages that were sent about someone being in the house, someone walking into the bathroom, you don't know any of the responses that, or even the thoughts Jennifer Crumbley had when she did in fact read those messages.
I don't know if she would have called back if that was alarming to her. Is that what you're saying, or?
I guess what I'm saying is, so these messages are coming in, and even when she does see them, let's say if she sees them as they're coming in, you don't know what she's thinking about these.
I don't know what she's thinking, no.
Okay, and you also don't know, and obviously we've already talked about it, this has already been asked, but you obviously don't know when she's seen each message. There's no documentation like she saw this one at 8 o'clock, this one at 8:05, anything like that.
Those are the times that they came into the phone, yes.
Okay. The next message we see is a text message on the following day sent to Ethan by Jennifer Crumbley that says, "Where is your dad?" Correct?
Can you just scroll down a little bit?
Yeah.
I just want to make sure I see
Yeah,
it.
no, sorry.
You know, I feel like maybe I should give the jury a break. You're not close, right?
I'm not even close.
I think the witness could probably use a break as well.
Okay. All right, so I'm going to let you step down. You can't discuss your testimony anymore.
Okay.
Okay, so can you come back at about 5 after 3? Okay?
Yes, ma'am.
All right.
All rise for the jury.
You know, some of the questions are becoming repetitive, so that's going to make you lose them.
Okay.
All right, so 5 after 3. Okay.
Thank you.
Thanks, Judge.
Recording stopped.
Okay, so it appears as though they are taking another break after more testimony from that former deputy at the Oakland County Sheriff's Office. We've been watching the trial of Jennifer Crumbley, of course. We're still joined by our legal experts, Terry Johnson and Richard Convertino. Thank you both for being here throughout the day. We've been here since the start of the morning when this began.
Yeah,
so this testimony is really dragged out today. We've only had one witness. What's your take, Terry?
I'm trying to understand it all. I mean, I understand this is an important witness. I understand the prosecution has put this witness on to establish that connection, as Rick said earlier. And I'm not exactly sure where where the defense attorney is going in terms of the questions. I mean, you know, some of this could have been resolved very simply, whether or not she received text messages. You know, someone received a text message at this point or that point. I mean, we all, common sense knows people send us text messages and we may not read them right away. It could be a little bit longer, but I don't understand why we've spent the last hour on delivery of text messages.
Yeah, because what is that doing for her client in the way she's trying to unpack this?
I don't know, but like I mentioned before, you know, there are lots of things that came out of those messages that Rick and I discussed earlier, you know, when the prosecutor put those things up, in terms of how she really cared about her son and she was trying to get him help. And those are the things I think I would focus on a little more, and maybe she's going to do that. But currently, this is when did the text messages arrive, and, you know, why did somebody deactivate Facebook? And that doesn't go anywhere to tell us what she thought of her son and the care and that she did. I'm just stunned.
Yeah. Almost redundant in a way.
Yes, it does feel very redundant. We're revisiting the same points over and over, the same messages over and over. It just feels like we're kind of at a standstill. We're just wondering where this is going.
It's like cross-examination by the Three Stooges minus Moe and Shem.
Oh gosh.
You know, it's just a. It reiterates and reinforces the prosecution's case at times. Then there are other times when if there are points, they're so buried deep into what sounds like a confused kind of hunting, searching for, you know, the best method to get it out. So the points that she could be making, I think, are lost. So it's unfortunate, but what she's trying to do, and she began, you know, initially was the defense attorney. She was stressing that the witnesses couldn't know personally. In other words, there are these there's interstitial gaps between text messages. You know, as Terry just said, you have a text message between two people. Maybe it seems like the second person didn't answer, but we don't know if the second person came home and they had a personal discussion and the text message was therefore, you know, moot because they already had a discussion prior to the answering of the text. So a lot of times text messages don't get answered, but it doesn't mean the question or the theme of the text doesn't get responded to. So I think that was what she was stressing, that there are opportunities for her to speak to her son directly. Just because she didn't answer a text message directly doesn't mean they didn't have a conversation about a particular topic. But this is an experienced and seasoned witness. He's 28 years with the Sheriff's Department. He's probably testified hundreds and hundreds of times from big cases to little cases. Now he's with the Secret Service. They give training in how to testify. He looks at the jury. I think the jury likes him. He had that emotional time when I think he got a sense of ethos with the jury. But he was a strong fact witness, and he's the kind of witness that if you're not careful and you ask a open-ended question, that he'll come back and he'll just slam you, and that's what he's doing to her.
And he's been the only witness today. Is this common?
Well, it's common if this is the key witness who's going to put everything together. I don't believe, again, I don't know the prosecution's witness list, but I would be very shocked if he was the necessary, absolute top witness that they need. He is generally, you kind of end with that last witness. And he is he's the third witness, I guess, in this trial so far in 2 days. And
be the fourth.
He'll be the fourth?
Yeah.
Okay.
We did have the business, the woman who worked at the business that sold the gun. There was a brief
So you know what?
yesterday.
I forgot about her. Fifth.
Okay.
Yeah. Be the
So we
fifth
had
witness.
4 yesterday?
Yeah, we had a substantial witness yesterday, that being the BATF agent.
That's right.
Yes.
Special agent. And now this witness will be here he'll be here the rest of the day, I would anticipate. There's redirect. And in redirect, he'll be extremely powerful because she opened the door for certain things, and he'll be able to clean up some of the confusion that she did leave behind.
Speaking of being uncommon, something I was saying while we were watching is I don't feel like I've learned much about Jennifer, and I would think that the defense would want to paint a picture of who she is, what her headspace was, or just let us know a little bit more about Jennifer as the woman. Is that also uncommon?
Well, one of the things I said during, while we were off air here, I basically said, why does she keep saying the shooter? Why doesn't she say her son? She needs to humanize Ms. Crumbley. And thus far, every time you say the shooter or, you know, Ethan or anything else other than her son, I think it takes away from who she is. And you're right, we don't know who she being Jennifer Crumbley, we don't know who she is at this point. And I think, again, with these text messages that the people put out, I think, again, I'm looking at this, you know, she talks about therapy with the horses from someone else. She talks about in text messages with her friends where she said, hey, look, you know, I'm trying to reach out, he's not responding, right? Certain things you see where she is a mother here. Even on the day of, you know, we saw the messages, oh my God, that's what she said, oh my God, he might kill himself, he's the shooter. Surprise, she's surprised. Those are the things I would be focusing on, not whether someone deactivated an account. We've been doing that for what, 45? Let's say we came back at 1 o'clock and we've been going almost 2 hours on the same theme of deactivation. It goes back to your point. Who's Jennifer Crumbley? How is this connecting that and who she is to the jury? And right now they haven't.
Well, I think they intend to on direct examination in their case in chief. I think that the more and more the trial progresses, I think you're going to have to see her testify. I think that's a foregone conclusion. You had that promise in opening. I think she's made it pretty clear that Jennifer Crumbley will be testifying. You don't think so?
No, I think she's going to testify.
Yeah.
But now I believe if things were set up a different way, you may not have to have put her on. And some of these text messages and blaming, as you say, the empty chair, the dad who's not there, that could have kept her off the stand. But you got to remember, it's not just her testifying, it's her withstanding cross-examination. And I promise you, Karen McDonald will be doing the cross-examination because this is political.
All right,
now,
we are going to a short break now, but we will be back soon. Stay tuned.
All right, day 2 of the trial for Jennifer Crumbley, mother of the Oxford school shooter. We are waiting for court to resume. They're in a short break. Before we went to commercial, Rick, you were wanting to finish a thought.
Terry had mentioned that the defendant, if she testifies, will be cross-examined by the elected prosecutor, and I agree. Also, I think it's very commendable that the elected prosecutor, the highest person in the office, is actually a person who's trying a case. You almost never see that. They want to kind of.
When's the election? Never mind. I'm sorry.
Well, I don't know. I mean, there's a lot of risk for somebody that high up in an office to you know, that takes courage and grit, and I certainly applaud that. You never see a U.S. attorney trying a case. You don't see Kim Worthy trying cases. I mean, this prosecutor stepped up, and she's in the belly of the beast, slugging it out, and I think that's fantastic. But when you cross-examine a defendant, that is a very risky proposition, and it's very risky for a defendant to testify, because a jury is looking very, very closely at a defendant. In particular, they want to hear from a defendant. You know, the courts admonish and they tell a jury that a defendant doesn't have any obligation to testify, and you shouldn't hold that against them. But I personally think in most cases juries do. They want to hear, hey, you've been accused of this. Are you going to step up and defend yourself? And I think that they do give the benefit of the doubt to a defendant, juries. And so a heavy-handed cross-examination, one that seems mean and cruel and petty, even though you make points, can turn against a prosecutor real quick. And they want to make, she's going to want to be sympathetic to the jury, want to be soft, and want to explain her actions in a way that, you know, that may be very self-deprecating. She may want to say, you know, listen, I'm not the mother of the year, certainly by any stretch of the imagination, but I had no idea that my son would, I would not be aware of that. It's not something that, of which the consequences I understood to be this. And that has to be what she convinces the jury of, beyond a reasonable doubt.
Yeah.
When do we think she might take the stand, Terry?
At the rate we're going, probably March. And I'm just kidding there, but it will be at the very end, because again, you've got a couple of things. The prosecution still has to get through its case in chief, and then the defense puts on its case. Assuming there are more witnesses than just Jennifer Crumbley, Ms. Crumbley will probably come last, because again, this is the one you're waiting to hear, and this is what we want to send to the jury room, the last impression. So.
Something else that stuck out to me from the defense, when she spent all of that time going through those text messages, there wasn't a lot of mention of her son. A lot of the conversations were about the horse. Do you think that that is pretty damaging to trying to, again, paint this narrative or picture about her so that they can get an understanding of who she is?
That's certainly what they're trying to do. They're trying to make her appear to be a very unsympathetic, very uncaring mother in general, someone who is so concerned about her horse that she wants to make sure that there's lotion applied between the horse's toes. So she's very, very in tuned and detailed in a specific way about the health and benefit and the well-being of the horse. And conversely, you see the prosecutor put up text messages between the defendant in this case and her husband, defendant in the next case, communications about the horse, interspersing communications about the son that showed her to be, and James to be very uncaring, unsympathetic, and unconcerned about their son at the time, but very concerned about the horse.
And ultimately, you know, it's a question, Terry, you might agree with, that what's being really put up on trial here. Is it illegal to be a bad parent?
That's the problem that I have with the charges. You know, if they're a bad parent, charge them with child abuse, which again I've said over and over for anybody who's been watching, child abuse is the proper charge here. I think there's no running from it. There's a way to run from involuntary manslaughter in this. Because if it was child abuse, you could talk about standards for parenting and other things along those lines. Here, we're making those leaps. I would have taken, again, if I were a prosecutor, I would have taken those leaps away, charged them with child abuse, even in the first degree, because of the mental aspect of this that they placed on this kid. Now that would have been me if I were charging this case, but I'm not a prosecutor. The best way out of this, again, is to say, yep, she wasn't a perfect mother, but she didn't know anything about X, Y, and Z. And if she didn't know about X, Y, and Z, away she goes. However, under child abuse, as Rick just mentioned, she cared more about the horse. She cared more about this. Look at these text messages. Look at the demons and all. Those things would have been absolutely perfect, in my opinion, for a charge of child abuse.
Well, do you think the charge of child abuse, if they were charged child abuse and were successful in showing that there was extensive child abuse beyond a reasonable doubt, and then the abused child went ahead as a result and consequentially of the child abuse itself, went ahead and executed four kids and injured 7 more, then wouldn't the parents be subjected to a felony murder charge?
That would be interesting, and that would be something that I think would be more apropos than where we are now. That gets to, we've crossed the bridge, we've done the things we needed to do legally, and I think I'd have a hard time arguing against that.
Now, there was a case in 2018 where that was charged, child abuse and involuntary manslaughter, and the father who put his shotgun unattended in a closet, and a 10-year-old shot her 9-year-old brother to death, and the father was convicted of both child abuse and convicted of involuntary manslaughter.
Yeah, and see, something like, I think if the child abuse aspect were added here, I think it would be almost a no-brainer, slam dunk. Let's work out some kind of plea deal. But because it's not added, I think this is where a lot of people in the legal community are saying, where's the connection? This is a slippery slope.
Speaking of connection, I'm sorry.
Are they trying to feel the heartstrings of the jury with these they're trying to show proof of child abuse in this case?
I think essentially it is a child abuse case is what they're trying to prove. They're proving the child
charging
abuse
it.
without charging it. Yeah. I think it's necessary to do that, to muddy them up. But I wanted to make a point before our last break. We were talking about direct and circumstantial evidence, and my position was that direct evidence is given the same weight as circumstantial evidence, and Terry said that I was wrong, and he said that if I could prove to him
that's not what you said.
That you would shave your head.
It's already shaved.
Okay, so
if you read what you said, let's be clear, and those who are on the web can go back and you said it says the instruction just as good as, and that's what I was saying. There are two instructions in the jury instruction as it relates to circumstantial evidence and circumstantial evidence. And it talks about certain things, but the words "are just as good as" are not anywhere in the jury instruction.
Well,
and that was my.
No, you said that direct
Go
evidence
back
was.
and rewind the tape.
You said direct evidence was more important or weightier than circumstantial. I'm going to read that. I'm going to read the jury instructions. The law makes no distinction between
weight. And when you say
weight
just as good as, raise your hands and wave so everybody can see, because those were your words.
The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. One is not greater than the other. Degree of certainty required from circumstantial evidence is the same as direct evidence. I'm waving my hands,
No.
brother.
Where does it say the law says just as good as? Because those were the words you used, and that's what I objected to.
Objection overruled.
Oh, good thing you're not a judge.
So who's shaving their head?
I know.
I think we're both almost there.
That's too funny. So,
All right.
okay, so we understand that the judge is coming back into the courtroom. Yeah, the jury still has not arrived.
Jennifer is making her way in. If we could pull that video up, we'll watch that as we wait for them to get back started. Again, they took a brief pause. We've had this one witness up there all day, and it's been a long one. And I think we've all agreed it's been a synonymous decision that we haven't really felt like we made a lot of progress today.
No.
Hopefully things will pick up in a way that we can.
I think the
we can hear something
prosecution made
else.
a lot of progress today.
Yeah, you're right. Let me clarify in terms of the defense.
Yeah, I don't think so.
Yeah.
Well, but again, Ms. Smith is still in her cross-examination, I believe. And, there's still an opportunity before this witness gets off the stand to do some damage. So let's see if she's going to do that.
Yeah, and you actually said that going into this, that, she has the tools to knock it out.
I think there are several tools based upon everything that happened on the 29th and how she reacted. It's not like she didn't go to the school. She went to the school. She called her husband. She talked with her friend about therapy and other things, I'm worried about him. Those were motherly kinds of things that people do. And I would be all over that.
She came to the conclusion in a matter of seconds after she talked to her husband, who made her aware of the email from the school that there was an active shooter. It came to her mind almost instantly that her son was the shooter. She said, "Oh my God, Ethan did it. He's the shooter." That's what she told her.
Don't forget the second part. He's going to kill himself. That was stated in there.
Right.
And coming to that conclusion doesn't mean that she had forethought that it was him.
She needn't have forethought. She needn't have forethought. That's if she had forethought, malice of forethought, it'd be second-degree murder. That's why it's not. She has to show criminal negligence, wanton recklessness, and I think that's
understand.
it.
And what she did before, again, like we talked during one of the other segments, even the bullet, you know, she got a text from the school. But here's a question: why isn't the school being charged?
Well,
I mean, why
there's-
isn't an official from the school being charged here if this is involuntary? Because they had knowledge of what was going on as well. They did nothing also.
All right, they're getting started again.
But we have to get back into that courtroom. Let's take a listen.
Messages from March 8th, so the day before that you testified about. Do you recall those messages?
I do.
Okay. Do you recall? Do you need to see those messages, or are you able to answer questions without?
I'd like to see them. Not yes, please.
Okay. So these are going to be. Let's see here. This is Exhibit 84. Okay, Exhibit 84. Can you see it up on your screen?
Yes, I can.
Okay, these are texts that are between James and Jennifer Crumbley, correct?
Correct.
Now, these texts are confirming that Jennifer is saying she's swamped at work and is going to have to not go to the barn that night, correct?
I'm sorry. Do you have the copy? I can. Don't scroll.
I don't know what I did with my copy. Let me just. I'm sorry. Here it is. It's right
You're
here.
just scrolling too fast.
Here you go. Sorry.
No, it's fine.
This is 84.
Thank you.
Do you want me to take these, or do you want to keep those?
Unless you're going to refer to them, I don't need them.
I'm not sure if I will, so we'll find out. Okay. So on Exhibit 84, these are the texts from the day before. March 9th are the texts where Ethan is sending those things saying there's somebody slamming the door, things like that, right?
Correct.
Okay. These are from the day before on March 8th, yes?
Correct.
And you testified about these texts from March 8th on direct, and those were admitted through the prosecution.
Correct.
Okay. On March 8th, the parents are talking about Ethan at the beginning of the text messages. Is that a fair statement?
At 3:09, Jennifer asks, "Is Ethan going bowling?"
Okay, so on page 386, she starts off with, "Is Ethan going bowling?" He says, "IDK," which is I don't know. We can agree
Correct.
on that. Okay. What do you mean, I don't know? Okay, goes down further, and Jennifer Crumbley on the 8th is asking at 3:12 in the afternoon, why isn't he home yet, correct?
That's correct.
At 3:12 and 51 seconds, she says he should be home by now, correct?
That's correct.
When she's saying he, we know that she's talking about Ethan, correct?
Correct.
And then it goes on at 3:12 and 56 seconds, she says freaking out, correct?
Correct.
And James responds to her at 3:13, so not even a minute later. He doesn't get home until 3:16, correct?
Correct. That's what he says, yes.
So these parents are communicating about when their son gets home down to the minute of when he can be expected, yes?
Correct.
Jennifer's text back to him is, "I told you to pick him up because he's upset, and I don't want him to do anything stupid, God damn it," correct?
Correct.
That's Jennifer saying that to James.
Correct.
On this date in March of 2021, Jennifer is working at Princeton at her job that's out in West Bloomfield, correct?
Correct.
And as far as you know, James at that time is a DoorDash driver working out in the Oxford area.
Correct.
And at that time, James was in between jobs, and if you don't know, please tell me, in between jobs and door dashing on the side as he was waiting for another job to come along, correct?
I do recall a text message about trying to be an interviewer or something like that between them, yes.
Okay, and in all fairness, if I ask you something you don't know, just let me know.
Absolutely.
Okay, I'm just trying to speed it up a little. Okay, So Jennifer's yelling at James, I don't want him to do anything stupid, goddammit. When she says that, it's fair to say you don't know what she means by I don't want him to do anything stupid, correct?
I have no idea, correct.
Okay, and James's response is, dude, chill, he is fine, and I'm trying to fucking work, correct?
Correct.
And Jennifer's texting back again, not even a minute later, does he have his phone? Yes?
Yes.
And James texts back right away, he won't answer while he's walking, I'll let you know the minute he walks in, correct?
Correct.
And Jennifer, within a minute of that, is sending another text. I'm serious, freaking out. Is he home yet? Those are the next two texts in succession, correct?
Correct.
It would appear from these text messages that Jennifer is voicing concern over Ethan.
In this one thread, yes.
Okay.
Correct.
And again, we're guessing if she's concerned about him, correct?
The language makes her like she's excited. I would say yes.
Okay. So the next day, when she's not responding to Ethan's text, again, we've gone over this ad nauseum. We don't know why she's not responding or what's going on in her head or if she's getting the messages, correct?
I don't know, yes.
You would agree with me in the text messages between Jennifer and James, and I'm sorry, they communicate way more by Facebook Messenger, correct?
Yes, they did.
Okay, and if I were to say that this is the printed out stack of Facebook messages between James and Jennifer, would that surprise you?
I don't. There were a lot of them. I could tell you that. I don't know what it would look like printed out yet. If you say that, I believe you.
Okay. Approximately how many messages do you recall reviewing between them? Thousands?
Yes, thousands.
Okay. And in the messages, you read every one of these messages, correct?
Correct.
And when you were putting together information for the prosecution and for this investigation, you went through and found the evidence that's obviously brought into this trial.
I'm sorry, I don't understand. Give me the question
The evidence that's been admitted, these texts are texts you found when you read the whole thing.
Correct.
Okay? And obviously, if there were texts between Jennifer and James that said something like, I think Ethan's psychotic, you would have brought that in to this court, correct?
Just like the text we had where she said she was worried he was depressed, yes.
Okay, so, and I'm going to get to the text about him being depressed later, but if you saw something in these text messages, like, I think our son is a serious threat, you would have brought that in here to show this jury.
I don't understand the question. I mean, this chat was brought in because for an unknown reason, she's very excited or doesn't want to do anything stupid. I don't know what he would do that's stupid.
Right, okay, so you don't know what he would do that's stupid. Aside from that, though, my point is, we're not going to have this jury read all of the text and messages between James and Jennifer Crumbley, right?
Correct.
And in prepping for a trial, you bring in the ones that show the point you're trying to make, correct?
Correct.
So to do that, you read through all of them.
Correct.
And you pick out the ones that you think are important.
Correct.
And the ones that you've shown the jury are the most important ones you found.
Correct.
And we can agree that the balance of the messages, there's a lot more information that this jury is not going to see because it's not important to proving this case.
I'm sorry. What was give me the question again.
I'll ask a different question. It's fair to say throughout these texts there are numerous conversations between James Crumbley and Jennifer Crumbley about their son.
Numerous?
Yes.
I wouldn't say numerous.
Okay, there's many conversations about, is he home yet from school?
There's some, yes.
Okay, there are conversations about him having to go to take headache medication.
I don't recall it. It might be that what we call headache medication. I remember him having a headache.
Okay. There are texts in here about what they're going to eat for dinner with their son.
Okay.
Do you agree?
Correct, yes.
Okay. There's texts about all kinds of things that a mom and a dad would talk about that are not important in terms of proving this case, correct?
Correct.
Okay. And the most important information you found are the papers that have been admitted through the prosecutor.
Correct.
Okay. And in the rest of the text messages, my point is, if you saw something that was more serious, like, I think Ethan's going to shoot people, you would have brought that into court.
Just like the one, yes.
Okay.
We would have.
So, when we're looking at the evidence...
I just need to object to the form of the question. She's characterizing that he brings it into court. He doesn't bring it into court.
He's the investigator. The prosecutor decides what they're asking to be admitted. So,
right. She's insinuating that he's taking certain things out and not telling anybody else, and everything's been turned over. I mean, it's the
I'm
same
not
argument.
insinuating that.
I'm starting to think it might be shorter to ask the jury to read that whole staff. Right? Would that be shorter? Yeah.
Okay. My point and my question is, James and Jennifer discuss Ethan in other text messages.
Yes, they do.
And if there were text messages that showed evidence that either one of them believed Ethan was sick, mentally ill, anything along those lines, you would be pointing them out for this jury.
More than what we have, correct, yes.
Okay. What you have is the best evidence you could find after going through all of them.
That, like was said, that I turned over to the prosecution, yes.
Okay. And that's true, too, of the messages between Ethan and his friend, correct? In terms of the evidence you brought in, is the most important evidence you thought that was relevant to this case, correct?
Not entirely, no.
Same objection. It's the witness doesn't bring in evidence what he thinks is relevant. He's already testified. His job is to take the data, he extracts it from devices, and he passes along all the information.
The prosecutor decides.
Thank you.
Okay.
And it's a technicality. They work together, but the prosecutor is the one who decides what might be relevant and what might be admissible.
Okay. When you went through the cell phone reports, you read all of the messages between the shooter and his friend, the friend that the prosecution has not named, but the one friend that's been an issue in this trial, correct?
Correct.
You read through, there were over 25,000 messages exchanged between the shooter and his friend that came off of the phones.
Correct.
If I told you that this was the amount of text messages all printed out, would you disagree with that?
I would not.
Okay. And when you went through and pulled out, we can agree that there's lots of different topics discussed among these text messages.
Correct.
And the text messages that were brought in and entered as evidence were from this large stack of text as a whole.
What was presented, I'm sorry.
They're in these.
Yes.
They're from here.
Yes, there was more information that was turned over, but
Right. Okay. So my point is, though, the pieces, the materials that have been admitted and that you've been testifying about are a part of all of the messages between the shooter and his friend.
correct.
Judge, if counsel wants to continue with this, that's admissible. And she has asked the court not to be.
I think we need to be really careful, okay? See, this is the conversation we had when we were picking the jury, that we are not trying the case of the shooter. So we've all endeavored to give you the things that are important to this case that are not specific to the shooter's case. So I don't want the jury to think that they are not allowed to see something. All right, so I don't want the jury to think that either side is hiding something, because they're not. There have been evidentiary rulings made over the last year and a half in this case, and those are rulings that I've made after extensive research and briefing and all those different things with the prosecutor and defense counsel. So I don't want you to think anything's being hidden. That's not a fair, characterization. So.
Judge, I'd ask the court to instruct counsel that you can't request certain things and then make this line of questioning without opening the door.
Well, I do not want to try the shooter's case. Okay, so let's not do that, right? Yeah, yes.
Thank you.
Okay, so we've talked about March 8th, and we've talked about texts from March 9th, yes?
Correct, yes.
Okay, and then you also testified about text messages that were sent on March 17th. Do you recall that?
I recall the date, yes.
And the overall point of those messages, and please correct me if I'm wrong, is that on that date, the parents were at the barn together with their horses.
Those are the pictures, yeah. I don't remember if you have a copy of the text messages that were in that day.
I can show you them if you
Can I make a request?
Yes.
Could you disassemble the Leaning Tower of Pisa?
Oh, sure.
Honestly, it looked like it was. I would hate you to have to reconstruct that. It just looked like it was going to tip, and then you'd have to try to re-put it together, and that would take. I'm hoping you're going to be drinking a glass of wine in your sweatpants this weekend instead of reassembling that file. So
5 bottles.
It looked like it was going to tip.
Okay.
So.
No, thank you.
All right.
All right. We talked about 3/8. We talked about 3/9. I'm going to 3/17. You asked me what text messages I'm talking about. And these are the exhibits that are around exhibits 83 through 86. Would you like me to bring you the text messages so that you can see those?
If you could, please, yes.
I think the March 17th starts with exhibit 85.
Okay. Now, on 85, we amended it, so there are texts that
I remember, yes, ma'am.
Okay. And then I'm also going to hand you right now what's on 86. Okay?
Okay, thank you.
Okay. Now, the overall point of these text messages was to show that both of the parents were at the barn on March 17th, correct?
Correct.
Okay. And on that day, while they were at the barn on March 17th, the shooter was trying to get a hold of them. Is that correct?
That's correct.
Okay. And on that date, we have cell phone evidence that was admitted in Exhibit 83 that shows, and tell me if I need to slow down, I can break this down more. An hour after the shooter was texting Jennifer Crumbley, she called him and had a phone conversation within an hour, correct?
Correct.
And that phone conversation lasted less than a minute.
Correct. I remember that.
And you have no idea what was said during that phone conversation.
No, I do not.
You have no idea what happened after Jennifer left the barn that day or James left the barn.
No, I do not.
You have no knowledge that the family, whether they were together that night or not, correct?
Correct.
You've done the best you can do to put together the information with materials you have.
Correct.
Okay, so we've talked about March 17th. Now I want to talk about March 20th. I'm sorry, the 19th and the 20th. On March 19th, there were text messages that were introduced, and tell me if you need them, they're exhibits 95 through 100, where there's a discussion about Ethan waking up and seeming hungover. Do you recall those?
I do, yes.
Would you like me to give you those?
I just like having a copy in my hand or on the screen, either way. Thank you.
Yeah, absolutely. Okay, so here's exhibit, this is 95. And I'm going to put 95 up on the screen. So now we're talking about March. Sean, can you please? Okay. All right. So we're looking at exhibit 95, okay, which has been submitted. And this is from March 18th, correct?
19th, 95?
Okay. Exhibit 95 is from March 18th.
It's
You know what? It goes over multiple days. Okay, may I please approach with 96 also?
Sure.
Okay, there's two that are in order and they both contain multiple days, correct?
correct.
Okay, so I'm sorry, this is a little bit confusing because we've got two different dates on two different exhibits. Okay, so I'm going to go to 96 first. These texts actually come before 95. On this date, these are the texts where Ethan says, I just finished picking up the room. I cleaned until clothes started flying off the shelf. This stuff only happens when I'm home alone, correct?
Correct.
Okay, and I am totally off. I am so sorry. March 17th. I need to be on exhibit 85.
85. 85 it says is the thread from March 17th, 2021.
Yes, and 85 is one that I cannot display because it's been redacted. So I'm asking if the prosecution can please put 85 up on the screen.
Can you put redacted 85 on the screen?
I kind of just need a minute, Judge.
Okay, so on 85, this is on March 17th. This is the text where it started off, gonna get drunk and ride my horse. Jennifer Crumbley sent that at 1:30 p.m.
Correct.
Okay, and I'm sorry, Mr. Keese, can you please scroll down? Okay, Jennifer Crumbley's indicating that afternoon, I hate my job. Can you bring out last, please? And I don't know what that means. You don't know what that means. Would you agree with that?
I don't know what she's referring to.
I don't either. Okay, can you go down, please? Okay, Jennifer Crumbley indicates at 4:02 that she's left work. Yes?
Correct.
I'm sorry, I'm maybe going too fast.
Nope, you're good.
Okay, and then if we can go down more, please. That jumped exhibits.
That's the end.
Oh, I'm sorry. So 85, can you go to the end of 85? Because it jumped to 86. Okay, so on 402, at 402, Jennifer Crumbley said that she left work.
Correct.
Okay, and the important thing about the 17th is showing that on that date, she was at the barn.
Correct.
And the next day is on the 18th, when we have the text messages about, I'm sorry, March 19th, exhibit 95. Do you have 95 in your hand?
I do not.
I it would be easier probably to submit the whole thing and go page numbers, but obviously we're not going to do that. I'm just having a difficult time with these pages. Do you have Exhibit 95?
I do not. I have 96.
Okay. I am so sorry that this is a mess. Okay. On March 19th, I've got it up on the screen. This is when Jennifer Crumbley and James Crumbley are talking about Ethan acting like or seeming like he was way hungover that day, correct?
Correct.
And it appears from the text that Jennifer is asking if he's okay. She says, "How is he?"
Correct.
Okay. Why is this doing this now? I am going to kill myself. Okay. Okay. So he woke up acting like he had way too much to drink last night, complaining about a headache. That's what James said back to Jennifer, correct?
Correct.
And, okay, Your Honor, I need like a minute, and I'm so sorry. Now I've got exhibits that are doubled on the page, and I'm having a really tough time with the exhibits. I apologize to the jury. Can I please have a minute?
Okay, well, I'm fine. I can excuse them because
Can you help me get this
Are you
back
able to
on?
do it while they're here? 'Cause
Yeah, I'm trying to just get it
next time I
back.
excuse them, I'm going to send them home. I was hoping to finish this witness. I have this task completion thing. I like to.
You know what, we can just leave it 2 pages on the screen. So right now it's got on 440, page 441 is on the left, 442 is on the right. Okay, so starting with 441, this is where the text says, well, he was really worked up and out of control, so I can see why. This is after they're talking about him waking up, correct?
Correct.
And Jennifer Crumbley texts, all I know is he needs to eat, go to work hard, not complain, and he can get his stuff back, correct?
Correct.
And James ends up saying that Ethan asked, why was I in your room last night?
Correct.
And Jennifer ultimately says she gave him a melatonin pill, or a melatonin tablet.
Correct.
And James says to her, I thought you gave him a Xanax last night.
Correct.
And it's evident from this that Ethan, or the shooter, their son, slept in their bed that night.
Correct.
And it appears that on March 19th, as the parents are talking, there was some kind of argument or something happened with their son the night before.
Correct.
And we don't know anything about what happened the night before on March 18th that preceded this whole conversation.
Correct.
It appears from the conversation on the 19th that something was taken away from him because it implies he can get his stuff back.
Judge, objection to the form of the question. He can't testify what it implies or what it appears. Only what's on the phone.
I'm sorry, I'll restate that. The text explicitly says if he does these things, he can get his stuff back.
Correct.
Okay. All right, now I'm going to skip ahead to the 20th of March in 2021. On the 20th, we admitted exhibits 97 through 100.
The 96 are text messages dated March 20th. And the 97 starts with some pictures.
Okay. So 96 are the text messages that are up on the screen. Do you see those?
Yes, I do. I have
Okay.
them.
And it's on the 20th that the shooter is saying things like, I cleaned up and clothes started flying off the shelf. He's making other claims that something is happening that's not normal, correct?
I would say yes.
Okay, he's making claims that things happen when he's home alone and trying to make his mother think things are flying off the shelf.
That's what he said, yes.
Okay. And you don't see any response from Jennifer Crumbley that day.
Correct.
And you showed the jury, we introduced and admitted all of the exhibits to show on that day she was at the barn again, correct?
Correct.
Now, you don't know what they talked about before or after she got home from the barn?
Correct.
All we know are that we have these couple of text messages making it sound like something is flying around in the house from
Again,
her
Judge,
side.
I don't know how often I can say this. Objection in the form of the question. He can testify to what he found on the device.
Yeah, he doesn't know beyond that, right?
Okay, I apologize.
He wasn't there.
Okay, and so on the 20th, Mrs. Crumbley is obviously at the barn. So we've talked now about March 8th, March 9th, the 17th, 19th, and 20th, correct?
Correct.
So we can agree that from the 8th through the 20th, we're talking about a period in time that's about 12 days long.
Correct.
And we've seen bits of the 8th, the 9th, 17th, 19th, and 20th.
Correct.
Okay. In April 4th are the dates of the texts between the shooter and his friend, correct?
There was a lot of text messages. I believe they texted on that day.
Okay. And I believe it is Exhibit 101. Okay. I have 101 on the screen. Do you recall these?
Correct. Yes, I do.
Okay. Now, these texts on April 4th are between, we agree that they are between the shooter and his friend.
That's correct.
This is not a group chat where Mrs. Crumbley is on it.
That's correct.
There is no evidence that these texts were ever forwarded to Jennifer Crumbley.
Correct.
There is no evidence to show that Jennifer Crumbley ever saw these text messages.
Correct.
For example, there isn't a text like, oh my gosh, you should see what our son sent to his friend today. There's nothing along those lines, correct?
Well, not in this group. Are you talking about this chat still?
I'm just saying in general, if you found evidence that Jennifer Crumbley saw these texts, that would be important.
If she saw it, I would say yes.
Okay, and we don't have anything to show she saw them.
Not that was on the phone, no.
So, on this text thread between the shooter and his friend, he talks about how he hears people talking and he sees someone in the distance, correct?
That's correct.
There's no response from his friend.
Correct.
We don't know if his friend saw those texts and didn't respond, or if his friend didn't see those texts and the shooter just kept texting, right?
They came in rapid order, so yeah, they were one after another, correct.
Okay, so this is around, so 11:56, and then we go down 11:57, says, it's at the point that I'm asking to go to the doctor. Okay, that's one of the texts that you testified about, correct?
Correct.
There are not any texts where the shooter is saying anything to his mom and dad about, I want to go to the doctor.
Correct.
While the shooter is saying this to his friend, we don't have any evidence that it's true whether the shooter really wanted to go to a doctor or not, correct?
I mean, he said it a couple times, and they talked about everything.
And all the times that he talked about it, this jury is seeing. You've brought that in. Well, you haven't brought that in. I'm sorry. I keep misstating that. The evidence in this case is showing the jury what you gleaned from your investigation.
I don't understand. I'm sorry.
In the investigation, you don't have any text messages where the shooter is saying to his mother anything about going to the doctor for hallucinations or anything along those lines.
That's correct.
Okay, if that did exist, the jury would be seeing that.
That would have been turned over to the prosecution, yes.
Okay. So in this case, when the shooter says, it's at the point I'm asking to go to the doctor, my mom laughed when I told her, again, you have no idea if Mrs. Crumbley ever saw these texts between the shooter and his friend.
Correct.
And we can agree we don't have any more context than just this text thread that exists between these two.
Judge, again, counsel is getting very close to running afoul of the motion that she filed to preclude evidence, Judge. There is a lot of context, but counsel requested
Your Honor,
motions.
this is making it sound like there's evidence being hidden, and there's not.
Okay, well, I've said there's no evidence being hidden. There's no evidence being hidden. But, okay, so ask the next question.
Okay.
You're not aware of any communication between the shooter and his mother?
No.
Yes,
Correct.
Okay. And when the shooter texts his friend, I was thinking of calling 911 so I could go to the hospital and text, I need help. There are no 911 calls, correct?
Correct.
There are no text messages to Mr. or Mrs. Crumbley saying those same types of things.
Correct.
And when he says, I am going to ask my parents to go to the doctor tomorrow or Tuesday again, we obviously don't know if that's true.
Correct.
And when he says, but this time I'm going to tell them about the voices, okay, that's the next text, right?
Correct. Yes.
Okay. In his words, he did not send that information to his mom and dad as far as you can see from his messages with them.
Correct.
So when we're talking about this whole text thread, where at the end he says, like, I am mentally and physically dying, you also don't have any evidence that the friend who received these showed them to the shooter's mom, correct?
Correct.
There's no evidence that his friend did anything with these text messages beyond the fact that they exist.
Correct.
We don't know if...
Judge, we just need to clarify. There are thousands and thousands of text messages. She needs to be more specific. Is she asking to comment on the 20,000-page text thread? Is she asking to comment on certain days? It isn't fair to the witness who reviewed all this information.
Okay, well, is there any evidence that the friend shared anything with the parents?
Not that I know of.
Okay, thank you. Okay. Now, on April 29th, okay, so we've talked now about April 4th and 5th, the text between the shooter and his friend. Okay, we just finished that, correct?
Correct.
Okay, now I want to go to April 29th, and this is exhibit number 104. You testified about a text thread that went between Jennifer Crumbley and the shooter's friend's mother, correct?
Yes, ma'am.
Now, in this text thread, the moms are, you would agree with me, talking about the difficulties of online school and how it's wreaked havoc, essentially, on their kids.
Correct.
Okay? And they start off by talking because Jennifer is telling the friend's mother that Ethan is not going to bowling, correct?
Correct.
And she says he's been acting kind of depressed. I don't know what's going on, correct?
Correct.
And she says, I'm not sure if there's something bothering him at school. He doesn't really feel good. I can't get anything out of him, correct?
Correct.
She doesn't say anything in here like he's seeing things, he's hallucinating, I'm noticing that he's paranoid, correct?
Correct.
She uses the word, he appears to be somewhat depressed. Depressed is the word she uses.
Correct.
In terms of the word depressed, that could have meanings.
Objection, speculation.
Okay, he's not going to explain what being depressed means.
Well, that was actually my exact question, was just, you can't explain what it means. That was my question.
It means different things to different people, different professions. Right?
You answered my question. That was my question. Thank you. Okay. I'm sorry, may I continue?
Yes.
Okay. So then they're talking about how the shooter and his friend are happy when they're together, and Mrs. Crumbley was concerned, based on these text messages, that there had been something going on between the shooter and his friend, but it's clear that's not an issue, correct?
Correct.
So these text messages, Mrs. Crumbley is, you would agree with me that overall, she is indicating an interest in figuring out what's wrong with her son.
She's pointing out things that she's aware of.
Okay? And this text thread, there are more texts between Jennifer Crumbley and the friend's mother, correct?
Correct.
And there's one other set that we're going to talk about, but this evidence about, there's not any further explanation of what the word depressed means in the messages or not, correct?
Correct.
All we have is what's in these text messages. I'm sorry, scratch that. Okay, so this is on 4/29. We can agree that obviously on that date, Mrs. Crumbley made representations using the word depressed.
Correct.
The next set of text messages with the shooter's friend's mother were admitted as Exhibit 105, and we can agree these are months and months later, in October of 2021, correct?
That's correct.
So this jury is seeing texts from April 29th and then October 31st.
That's correct.
On October 31st, there is discussion between Jennifer and the shooter's friend's mother about the decision they had to make to send the friend away, correct?
There wasn't discussion. She didn't reply back till the 4th of November, but Jennifer texted her or sent a message to her.
Okay, send a message to her asking how they're doing, saying you're thinking about them.
Correct.
Okay, and the friend's mom writes back talking about how hard it is. I appreciate you checking on our family. Things, correct?
Correct.
Thanks for joining us for CBS News Detroit at 4 on It's Friday.
And I'm Meredith Bruckner, and let's continue listening in now to the Jennifer Crumbley trial. This is day 2. Let's have a listen.
And she's asking just how things are going for the friend who's away.
Correct.
Okay. Now, At the end of these text messages, there's a few texts from December of 2021, correct?
Correct.
Now, those text messages are not about anything related to the shooter being sad or depressed, correct? Those text messages are after the shooting has taken place, correct?
Correct.
And those text messages, there's not many. We're only talking about a couple. The friend's mother asks if Ethan is safe on November 30th, correct?
Correct.
So on the day of the shooting, when the friend's mother asks at 3:47, is Ethan home safe? It would be fair, and if you don't know the answer, you can tell me, it would be fair to assume she's asking, is he safe from the shooting?
He can't answer that question, and these are Facebook messages, not text.
Yeah, he doesn't know.
Okay. So Jennifer Crumbley says, I'm sure you've seen the news, and ultimately says, I'm sick to my stomach, correct?
Correct.
And she mentions to the friend's mother that they're getting threats all over social media, which is something we talked about earlier, correct?
Correct.
And she also says that they're staying in a hotel because the news is camped out at their house.
Correct.
Yes?
Yes.
During your testimony, you admitted some GPS location information.
Yes.
And if you need to see the exhibits, let me know, but I think these will be simple questions. When you provided the jury evidence that James was at the gun store on the 26th, we can agree Jennifer was not at the store when the gun was purchased, correct?
Correct.
And when that day, there was a video on the 26th that the shooter made of him holding the gun. It's a short video that was admitted as Exhibit 417. Do you recall that little video?
Yes, I do.
And in that little video, we can't see who else is around while the shooter is filming himself with holding the Sig Sauer gun.
In the video, correct.
And we don't know, obviously, who was present in the home or in the room even with him.
Correct.
That was the day the gun was bought.
Correct.
And the shooter took that video himself, as far as we can tell.
It was on his phone, yes. It was on his phone.
And he, and it was a video that he sent to, it was a, I'm sorry, let me back up. There were also photographs taken that day of the gun.
Correct.
The day they purchased it.
Correct.
Jennifer Crumbley actually posted a photo that was taken of the gun.
After they went to the gun range?
No, the day before, on Friday, the day the gun was bought. And if you don't recall, you can just, I believe it came in through the witness before you, and so if you don't know, you can just let me know.
Yeah, I don't know.
Okay, thank you. So the gun was purchased on the 26th, and the next day is Saturday the 27th, correct?
Correct.
On the 27th, we know that James Crumbley was door dashing that day.
Correct.
That's the day that the shooter and his mother went to the gun range.
Correct.
That is the day where there was posts about a mother-son experience at the range, in terms of shooting the gun, going to shoot the gun.
I remember those, yes.
Okay. Now, there is not any information about where the gun was stored or placed in the Crumbley's home overnight between the 26th and the 27th.
Judge, I'm going to object. These exhibits weren't introduced to this witness. It's inappropriate to ask this witness of those questions. Agent Brandon testified yesterday. It's the same questions that she asked to him at cross-examination. He doesn't have the foundation to give that sort of testimony.
Well, I guess I don't understand the question. Are you asking, is there any communication on a text or a Facebook or a picture about whether the guns were where they were stored or where they were?
Yeah.
Okay, so did you...
On the phones, no, I did not find.
Also, in the very minimum, he should be given the opportunity to review the exhibit before he's asked the question.
I don't know if she specifically asked him about exhibit.
She was asking about Instagram posts.
Oh, the Instagram post. Okay. All right. There's no Instagram posts about storage or being locked up or anything like that.
Not that I saw, no, ma'am.
Okay,
You
so...
didn't see locked guns on Instagram?
Locked guns, no.
And the evidence that you showed us from the 27th, there's not any information about who put the gun in the vehicle that drove the gun to the target, to the shooting range, correct?
I don't know anything about that.
We don't know anything about who did anything aside from the fact that we know when Mrs. Crumbley and her son went over to the shooting range.
I don't know anything about the transportation of the gun, no.
Okay. We know when they got to the range that Mrs. Crumbley and her son went in and they shot some targets, correct?
Correct.
Well, the ATF guy testified to that. Do you know that?
What,
Video?
I do know the video, yes.
Oh, okay.
The gun range video?
All right.
I have seen it.
Okay. And in terms of the text messages and all the evidence that you have reviewed, from the night of the 27th to the 28th, there are not any text messages or Facebook messages about where the gun was that night, where it was in the home, where it was in general, correct?
Correct. I don't know anything
Okay.
about that.
In these same days that the Crumbleys, that Mr. Crumbley bought the gun and Mom and the shooter went to the shooting range, from the evidence that you talked about in front of the jury, it's clear one of their horses has some kind of an issue, a health issue going on, correct?
Correct.
So as the evidence is unfolding about what's happening on those days in terms of what the parents were doing, there's also talk about medication for the horse and things along those lines.
Correct.
When you testified about the search on Mrs. Crumbley's phone about clinical depression, you don't know anything other than what was typed in when she searched for information about clinical depression, correct?
Correct.
You don't know if that was her looking up information for herself?
Correct.
You don't know if that's looking for information about the shooter?
Correct.
Or if it's looking up information about some other person?
That's correct.
On the 29th, that was a Monday. Does that sound right?
Yes, ma'am.
Of November.
Yes.
I'm sorry, of November.
Yes.
Okay. And that was the day that the voicemail was left that was played as evidence as Exhibit 115 from Miss Fine. Do you know what voicemail I'm talking about?
Yes, I recall it.
Okay. So going a little bit backwards, that day, on that Monday, the voicemail indicates that Ethan was caught looking at bullets on his phone, correct?
That's correct.
The voicemail, we saw lots of evidence, was left on Jennifer's.
All right, for those of you watching with us over the air, we have to take a quick break, but we have uninterrupted coverage on our stream on this day 2 of Jennifer Crumbley's trial.
We'll be right back.
Crumbley to call back, to return the phone call, correct?
I don't believe so.
That message indicated that Ethan was not in any trouble, but the teacher wanted, or Miss Fine wanted to make Mrs. Crumbley aware that
Judge,
they
the
had a
exhibit
discussion.
speaks for itself. He can't interpret the exhibit.
Yeah, that's the best evidence of what was said, right?
Okay.
You can have all the exhibits so you can listen to them again.
Thank you.
Yeah.
The conversation, in that conversation, there is talk about I can play the exhibit. I'm just going to ask about one quote, and if I need to play the exhibit, then I'll play it.
Okay, let's hear the question.
At the end of the voicemail, Miss Fine says that it's perfectly normal and healthy.
I can't remember what she was referring to when she said that, but I do remember those words.
Okay. The tone of that conversation was not one that, well, I'm sorry. The content of that conversation did not ask Mrs. Crumbley to come over to the school or anything along those lines, correct?
Correct.
And then we did see evidence that you testified about showing that Mrs. Crumbley asked her son about that voicemail, correct?
Correct.
And her text to him was evidence we saw as Exhibit 117, where she writes to her son, seriously, bullets, correct?
Correct.
And we saw the exchange in Exhibit 117. The shooter writes back to her, I'm in no trouble.
Correct.
Judge, counsel has to show the witness the exhibits.
I can do that. I'm sorry.
In the entire exhibit.
Okay, we'll do the whole thing. All right, so this is Exhibit 117, and as I...
Welcome back. We have gavel-to-gavel coverage of the Oxford school shooter's mother's trial, Jennifer Crumbley, happening now.
That's right. It's day 2. Let's take a listen in to the testimony.
He admits he was. We can agree that's the content of this conversation, correct?
Was that he went to the office for that? That's the last thing you said.
He says that he went. I already went to the office for that.
Yes, correct.
Okay, so I'm moving down, and he's explaining, or at least texting, what he was looking up and saying it's because he was curious.
Correct.
In his words, on page 199, he says, completely harmless.
Correct.
And based on the voicemail that we heard from Ms. Fine, it sounded like...
Objection sounded like...
Okay, I apologize. I'll move on. Jennifer told her son the school left me a voicemail, correct?
Correct.
And asked her son, did you show them your new gun?
Correct.
And obviously he says, no, he did not, and says, I did not show them the pic, my God.
Correct.
Okay. Again, says it was a harmless act.
Correct.
Gives more explanation to her.
Correct.
And ultimately, at the end of the conversation, he asks if he can hear the voicemail later, and she says she saved it.
Correct.
After that, there's conversation that was admitted in Exhibit 118. I've put it on the screen.
Judge, if counsel's just going to read exhibits, it's not a cross-examination. And I want to get to my redirect. I want to finish this witness today.
Finish this witness.
Your Honor, I find that when I'm asking questions, if I don't go step by step, I have to go backwards and go step by step
You
by
have to
step
follow
by
the
step.
rules of evidence. You can't ask the witness to guess.
There are some questions that could just simply be answered, and they're not being answered. So I have to go step by step by step when it's not happening.
Let's do it. Well, yeah, but they're sort of hearing the same things in direct, so.
The evidence that was admitted as Exhibit 118 shows there was a conversation between James and Jennifer Crumbley about the issue with the bullets at school.
Correct.
We went through the timeline from November 30th, 2021 in great detail earlier. You would agree with that?
Correct.
And obviously, you've collected all of the information you could from the 30th off the cell phones of James Crumbley, Jennifer Crumbley, and the shooter to look at in your investigation.
Correct.
It's fair to say that you did not seek a search warrant for people at the school who dealt with the shooter that day.
Hold on. To clarify the form of the question, seek a search warrant for the people at the school. That's not even an investigative method.
Okay.
A search warrant for who?
For the people, right, exactly.
Yeah, there's a lot.
All right, sorry. I'll back up.
And for what?
Okay, you're aware that Jennifer and James Crumbley went to the school. We saw the video of them walking in for the appointment, correct?
Correct.
You're aware they met with Sean Hopkins.
Correct.
You're aware there was conversation in a meeting.
Correct.
You did not at any time seek the messages off of the devices of Mr. Hopkins, correct?
That's not for me to decide. That's the officer in charge of the case to decide what to collect and bring to me to get data for them.
Okay, so that's not something you did. That's my only question.
It's not something that we would do in computer crimes, correct?
Now, when the text was sent at 9:31, the first thing that Mrs. Crumbley, that we can tell she received that morning that was of alarm, was the altered math sheet that the shooter had written on, correct?
Could you pull it up real quick just so I could see?
Sure. So that was Exhibit 123.
Correct, okay.
Okay, so Exhibit 123, now when we say altered math sheet, the shooter initially wrote things on a math paper that was introduced as a different exhibit. It was introduced as Exhibit 74. And I'll open that up. So I've got Exhibit 74 on the right, and we can agree that was initially what the shooter wrote on his math paper.
Correct.
And after writing all the writings on Exhibit 74, he added to the math paper and added the things that we see on Exhibit 123.
Correct.
Now, the first thing that Mrs. Crumbley receives is Exhibit 123, which is the altered drawing, correct?
Correct.
And in terms of what's on the drawing, it speaks for itself. but it has things like, I love my life.
You've been watching the involuntary manslaughter trial of Jennifer Crumbley, the mother of the Oxford High School shooter. We do have to take a short break, but we will be right back with continuing coverage.
It does, yes.
Okay. And when Mrs. Crumbley got that, we know that she immediately, because we have the timestamps, sent Mr. Crumbley a message to let him know that something was going on.
Correct.
And in the text messages, or Facebook messages, which were admitted as Exhibit 125, and I'll put it up, it's specifically, Mrs. Crumbley specifically sent photos over to, I'm sorry, scratch that. Jennifer's first message at 9:33 says, call now, now being in capital letters, correct?
Correct.
And emergency.
Correct.
And her next text right after says emergency again.
Correct.
And then we know that Mr. Crumbley texts back.
Correct.
And that's in a separate, it's further down in the thread. And his response is, my God, WTF, which stands for what the fuck, correct?
Correct.
So the parents, we can agree that as soon as the math paper is received by Jennifer Crumbley, there's conversation between the parents.
Correct.
In addition to the messages, there's also phone conversation.
Correct.
And at 10:04, we know that Jennifer Crumbley is heading to the school, physically going to the school, correct?
Correct.
And at 10:05, we can see she's sending text saying, I'm very concerned.
Correct.
We know, obviously, they get to the school and have a meeting with the counselor.
Correct.
And we know that that meeting only lasted 12 minutes long. That was your testimony.
Correct.
We don't have any kind of record or recording.
We're going to head back to the courtroom for Jennifer Crumbley's trial, the mother of the Oxford school shooter. Let's listen in.
After leaving the counselor's office, we have the text messages that Jennifer Crumbley sent Kira Pennick.
Correct.
Okay? We have text messages that Jennifer Crumbley sent Andy Smith, which were introduced and admitted.
Correct.
And it's fair to say that Jennifer Crumbley is telling at least those people about what's going on with her son, or that she's dealing with something.
Correct.
Now, we know Jennifer Crumbley goes back to work. We saw the exhibit showing her re-entering back at her office.
Correct.
Okay? And we know that at some point there's obviously a notice out that was admitted. The Oxford High School has there's an alarm of an active shooter, correct?
Yes, correct.
Upon hearing that, we saw all of the evidence about Mr. and Mrs. Crumbley heading back to the school, correct?
Correct.
And all of that evidence speaks for itself in terms of the timeline of events that happened. And you went through those times on the record already, so we don't need to do that again.
Correct.
In those messages, there was not anything from Jennifer Crumbley saying, anything along the lines of, I think Ethan might shoot people today.
It's actually the form of the question, anything along the lines.
Okay, I'll rephrase. Jennifer Crumbley, the text messages that we have are the extent of the text messages. You've provided everything from November 30th. Everything we've gone through, there's not more text messages that this jury's not seen. Is that a fair statement? On November 30th.
Correct.
Okay. And we can see the messages that Jennifer sent over to her son at the time. You introduced those when you testified.
Correct.
And there's various exchanges, obviously, between them that speak for themselves, and the jury can read those.
There were changes, yes.
Okay. And there is a message that says, ultimately, from Mrs. Crumbley, and if you need to see it, you can let me know, Ethan, don't do it.
After he was in custody, yes. That message was sent.
And at the time that message was sent, we don't know what Jennifer Crumbley knew in her head.
Correct.
All we can do is look at the evidence and read what's before us and what's been admitted in the testimony.
In the text messages?
Yes.
Correct.
You testified about alarm images in exhibits 149 and 150. Do you recall that?
I do, yes.
Okay, so I'm gonna just put up 149 and 150. Okay, and I just want to make sure I understand this correctly. This was an alarm clock on the track phone. Is that right?
Correct.
So this is an alarm clock set for 6:30 in the morning and 6:45 in the morning that would have been for Saturday, December 4th.
Correct.
Is that accurate?
Yes.
Okay, so these alarms, from what you can tell, were set on the day before, on the 3rd.
Correct.
Okay, and then again, there was some testimony, and I believe we've mostly covered this. Ultimately, when you looked at the cell phone, between Jennifer Crumbley and Kira Pennick, you testified, I believe, that there were 26 messages still on the phone.
Correct.
And from the data you could see, there was actually 4,047 that existed at one time between them.
Correct.
So obviously, many messages had been deleted between Kira and Jennifer Crumbley by Jennifer Crumbley on her phone.
That's correct.
And again, there's not any texts or anything that say that have explanations about deleting things. All we know is that they were deleted.
Correct, just that, yes.
May I have one moment, please? So, there's also, I just have one point of clarification and then I'm done, promise. There are some messages that say that they are unsent. What's the difference between unsent or deleted?
Deleted would tell me that it's just not there anymore. You would delete the message that says it was unsent even.
Okay, so the unsent messages, it's possible for someone to send a message to someone else, but before it's received, to unsend it and recall it back. Is that a fair statement?
I believe also if it was received, that you can unsend it, you can pull it back, yes.
Okay.
You're watching live coverage of the Jennifer Crumbley trial. We do have to go to a short break. We'll be back soon.
Correct.
I have nothing further.
Tell me how long you need for redraft.
I'll finish today.
Okay.
Just give me a few minutes.
All right.
Okay. Now, let's talk first about the deleted messages on the message between Jennifer and Brian Maloche. So when you looked at the return, it didn't just say unsent, it had the red X insignia next to it. What does that signify to you?
That it is deleted.
Okay, so clearly Jennifer Crumbley knew how to delete those messages.
Correct.
Okay, and in fact, she deleted ones that said, "We're on the run again."
That's correct.
And "We're fucked."
Correct.
Okay, and I want to talk to you just really quickly about this word right here. It was a harmless act. That signify anything to you?
Yes, it does.
How so?
It was also written on the modified math paperwork.
Harmless act, right there. Okay, that's Exhibit 123. And Jennifer was sent that.
Correct.
And she was sent that on November the 30th before the shooting.
That's correct.
She was also sent this, People 74. And People 74, the shooter wrote, "Help me."
Correct.
She was sent that, and she saw that.
Yes, sir.
Okay, and then she communicated about that with her husband.
Correct.
Okay. Now, you were asked lots and lots and lots of questions about, is there any evidence of, did you find any evidence of certain topics? So, specifically with deleted content, you can't tell if there's something that was deleted but unable to be recovered by search warrant.
That's correct.
And we've already established that Jennifer Crumbley knew how to delete. In fact, she did delete certain messages.
Correct.
All right. And one message in particular she deleted from to Kira Pennock was that picture of this drawing.
Correct.
Okay. And speaking of that exhibit between Jennifer Crumbley and Kira Pennock, that's People's 130. In those exhibits, they're in front of you if you want to look at them. There's about 28 pictures. They're screenshots. So there are many communications regarding her horses.
Yes, sir.
Okay. So one of the first things she does after the meeting is say, I can't, or after the shooting rather, is I won't be able to make it there tonight. Is that correct?
I believe that's correct. I can look it up.
Take a look. And tell us the time that came in too.
We are headed back to the courtroom for Jennifer Crumbley's trial, the mother of the Oxford school shooter.
You want? I'll pull it up for you.
Yeah, I don't see it real quick.
That's all right. I'll pull it up for you. (2:36 p.m.) Kira, I won't be there tonight. Okay, it's on the screen.
Okay.
That's part of Exhibit 130. And that is, the shooting ended at 1 p.m., so that's an hour and 36 minutes after he was taken into custody.
Correct, I see it now, yes.
That's 6 minutes after she arrived home from the substation, after she was brought there.
Correct.
And that's the last time she saw her son.
Correct.
6 minutes after. Okay. So you were asked about a lot of questions about this Facebook chat here, including a particular message where Jennifer says, "I wish there had been some kind of warnings."
Correct.
Okay.
Remember that?
But she sent this to Kira, and this is the picture where he said, "Help me," with the picture of, where he wrote, "Help me," with the picture of the firearm.
Correct.
Okay. And she deleted that, though. She later on deleted that particular text that she sent to Kira.
Correct.
Now, you were asked a lot of questions about this big stack of these messages between James and Jennifer Crumbley. Do you remember those questions from counsel?
Yes, sir.
Okay. And you were asked if there were certain messages about any message that Jennifer had about my son's going to shoot up the school, things like that.
I remember that, yes.
Okay. You have had a chance to review some of those messages, or all of those messages?
Yes.
Okay. And was there anything in the messages indicating they were going to take him to see a therapist?
No, there was not.
Anything in there indicating they were worried and they wanted to take him to see a psychiatrist?
No, there was not.
Was there any time they tried to set up any mental health counseling?
No.
In the phone logs or text messages from the period after the school meeting till the shooting, were there any indications that they researched any mental health professionals?
No, there was not.
Did they call any counseling offices?
No, they were. No,
Did they call any psychiatrists?
No.
I'd like you just referring to that message, and Judge, for the record, again, I'd like to omit the entire thread that is Exhibit 423. That's the entire Facebook thread between James and Jennifer Crumbley. I'd like to have that available for the jury if they want to look at that.
Your Honor, I would have no objection to that as long as we redact the things that this court's already deemed inadmissible.
Okay.
That would be fine.
Okay, I don't recall specifically what those are, but if there's already been a ruling and things have been redacted, then I would like those taken out.
Certainly.
Okay.
Certainly. Sir, if you could, referring to that, what would be Exhibit 423, contrast for the jury, please, the amount of time and messages between James and Jennifer Crumbley regarding their horses with their messages regarding their son.
Your Honor, I would object. There needs to be a foundation that he can even determine this or has data to support this.
Sure.
Did you look at the messages?
I looked at the messages, yes.
Okay. Are you able to contrast the amount of time and messages between James and Jennifer Crumbley regarding their horses versus
Your Honor,
their son?
I would object. This is misleading and speculative, and there's been lots of talk about things that have been deleted, that we don't have all the messages. So I would object, Your Honor.
Judge, for the record, the point is that counsel asked, is there any evidence of when this witness has already testified to things are deleted, and he's going to testify what's actually on thread.
Okay, I'm eating your dust a little bit here. Okay, first of all, you want 423 text messages between...
Facebook messages.
Facebook messages between Mr. and Mrs. Crumbley admitted in a redacted form. I'm going to ask that the redacted form be verified by Ms. Smith, and then I'll admit 423 because you do not object.
Thank you.
Okay, you want him to ask him. He's going to be estimating, obviously.
I'm asking for an estimation.
And, Your Honor, I was not allowed to ask his interpretation of topics or words that were in there. And so for the prosecutor to ask this question, that's asking him to interpret how often they're talking about various topics. That's the same kind of question I was asking, and I was prohibited from asking.
Well, so you asked him to interpret something that someone said or what they thought, which you can't do.
I also asked questions about, in those text messages, there was nothing about, I believe our son could be a shooter. And that was objected to, and he wasn't able to.
He answered.
There were other questions along the same lines where I was not able to talk about.
No, he answered that there were no communications like that. He answered that. If you had another example, he reviewed all of these the text messages. He also said some were deleted. He looked at the Facebook, right?
423 is going to be admitted, so it can be argued later. I will withdraw my objection.
Okay.
Could you contrast for us the amount of messages between James and Jennifer Crumbley regarding their horses with the messages regarding their son?
I would say there was a vast majority of just discussing their horses and putting ointments on their legs and getting the vets to see them. If I had to put a number on it, it'd be upwards of 75–80% of the conversation.
Over what period of time, if you know?
With that volume right there.
Oh, okay. When does that start and when does it end?
It's early in 2021.
Early 2021. Okay.
Thank you. Now, what about the percentage of time expressing concern over their son?
Your Honor, I object. This is speculation, and there's no way for he doesn't have data on this.
Do you have data on this?
Just the conversation after the pictures were sent, that they drew on the math paper, and there's a couple other conversations about him having a headache and that, but other than that, I can't remember any more conversations.
So I have some data.
You're going to make us listen to data?
No, well, this is just the one question. Does this sound right to you? That
Your Honor, I object to leading this witness into this. If he has data, he can testify about it. If he doesn't have data, this is inappropriate.
People are entitled to lead if it will. Okay. If you were to put a name search, because it's a PDF, right? So you can do a name search.
Correct.
And if you were to do a name search of their son, you could find how many times their son was mentioned.
That's correct.
Okay. And if you were to do a name search of either their horses' names or horses, you could find how many times that was mentioned.
That's correct.
Okay.
Your Honor, this is going so far beyond the scope of...
No, it's not. This is you asked about this. You asked about this.
Okay. Okay. Would it surprise you that it's thousands and thousands and thousands different?
It would not at all.
Thank you. Now, you, sir, were asked a lot of questions about March 9th, March 8th, March 17th, March 19th, and March 20th. It's that area spring of 2021 that we talked about where the defendant's son was text messaging his mother and where James and Jennifer were at.
Correct. Yeah,
Okay.
I remember.
All right, we are going to go on a short break. We'll be back soon.
Jennifer Crumbley saw those messages come.
Yes, I remember those questions.
Okay. I want to make clear that all of that information, all that evidence that was admitted on those days came from Jennifer Crumbley's original phone.
Correct.
Okay. So, if she wouldn't have received it because either her phone was off or no service, it wouldn't have had the same timestamps that we see in here.
Correct.
Okay. So, the timestamp of 6:03 on her phone, the exhibit, that means that's the time it actually got to her phone.
Correct.
Okay. And let me ask you something, sir. I don't think you need to be an expert to identify this, but when you take a picture, do you have to open your phone?
I mean, you have to access the app to take the picture. Yes.
Right. Do you have to look at your phone?
Not necessarily. You just push the button on the
You
side.
have to hold it up and push a button.
Correct.
Okay. And so when we have pictures on Jennifer's phone from the exact same time that her son is sending her text messages, what does that tell you?
That she would have seen them.
Right. Now you were asked about the alarm sent on December the 4th of 2021, and it was up on the screen. It's an exhibit.
I remember.
It was set for 6:30 a.m. and 6:45 a.m. on December the 4th, 2021.
Correct.
Okay, and it said when it was set. It said from 7 hours and 30 minutes from now.
Correct.
So then we can tell that she actually set that alarm at around 11 p.m. on Friday, December the 3rd.
That's correct.
Were you aware that Detroit police were actually on scene at that date and time, at that specific time, at the location where she was found?
Your Honor, I object. In terms,
if he knows,
I would.
What is the objection?
well, the objection is the lack of foundation about whether he knows.
Well, you can tell us.
Well, he can tell us if he knows. I don't know.
I was not aware when Detroit police was.
Okay. You were aware that they were on scene that evening?
Yes, I was.
Okay.
Yes, I am.
You were also asked about what counsel referred to as threats and Jennifer Crumbley, receiving threats. You remember those questions?
Yes.
Okay. And you didn't just review the Facebook messages between Jennifer Crumbley and Kara Pennock. You also reviewed other Facebook messages, other chats. Is that right?
That's correct.
Okay. And including the chat where she was communicating with a neighbor of hers on East Street, and James and Jennifer Crumbley met her at the Red Naps in Oxford the night of the shooting to exchange pet food.
I remember that.
Okay. Now, how close is the Red Naps to her home?
It's just down the road.
It's right in downtown Oxford,
Yep,
right?
correct.
Like a block away.
Correct.
That testimony continues on day 2 of the Jennifer Crumbley trial, mother of the Oxford school shooter. Let's listen in.
So you were asked specifically about Exhibit 130 here. If Jennifer Crumbley expressed some sort of concern over what her son did. Right here, it's, I'm bawling right now, Kira, my son ruined so many lives today.
Yes, correct.
Okay. Now, that was substantially after she was asking to sell her horses for cash.
Correct.
Asking cash stats. I think it was
Correct.
stats.
Yes.
Okay. And is there any text messages at all in this exhibit expressing any sort of sympathy over the victims after this?
Not that I recall.
And in fact, the conversation continues about liquidating her assets.
Correct.
Okay. And it continues about her not being able to see her horses.
That's correct.
And expressing how upset she is that she can't see her horses.
That's correct.
Nothing further, Judge.
All right, you may step down. You're excused. Hardest working hearing and working training. All right, ladies and gentlemen, during this trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they contain incorrect or misleading information that might unfairly favor one side or the other. So to be fair to both sides, you must follow this instruction. You must not go on social media, you must not post, you must not do research, you must not discuss the case with anyone. We're moving quickly. Please follow my instruction. It's so important. I don't want to have to put you in the middle of the holiday again. All right? I can still do it. Okay? So follow my instructions so that we don't have to do that. Okay? I'm going to have you return at 8:30 on Monday. Don't look at anything over the weekend. I should have served you some vitamins with your lunch. Please stay healthy and go Lions.
All right for the jury.
All right, well, that concludes rather, day 2 of this trial. So Terry, just walk us through what we saw today. What was accomplished today?
Great question. I think the prosecution, from their perspective, put forth, I'd have to say, compelling evidence that Ms. Crumbley was not a great parent, that she cared more about the horses than she did her son. I think that the prosecution put forth kind of a timeline to show that her son had some issues, and it appears that none of them were addressed. I think the prosecution did all of this with one witness, and from the defense side, I'm not sure what was accomplished. Again, I'm a defense attorney, and I'm looking at things really from that lens. I think some opportunities were missed. You know, again, looking at my notes here, looking at the date and time when the shooting happened, what happened before, I probably would have emphasized how the parents went to the school, how they talked to, you know, the day before, how they quickly returned phone calls to the school the day before. You need to come up here. They were right there. Texting, you know, their son right after, making Ms. Crumbley a little more human. Those are the things that did not come out. I saw a lot of what I'll call irrelevant arguing about deactivating a Facebook account. I mean, listen, somebody gets harassed and, you know, in social media land, what are we going to do? We're going to take down our account. We're going to shut it down. That's normal. But I just think we were in the weeds on some things that really just put us off to the side. So what was accomplished? I'd say a lot on the prosecution side and not too much on the defense.
A lot of eyes on Michigan right now because of this trial. And when this initially happened, a lot of people were thinking, what were those parents thinking? What happened here? And a lot of people have wanted some answers. Do you feel like we've been able to get any of those? Or do you agree with Terry that we've been kind of left in the dark a little bit about where those parents stood, at least Jennifer, since we're talking about her right now?
Well, I have a different opinion based upon the evidence, the witnesses that have been presented so far. I don't think there's any question where the parents stood. I don't think there's much question about their culpability, at least at this point in time. That could change given the future witnesses, maybe cross-examination. If it's less feckless than it's been totally ineffective so far. Like I said earlier, it's like cross-examination by the Three Stooges minus Moe and Shemp. I don't think that any of the important points have been made. I do think that the prosecution is very compelling, concise, and clear so far.
Since this is so slow going so far, we've only gotten through 5 witnesses in 2 days. Is there a scenario where they wouldn't call the total amount of witnesses they were intending on heading into the trial?
That's very possible. Sometimes the prosecution may look and say, listen, I don't need this one because I get everything through here. I don't need this because I get everything through here. I mean, again, if the defense were looking at this, if I were trying the case, and again, I'm not criticizing what Ms. Smith is doing, but if I were trying the case, one of the things I would just make sure to say is, show me the connection here. Being a bad parent does not equate to involuntary manslaughter. And that is what I would just pound on the table again and again. Show me where being a bad parent. Because no one's saying that they're going to get Parent of the Year. But there's got to be that connection. And again, I still say it's a stretch. But if you don't put up a proper defense to talk about that, it only comes down to, are they good or bad parents? And if they think they're bad parents, then they must have allowed their kids to do X, Y, and Z.
Much more than being a bad parent in this case. I mean, being a bad parent, one of the things that the defense in this case is positioning for, and they're saying, she's saying it outright, is that not only was she not a bad parent, but she was a vigilant mother. She used that term over and over, a vigilant mother. I think hyper-vigilant mother. Clearly, there's no evidence whatever that this woman, the defendant in this case, was a vigilant mother. So it's not a case about bad parenting, because remember, what did they do when they were informed and aware of the severe mental issues that her son, their son, was struggling with? They went out and they bought him a gun. And they bought him a gun.
There was a gap there. Right there.
No, it's 3 days. 3 days. They bought him the gun 3 days before the
incident.
shooting.
But you asked the question when they found out he had severe mental issues, and the only time he talked about that came up was back in March. So what happened between March and November? And let's go back here.
What happened between March and November 27th, or I'm sorry, yeah, November 30th. Pardon me. Thank you. There was a math sheet with extraordinarily disturbing information on it, including guns and killing.
And they had 1 hour to do something at that point. And which goes back to the question that I asked before. The school knew this as well. So why aren't we holding the school accountable as well in this? And this is why I've said all along, this is child abuse. If this were child abuse, I would say you have something. Involuntary manslaughter, I mean, if I know something an hour, I mean, you have to understand, they were just told. And if you look at the text messages that came out in the evidence today, again, she's texting her son after, hey, I love you. I are just making sure you're okay. He's texting back, I'm fine, I'm good. He never once said, oh my God, I'm gonna go kill somebody. I'm gonna go shoot somebody.
Of course he's not going to say, I'm going to go kill somebody or shoot
Why
somebody.
Not? But people do that. And if she didn't do anything to stop that, then that would be involuntary manslaughter.
It was on demonstrable evidence. It was on a piece of paper. It had guns and bullets and death and killing and blood.
So 1 hour before, but does that, again, looking at that.
What do you do? 1 hour before, do you leave the school and leave the kid in school with what we now know is a backpack full of weaponry and magazines and bullets? And
but now we know. But here's the problem with the scenario.
Him home. Take him home.
Why didn't the school get charged? Ask Karen McDonald that question.
It's absurd.
Thank you both very much for being here and for your insight today.
They're just as responsible.
We are going to take a quick break from this. We are going to have a look at weather with Stacy DeFord. Stacy.
Well, we are seeing a little bit of drizzle sticking around throughout the area. We could see a few scattered showers throughout the evening. The big thing is going to be patchy dense fog moving in, especially through the overnight hours. And we already are seeing some reduced visibility out there in some areas. So if you do have to be on the roads tonight, keep in mind that they are going to be wet. So you may find some slick spots as temperatures drop. And again, reduced visibility out there because of that patchy dense fog. Expecting a low near 33 degrees. And we're going to see those showers come to an end as that fog moves in. For tomorrow, expecting a cloudy day and a high near 40 degrees. And taking a look at the next couple of days, we are having a chance of seeing some rain and snow move in on Sunday morning. We're watching this system to see who it's really going to affect. Right now, it just looks like the southern counties. We dry out again for Monday. Another chance of rain and snow moving in on Tuesday, especially in the morning hours. But as you can see, temperatures are remaining pretty steady in the upper 30s, right around 40 degrees. And our overnight lows are actually right around freezing, which means roads could get slick in the overnight hours, especially if there has been any precipitation. Back to you guys.
All right, thank you, Stacey. That does it for us at 4. We're going now to head over to the 2024 Farmers Insurance Open on CBS.
You can watch CBS News Detroit at 5 and 6 on our website and streaming on Pluto TV. For the latest on Jennifer Crumbley's involuntary manslaughter trial, that address, cbsdetroit.com. Thank you again for joining us. Thank you to our guests. Have a great day.
Time. Yes. She reminds me of myself at 12.
Mic check 1, 2.
Good evening and welcome to CBS News Detroit at 5. I'm Shayna Humphreys.
And I'm Terrence Friday. The involuntary manslaughter trial of Jennifer Crumbley continues today, and we've been listening all day with that gavel-to-gavel coverage.
Today, the jury heard a deep dive into the Crumbley family's digital footprint as the prosecution builds its case, arguing that the mother of the Oxford High School shooter ignored multiple signs of mental illness. CBS Detroit's Andres Gutierrez is live outside the Oakland County Courthouse to break down the text messages that were at the center of today's testimony.
Well, Shayna, between the messages that were shown and the line of questioning that took place earlier today, the prosecution was essentially having the jury connect the dots that Jennifer Crumbley cared more about her horses than she did about her son, who would carry out the worst mass shooting in state history. The only witness that we heard from today was from a forensic analyst who pulled everything from the 7 phones investigators collected from the shooter and his parents. The prosecution honing in on messages sent from March 2021, where the shooter texted Jennifer Crumbley several times saying that he was home alone, scared because he was hearing strange sounds and seeing demons. However, his parents ignored those messages because they were busy riding horses. In fact, days before the mass shooting, one of those horses, Billy, had a swollen foot, and they wanted him to get seen by a vet as soon as possible. But when the shooter needed mental help, here's what he wrote to his only friend.
The shooter wrote, like, I hear people talking to me and see someone in the distance, and then corrected the spelling of the word distance.
It's April 4th, 11:56 p.m.
Correct.
Okay.
Yeah.
What else?
The shooter said, I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to, quote, suck it up.
And then what?
He then says, like, it's at the point that I'm asking to go to the doctor. Then he says, my mom laughed when I told her.
And so this afternoon, the jury ended up hearing how Jennifer and her husband, James, responded in the aftermath of the shooting, including deleting several messages while they were on the run, including one acknowledging that their lives were changed forever. Reporting live in Pontiac, Andres Gutierrez, CBS News, Detroit.
And Andres, why did the prosecution juxtapose or compare contrast the message about the horse and the shooter's mental health?
Well, from the beginning, Terrence, they were essentially saying that being a bad parent is not criminal. So what they are trying to do here is establish a pattern where they are saying that in the months, days, and even hours before the shooting, there were signs that the shooter needed some help, but the parents, the mom especially here, ignored those pleas.
All right, thank you very much, Andres. Let's bring in our legal panel now, who have been with us throughout the day. We've got defense attorneys Terry Johnson and Rick Convertino, who also served as a federal prosecutor. So with all of these communications, the defense and the prosecution are trying to paint very different pictures of who Jennifer Crumbley is. So if I could ask both of you, perhaps Rick, could you describe who she is according to the prosecution, and then we'll follow up with Terry. Who is Jennifer Crumbley according to the defense?
She's a disassociated, deracinated woman when it comes to her child. She is not included in his mental illness to the point where, as we just heard testimony and text messages, that she ignored and laughed. And defendant in the second trial, Mr. Crumbley, gave her son, during the throes of mental illness, some medication. There were also earlier texts that it was Xanax. So they were parents who not only were bad parents, but parents who in the throes of a mental illness ignored their son, whose mental illness became progressively worse, and then, close to the time of this horrific shooting, purchased a handgun to him. Not only purchased a handgun, took him to a range so he could practice target shooting. It was extraordinarily horrific, what the conclusions of their actions, and I think that the prosecution showed that in spades. I think that they did a methodical, yeoman-like, professional way of presenting evidence. This is the fifth witness. I think the cross-examination on this witness was at best clumsy, feckless, ineffective, and re-emphasized all of the prosecution's points in cross-examination.
And Terry, who is Jennifer Crumbley according to the defense attorneys?
According to the defense attorney, she's one thing. In the opening argument, she's, again, not a perfect parent. vigilant mother who had no, what's the word I'm looking for, no control of a firearm, didn't know much about it. That was kind of left to the husband, and the husband was the one that, you know, was kind of left to handle those things. According to the evidence, we don't know, because as Rick has said, you know, the prosecution's put all these things in, but not once have I heard anything that goes to who Jennifer Crumbley is. I think there was a missed opportunity this afternoon on cross-examination when I saw a lot of text messages actually showing where the mother cared, and she's talking to her friend about, you know, her son, and she's talking about other things with her son in terms of, you know, I can't get through to him. I'm trying to talk to him. You can always talk to me. I love you was one of the last text messages she sent to him before she even knew the shooting was going, but none of those things came in from the defense's side. So from the defense's side, I don't know, other than what the defense attorney said initially of who she is. That evidence has not been shown at this point.
Yeah, and Terry, before we even started this morning, you had said that the defense has real opportunity today to cover some ground substantially, and it felt like the line of questioning was almost disjointed at certain points.
Yeah, I mean, what I saw was the arguing over why do someone deactivate a Facebook account? Why would somebody stop doing, you know, those are questions that could have been answered literally in about 2 minutes. I mean, I think we all know based upon the threats and other things why someone would do that. But I think what truly hurt is during all that time, and the prosecution showed, there was no talk about what happened. There was talk about the horses, there was talk about woe is me, and that goes back to Rick's point of showing where the prosecution has really scored a lot of points here.
Yeah. Why is it so important? We're learning about what happened after the fact when they were allegedly on the run, though text messages were revealed that literally said we are on the run. How big of a deal is that specific piece of evidence?
Consciousness of guilt is the terminology that's used for activity that occurs after an act occurs and the people, the defendants in this case, become fugitives. Mm-hmm. Why would they flee? That was the question that was posed. The defense has posited that the reason they fled was they felt they were in danger, their lives were in danger. Terry pointed out earlier that one of the reasons that they didn't turn themselves in earlier was due to some of the issues with the defense attorney in this case. I didn't recall that, but he reminded me of that this morning. But that is a very, very hard hurdle to overcome. And I don't think the defense did. I think the prosecution is showing that they had consciousness of guilt and therefore they fled accordingly.
Based on what's been presented so far, gentlemen, how do you feel the jury is digesting all of this, and how do you think they see Jennifer?
I don't know. I mean, right now there's only one side to Jennifer, and that's the side that the prosecution has painted. Again, opening arguments are not evidence, but based upon the evidence that's come in thus far, I've seen zero evidence to show anything about Jennifer Crumbley. All we're hearing is, again, about Facebook posts, why they were taken down, you know. We're on the run. Again, I don't know if that's akin to, look, I want to kill myself. That doesn't mean I'm suicidal. It just could be a phrase that they're using. But again, there's been no defense put forth to answer those types of questions.
When you consider what you just pointed out, that the defense hasn't really risen to the occasion there, and some of just the combative nature and tone of the proceedings so far, what might we be dealing with? Is there potentially going to be an argument for ineffective counsel here?
Unquestionably, that'll be part of what I would anticipate would be an appeal in this case, because I'm convinced right now, beyond all peradventure, that the defendant in this case will be convicted of all 4 counts. The critical assessment that was made by this defense attorney of how to proceed with this case is disassociated with the facts, the evidence. So to present this woman, the defendant in this case, as a vigilant parent is hyper-vigilant parent is markedly absurd. There is no way to defend her actions as a vigilant or hyper-vigilant parent, or a good parent, or a decent parent, or a caring, loving parent. So what I think the defense should have done was taken the facts as they are, not rearrange reality or alternative facts, but the facts as they are, presented her as she is, a flawed person, a flawed parent, and defend the case honestly and openly as, hey, she had her drawbacks, she had her own problems, she was in a marriage that was difficult, etc. Those facts, and then she missed this, but she's not a criminal. That would be the defense. She's not criminally negligent. She's negligent. She's not criminally negligent as a parent. I think they've missed that boat by raising the bar as a vigilant, good parent who didn't do anything wrong. She didn't know that her son was seeing demons that were flying around a room throwing dishes and clothes. She didn't know her son had these command hallucinations, even though the text messages said that from him to her. She didn't laugh at him. Those were all misunderstandings. Is market bullshit, honestly. And I think that she should have been presented in a reality form, and that you give that to a jury. You say, this is who she is. These are the mistakes she made, but she's not a criminal. A jury can accept that. They can say, yeah, hey, we make mistakes, but that's not the presentation that's in this courtroom at this time.
All right, well, that is all for today, but of course this will continue, and we will be following every moment of it. Rick Convertino and Terry Johnson, thanks so much for being here today.
Thank you.
Patchy dense fog moves into southeast Michigan and sticks around through the overnight hours and Saturday morning. We'll talk about what we're expecting for the weekend coming up.
Watch CBS News Detroit
with breaking Southeast Michigan news and next weather updates.
Better informed, better prepared. Open the free Pluto TV app, scroll to local news, and choose CBS News Detroit. Then just add us to your favorites.
The cleanup continues after a 30-inch water main break in Northville overnight. It happened around 3:30 a.m. between Novi Street and Oakland Avenue, and combined with the rain and melting snow, it's caused some severe flooding.
GLEWA crews worked to isolate the break by closing 2 valves on the main. Then they started draining the water to figure out the next step for repairs. There is no boil water advisory for now, but area residents are being asked to restrict their water usage.
You have to see underground where the water went and, the different buckling up.
the infrastructure underneath and all the roads right this second. So we're going door to door and going into everybody's front and backyard to see what could collapse. But we're trying to make sure everybody is safe, and safety is the most important thing. Right?
At this point, Gliwa has not offered a timeline for when those repairs will be completed.
Let's check in now with next weather forecaster Stacey Duford. Another pretty gloomy day, but on the bright side, it is nice and warm and comfortable. We're not freezing anymore, Stacey.
We are not freezing, but unfortunately, we're going to see the gloom sticking around, but also the warmer temperatures. So there's a upside, downside. Right now, temperatures are remaining pretty steady, right around 39, 40 degrees, but we are starting to see some of that patchy, dense fog move into the area. We're going to see that really through the overnight hours, down to a quarter mile in some areas, sticking around for Saturday morning as well. So again, if you do need to be on the roads, use those low beams and keep plenty of distance between you and the vehicle ahead of you. Right now, we also have a flood warning for the Clinton River, the Rouge River, and the River Raisin, indefinite right now as they watch the levels. All of them are near flooding levels or above at this point. So do be cautious if you are in those areas overnight. We are expecting temperatures to drop down to 33 degrees. We could see a few more showers, but they will come to an end. We do have that patchy, dense fog moving into the area. For tomorrow, we're going to see the gloom, cloudy conditions, but again, above average temperatures, expecting a high near 40 degrees. Now, here is a look at the next weather futurecast. Again, maybe a few scattered showers throughout the evening hours, but we are going to see them mostly clearing out. We'll see cloudy skies for Saturday and then for Sunday morning. In the overnight hours, Saturday night into Sunday, we're watching another system that is moving up from the southwest, and exactly how far north it goes and the temperatures we're at when it gets here is going to determine what we see and when. So it could come in as all rain, it could transition to snow, it could come in as all snow, and it's mostly right now going to affect the southern counties. Could it move a little further north? Yes, these are all things we are keeping an eye on. I would just plan to expect a little bit of precipitation on Sunday morning, and then that will move out in the afternoon. Okay, so here's our precipitation chances. Again, Sunday, that 40% chance. We do dry out for Monday. Another system moving through on Tuesday, bringing another chance of rain and snow. But then we do dry out for the end of the week. So here's a closer look at the next 7 days. Again, cloudy for tomorrow. That chance of rain and snow on Sunday morning. Cloudy again for Monday. More rain and snow for Tuesday, but as you can see, these temperatures all hovering right around 40 degrees for the week, which is above average. Our average temperature this time of year is 32 degrees, which you can see is basically going to be our overnight low most nights this week. So again, we could see a little bit of freezing, some slick spots on the roads in the overnight hours, but we do start drying up towards the end of the week and maybe even seeing a little bit of sunshine by Friday.
Thank you, Stacey. Breaking news right now in the civil defamation case against former President Donald Trump. After deliberating for less than 3 hours, a jury in New York City just awarded an additional $83.3 million to E. Jean Carroll. She is the former advice columnist who says the former president damaged her reputation by calling her a liar after she accused him of sexual assault.
Today's verdict was the second time in 9 months that a jury addressed Carroll's claim that Trump assaulted her at a department store in 1996. Another jury last May found Trump liable for sexual abuse and ordered him to pay $5 million. This defamation trial was over things that Trump said about Carroll when he was president. Trump continues to insist that he was falsely accused.
There was a first-of-its-kind execution in Alabama last night as convicted killer Kenneth Smith was put to death using nitrogen gas, a method that had never been used in an execution before, nor had it been tested. Some of the witnesses described his death as inhumane. I want to warn you, some of the details are graphic. Smith was sentenced to death for his role in the 1988 murder for hire of Elizabeth Dorleen Sennett. The state tried to execute him through lethal injection in 2022, but repeatedly failed to find a vein. His lawyers tried to stop yesterday's execution, calling it cruel and unusual punishment, but the Supreme Court rejected their last-ditch effort.
There's some involuntary movement and some agonal breathing, so that was all expected. So nothing was out of the ordinary.
We didn't see somebody go unconscious in 30 seconds. What we saw was minutes of someone struggling for their life.
Witnesses say Smith appeared conscious for several minutes into the execution and then shook and writhed on the gurney for at least 2 minutes until he eventually died.
Coming up, a look at the exploding popularity of flag football across the country. We'll hear from athletes and coaches helping lead the surge among boys and girls. More people in the U.S. are playing flag football, and some parents see it as a safer alternative to tackle football. It's growing in popularity, and now the NFL Pro Bowl also includes a game.
Yeah, organized leagues have exploded in recent years, and it will even become an Olympic sport for both men and women in 2028. CBS's Chris Van Cleve has the story.
Go for me, go for 3, 1, 2, 3, go!
High school senior Nyjah Green is a force on the football field. She grew up playing the sport, but as she got older, there just weren't a lot of options for girls.
There's this sense that football is kind of a boys' sport.
I would disagree.
Tell me why.
Girls can do the same thing as boys, literally. Like, when all the boys be out, they be low-key watching our games. Like, they be watching like, oh, shoot, she can actually catch. She can actually go up for the ball like I can.
She signed up immediately when Arizona became one of 8 states to add flag football as a varsity sport last year. 22 other states are now considering similar action, and Green is planning to continue her flag football career in college.
What's it meant to be able to just keep playing, and now maybe be able to do it in college too?
It's amazing. Like, I never expected this. I always had to play with the boys. I was always playing with, it was never girls.
A handful of small universities are adding flag football and offering player scholarships, prompting one of the first female flag football player combines to be held in Houston, with 52 women from across Texas last month hoping to impress college coaches. The NFL is helping the game's expansion with funding and a massive marketing push. NFL Flag has organized more than 1,800 leagues with nearly 700,000 players nationwide. Women make up 25% of the athletes and are the game's fastest growing segment.
It's making those establishments or making those advancements for women's sports and finally getting recognized.
Last year, nearly 500,000 girls ages 6 to 17 played flag football, a 63% increase from 2019. There are now more than 15,000 girls playing flag football at more than 700 high schools.
It's brought young women into the sport and given them a chance to play, which I think is incredibly valuable.
You're going to start seeing this thing grow a lot more and really have an opportunity to play
big-time Division I football, back to quarterback.
Lorenzo Alexander is a two-time NFL Pro Bowl linebacker. He played 15 seasons in the NFL.
Toes on the line, toes on the line.
But he'll tell you he's having more fun coaching his daughter's flag football team. His young sons are playing too.
Good, break on it. Yeah, I didn't let my sons play tackle, but this was a great alternative where they can still learn the game, get out here, work on their athleticism, and really maybe you can get a leg up on some guys that played primarily tackle football.
This is one of NFL Flag's largest regional tournaments. Nearly 1,000 kids ages 8 to 17 from 8 states. The teams that win here, they go on to the NFL Flag Championship Series. Those are played at the NFL Pro Bowl.
Gotta go, pull the flag, pull the flag.
The pace is quick. Everyone on offense except the quarterback is eligible to catch and run with the ball. And defenders, instead of tackling, are trying to pull the offensive player's flag. A 2021 CDC study found kids between 6 and 14 sustained 15 times more head impacts playing tackle football than flag football. Kids playing tackle also experienced 23 times more high-magnitude head impact events each season.
A lot of people like the kind of sort of lighter nature of the sport, and yes, there's running and diving and potential risk of injury there, but it's less severe impacts, less collisions, and that's really appealing to a lot of people.
People like Nija Green, who hopes flag football keeps her on the gridiron for years to come.
Ready, set, go.
All right.
I'm Chris Van Cleve in Glendale, Arizona.
All right. Love that story. So Detroit Lions fans are hoping to see their team go all the way to the Super Bowl, but the NFC Championship against the San Francisco 49ers stands in the way. Ahead at 5:30, how Lions players are preparing for the game.
And a Detroit council member says there's a better way to share money from games and events by creating an amusement tax. The details and reaction just ahead.
You're watching CBS News Detroit.
Welcome back to CBS News Detroit at 5. I'm Terrence Friday.
I'm Shayna Humphreys. Another gloomy day, but it's kind of juxtaposed. There's an energy building as we head into a very exciting weekend for Metro Detroit. But yeah, the weather.
You see the blue here?
Yeah, you see the pride all around. It's a good thing there's so much energy because we're not getting it from the weather, Stacey. It's just kind of dark out there.
We are not getting it from the weather, and unfortunately, we're going to see these cloudy, gloomy conditions sticking around. If you're just heading out this evening, you're going to find temperatures remaining pretty steady. We could see a few more light showers out there, maybe some drizzle throughout the evening hours. Again, temperatures remaining pretty steady, right around 39, 40 degrees, and then we'll see cloudy conditions overnight. So if you are heading out on the roads, though, those roads are most likely going to be wet because of the rain earlier and the little bit of melting that's been going on, or actually the lot of melting that's been going on. And we do have fog moving in, patchy dense fog sticking around throughout the overnight hours and Saturday morning as well. And it's going to be fluctuating, so you could come upon it suddenly, really reducing visibility down to a quarter mile or less throughout the overnight hours and on Saturday morning. And we are expecting a low near 33 degrees for tonight. Again, those showers are going to end. The fog moves in. For tomorrow, those cloudy conditions sticking around throughout the day, expecting a high near 40 degrees. And we do have more precipitation heading our way. We'll talk about when it's moving in and how long it expects to stay coming up.
Thank you, Stacy. The Detroit Lions have the city behind them and more as they carry the hopes